it gets moved, that is still a day of court. You don't just say, okay, that day didn't happen. What is that? That's nonsense. We are on day 17. Good morning, towel friends on the YouTube stream. We're here. I am a towel. You are towels. It is another towel day. It's Thursday, ladies and gentlemen, May 15, 2025. And you might be saying, towel, are you tired? Yes. Ladies and gentlemen, we are going to watch the recap so you can all get caught up and I can save my voice. But Towel was in the courtroom yesterday for the media blackout of the devastating testimony from John O'Keefe's niece, KF. KF basically detailed for the jury that Karen Read was emotionally abusing John O'Keefe. The jurors were just shocked, and it was horrifying to listen to. That jury, I don't know if you missed the recap yesterday, that jury does not like Karen Read at all. Hank Brennan has that jury in his hands. They write down everything he's saying when he's walking around, and then when the witnesses are talking on his part of the examinations. The jurors got so bored by the end of Bob Alessi's examination cross, and they were so confused that one of the jurors was sitting there like this. Also, after the clip played in the morning yesterday before KF's testimony, oh my dear goodness, ladies and gentlemen, I watched one of the jurors, John DePetro's reporting was spot on. I watched it happen. One of the jurors went like this. And it wasn't subtle. It was not subtle, ladies and gentlemen. It was as subtle as Towel when he gets into horse racing announcer towel mode. But listen, we need to watch the recap. All right, if you're just tuning in, if you missed it yesterday, Little Towel recapped the whole day. I'm pretty sure I uploaded it. I either clipped it or I think I clipped it. I don't know if I actually posted it because I got so tired, but let's find out if I did. No, I didn't actually post the video. I just made a clip of it. Okay, so you know what we're going to do? I'm going to post this video now so that we can watch the recap and I don't actually have to read it again because I actually already did a recap. So what we will do is while I'm doing that, you all will watch 3 videos. First, let's take a look at Karen leaving court yesterday because I'm a little towel. Oh, 1 second. You don't have that ready yet. I have to do one thing to make that visible for you. Hold on, little towels. I thought about this. I have everything planned ahead of time. There we go. Look at that, little towels. And then here's Karen Read leaving court. We're going to be good little towels, and we're going to watch this. All right, here we go. Let's do it.
Karen John's niece was on the stand. Any reaction to her testimony?
No comment.
How about would you like to see her?
No comment.
We've heard a lot of talk about
Slow, Brandon, slow. And the hearing is in that came from the fire, correct?
Are you feeling better, Karen? Hi, Esty. Hi, Miss Reed.
Hi there.
You better watch yourself.
Say hello to the police for me. I already sent you the picture. All right. I'll take it down to see you. Yeah.
All right, ladies and gentlemen, that was Karen Read. Now let's take a look at the next video, which is Bill Read. This is a little loud, but I did my best to up the audio for you because Bill Read doesn't talk very loud and my microphone wasn't next to him, but let's listen.
She said, fire it up. Never been a strong person. And so she just got she needed more sleep than she got, I guess. And so she's doing fine. It's not related to her long-term health issues. Well, I mean, she does have MS, as you all know, right? So anything that wears on that ability to maintain your health and maintain your strength is certainly something that is very strong to her. So no, it wasn't. It was just she was going down everything that they worked through the weekends. I mean, these are people who have tremendous amount of pride and working to free Karen Reed from all of this persecution. And as you can see, they're doing one hell of an effective job.
Bill, what do you make of the hair on the bumper that made it out to Dighton and back in a snowstorm?
Well, listen, I'm a reasonable man, and I drove the vehicle there, and I did, by the way, clean off that bumper with my hand. I didn't even clean that off from your hand. So it's pretty remarkable, right? Glass traveling, as well as the hair. I mean, it's pretty remarkable. Everyone did. John O'Keefe, some vacations I did some seeing. I had a niece, I had a nephew, and I said I did. Sorry. Both John O'Keefe Sr. and Mrs. John O'Keefe Baker. That's just common decency, and I would not have overlooked it. I sat down and had a cup of coffee at the island. I had a conversation with John O'Keefe Sr. They're talking about kind of nervous conversations, and that they had water damage in the kitchen, and they had
No, pause. He may actually have to get called now. He wants to get called. I'm told that I was reading, and I'm told that no, he didn't. Bill Reed did not sit down for a cup of coffee with Mr. O'Keefe that morning. He lied, folks. Oh my goodness, it was Murder by Maestro. Wait, are you here now? Oh my goodness, it's Murder by Maestro. I couldn't tell if you were in the replay clip. If you're here now, you are a towel, sir. I repeat, Murder by Maestro is a towel. Z Travels, great to see you. Ange Whittick, great to see you. But yes, folks, let me tell you, that man, there was no conversation. He didn't stop for coffee. He didn't sit for coffee with Mr. O'Keefe. Ladies and gentlemen, something is going on here. Hold on, stay with Little Towel. I'm still here. Something is going on, ladies and gentlemen. Something is going on. I don't know if Bill Reed's trying to get called or what it is, folks, but something is going on. Let's listen to the end of his remarks. Sorry about putting that Karen's face above the screen. I reset all the windows.
Flooring and the like at a cost of $75,000. He was hurting, and I was hurting for him. And my daughter was crying, and she hugged Katie, and they were both crying. And the rest I'll reveal if Attorney Brennan wants to call me. I'm on the list, so we'll see who wants to call me. Well, I wasn't sitting on a stool, dangling my legs and doing a cup of coffee in my lap.
Cup of coffee. Cup of coffee in the big time. I don't mean to mock him, but he sounds like Randy Savage. Cup of coffee in the big time.
Thank you.
Thank you. Be well, Mr. O'Keefe, Mr. Reed.
I called him Mr. O'Keefe because Mr. Reed was talking so much about Mr. O'Keefe. I had Mr. O'Keefe in my mind. I was like visualizing them two sitting together and talking. But I don't think that actually happened. Folks, I tell you, I don't think that actually happened. But you know what did actually happen? Hank Brennan said I could call him Hank. Oh, goodness, ladies and gentlemen. I have to tell this story before we watch. Give me 1 sec. We're gonna watch this with audio first, without audio, so I can buffer up the video because it will go grainy for a second. And then the way Twitter buffers its videos now is a little weird. It does like this weird pre-buffer thing, and then it rebuffers them. But let's listen to this, folks. Hank Brennan called me, said, you could call me Hank. Oh, goodness, it was a moment.
Good night. You as well, Mr. Brennan.
Call me Hank.
Okay, sir, I will, Hank.
Okay, sir, I will, Hank. I was like, what? I'm a little towel. I don't know what to do in this situation. Someone's like, you should have said you could call me Towel. I would have been, No, I was not going to say that. That's very creative, but I was not going to say that. Yeah, so if you didn't catch it, one more time, let's run it back, and then I'll tell you what happened afterwards.
Good night.
You as well, Mr. Brennan. Okay, sir, I will, Hank.
Just absolute absurdity. But, okay, sir, I will, Hank. I really should have said, okay, Hank, you could call me Towel. So, yeah, that was Towels Day. Oh, it was a moment, folks. And then I have to tell you, yes, John DePetro was named an honorary towel. It was a wonderful moment. John DePetro was very pleased. He walked around beaming the whole day. He was telling people that he was an honorary towel. I was like, this is wonderful, John. And then I told him on live stream, I was like, that's true, John. You got denoted an honorary towel. John was pleased. And then we're going to watch it in the clip because it's uploading. KF got designated a super towel at the end of her testimony. It was very sad, actually, to read the very end, but listen to me read it because I'll rest my voice. We'll watch it together. No, and so I'm wondering if someone was like, KF, I know it was a tough day, but did you hear you're now a super towel? Oh, goodness, ladies and gentlemen. If Hank Brennan and I ever get slices of 7-Eleven pizza after the trial, I'll let you all know. You know, I saw someone like creepily found him in his gym. He goes to like Planet Fitness. He's out. Hank Brennan's out, and he plays in a harmonica band. He's absolutely the kind of person that would eat 7-Eleven pizza just like because it's economical. Oh, goodness. Yeah, I think Hank Brennan. So after the Whitey Bulger case, Hank Brennan sat down with Marjorie Egan and Jim Browdy. And I'll show you guys the picture, but I've known Jim and Marjorie for a while, dear friends. And the video's still uploading. We're almost done. But I want to show you, I don't know if I still have the picture just accessible. I posted it many years ago. Marjorie interviewed Hank Brennan. We can watch it again after you want. I've watched it a few times. Marjorie interviewed Hank Brennan about the Whitey Bulger case, and Hank Brennan was talking, and Whitey Bulger was Hank Brennan's client. Hank Brennan's done prosecution and defense at the I don't know if he was a federal prosecutor, but he's very skilled and he has been a federal lawyer. But ladies and gentlemen, Marjorie Egan was in the courtroom and said that the Whitey Bulger victims were hugging Hank Brennan for asking questions on cross of Stephen the Rifleman Flemmi and Frank Cadillac Salemi, or one or the other, or both, that exposed Whitey Bulger, but he also exposed the government corruption in the case. And so that, to me, I thought was very interesting. And the background here is Marjorie Egan interviewed Hank Brennan after that Whitey Bulger case. And we can watch it. I want to watch the review of KF's testimony first. You guys are going to watch me do my short review, the truncated review from yesterday, and then we'll watch the Hank Brennan clip with Marjorie Egan, because yes, well, first of all, Marjorie's a wonderful person, and I've known her and Jim for decades. And second of all, I really want to show, I really would like to do that, because Marjorie's interview with Brennan was stellar. Stellar, friends. Absolutely stellar. And so it made me realize, like, okay, I could do that kind of interview after the trial, maybe, depending on appeals, whatever. I could absolutely do that kind of interview with Hank Brennan. Okay, but, folks, Little Towels, look at that. Do you see? Look at Little Towel. That's me. I'm a towel. Do you see me? And that's Jim and Marjorie. Hold on, I can make the image a little bit bigger. That's Jim and Marjorie, and that's Rep. Ayanna Presley. Little Towel. Just that picture of Jim, me, and Marjorie is one of my favorite pictures. That's Marjorie Egan. Marjorie Egan used to be the host of Greater Boston. Then Jim was the host of Greater Boston for a while, and now they both do a radio program. You should listen to it every lunch hour. I listen to it like all the time, and they do once a month interviews with the governor, the attorney general. Like, that program is just the epitome of public service journalism in Massachusetts, and both of those two are literally towering figures in public service broadcasting. First of all, I have known them for a long time. Still, when I am around them, I am like, oh my God, I am in the presence of greatness. Like, oh my dear goodness. Like, look at me in that picture. We were just, that was an event, so it was a great event, actually. My mom was supposed to come to the event. It was at the BPL or something, and Ayanna Pressley had just announced something about the ERA, and my mom has done a lot of work related to the Equal Rights Amendment, which basically there's a convoluted history related to the Equal Rights Amendment, which would give women equal rights under the Constitution. They technically have equal rights. This is a very complex issue. I'm going to explain it very briefly. Women and men have equal rights under the Constitution. Okay, this first came up in the 1970s when Wisconsin made a law that said men between the ages of 18 and 21 could drink alcohol by volume beer of 5.7%, but women between the ages of 18 and 21 could only drink alcohol by volume beer of 3.1%. And then at 21, they both could drink the same ABV. Okay, so that case was reviewed by the Supreme Court, which struck down the law on the basis of intermediate scrutiny, okay, which means that you cannot treat men and women differently under the law. And the standard, okay, the standard for whether a state can do so is more elevated than the rational basis review that a lot of government actions get. But it's not as high as strict scrutiny, okay? Strict scrutiny is the highest level, like for First Amendment rights and other core rights. But it's intermediate level scrutiny, okay? It gets this more than rational basis with a bite even. It gets a very high level of scrutiny. And the court said, no, you cannot have a law that says women and men can be treated differently for the purposes of that, okay? Now, there's a little bit more context to it, because then there was an Equal Rights Amendment about 50 years after women got the right to vote. There was another amendment, an Equal Rights Amendment proposed that had a lot to do with not necessarily intermediate scrutiny, but more just kind of entrenching in the Constitution this equality. It's not a rhetorical thing. It does bump the level of scrutiny that would be applied to, like, if men were discriminated against because they're men, or women were discriminated against because they're women. It would bump it up to strict scrutiny. But it's more like a constitutional amendment affirming the equality of the sexes. Now, really interestingly enough, sex was originally not going to be in the Civil Rights Acts of 1957 and otherwise, but there was a poison pill amendment submitted by someone in the House in 57 that was designed to try to sabotage the Civil Rights Amendment by adding sex. But then the National Women's Party was like, yeah, let's do this, and the amendment passed. But anyway, so to give you the context, this ERA, the Equal Rights Amendment, gets proposed. It gets ratified by 37 of the required 38 states, or 35 of the required 38 states before the deadline in the preamble of the amendment, which was like originally 8 years or something. So then Congress extends the deadline a little bit longer until like 1982 or something, in 10 years total. And by that point, enough states don't ratify, and the amendment just kind of lingers. Now, fast forward to the past 30 years, eventually 2 other states ratify, and then maybe like 3 or 4 years ago, Virginia becomes the 38th state to ratify the ERA. But this caused this, like, not really a constitutional crisis, but it caused my mother to come up with this legal argument that because the Madison Amendment, which has to do with, I think it's congressional pay or something, it lingered for like 200 or something years. Even though it didn't have a formal deadline in the amendment when it was originally passed, it lingered for like 200 years and then got passed, ladies and gentlemen. And so, but yes, the way in which the Madison Amendment passed gave my mother this idea, well, okay, so the constitutional or the congressional deadline imposed in the preamble of the Equal Rights Amendment, even though it got extended by Congress, whatever, like that might not actually be constitutionally valid. It wasn't in the text of the amendment. And now you have this like timeliness issue in a case called Dillon from the 1920s or something. Some guy argued that because he had been charged and convicted under alcohol smuggling rules or something after the Prohibition Amendment had passed 38 states, but before it had actually been ministerially promulgated by the archivist of the United States, that his conviction shouldn't have stood. Now, in that case, I think the conviction stood, and it doesn't. The argument is that once the 38th state ratifies, it doesn't matter when ministerial promulgation occurs. Functionally, the amendment, you can make an argument that the amendment is ratified. But the big issue here is it's a separation of powers issues, and this is why it's the ERA, the Equal Rights Amendment, has been lingering for decades and decades. What it really comes down to is, so when you write an amendment to the Constitution, it's like a federalism versus anti-federalism compromise. You have to submit the text of the amendment in the federal Congress. It has to pass through the House and the Senate. And then what happens is it gets sent to all of the state legislatures at the time. And you must obtain a two-thirds majority, yes, two-thirds of the states, in order for that amendment to become law. So do you see how it's kind of like this back and forth process? And any state can just be like, we don't want to ratify, or they can just not take up ratification. So you have to do this bifurcated process to get an amendment passed. But what's weird is Congress kind of dictates the ebb and flow of amendments. They come down from the Congress to the states, and the states get to decide. They don't really have a lot of input once the amendments come down from the Congress. Now, in this context, okay, states can kind of like rebel against the process or whatever. But the real question is, can Congress say to the states within a preamble to a constitutional amendment bill, technically the amendment itself, you have 10 years to ratify, and if you ratify beyond 10 years, it's invalid. Now, listen, it's a really tough call. Like my mom's dedicated a lot of her life to this fight. It's constitutionally, to me, I'm sympathetic to this argument, but it has to be cohesive. So, like, if we want to have a rule that congressional deadlines, supertextual in preambles or in the amendment itself, are valid, then we should be clear about that. Like the Supreme Court, in the interest of defining balance of powers between the branches, should say that. It hasn't really said that. So that's what my mom wants them to say. Likewise, my mom thinks and I agree, there's a little chance the court will say, that supertextual preamble-based deadline is not valid. So the 38th state ratifying Virginia, that's enough to trigger the amendment passing. Now, the reason why this is such a hot potato political issue, I know this is an aside, but we had to wait for this long video to upload. The reason why this is such a hot button political issue is they can't go back. You're not going to get another ERA to pass the federal Congress. You are, and I've said this to my mother, you are out of your mind if you think that this Congress, a Republican GOP-led Congress or any Congress, is going to be able to do a amendment process about equal rights for women because of the gender issues at play in society right now, in terms of like what is gender, what is sex, are we going to cover both, are people going to no one is ever going to agree to this because everyone's going to have a reason to hate it. So the best and only hope for getting the ERA passed is to get a Supreme Court ruling that the pretextual congressional deadline was invalid. It's a long shot, but that's her argument. So anyway, Jim Browdy asked Ayanna Pressley about the ERA at this event, and my mom was going to come, but she wasn't able to. So I was there, and I saw Jim ask Ayanna Pressley, Rep. Pressley, about, like, do you think resubmitting the ERA, like, why are you doing this? Like, can you tell us more about it? And so, of course, Little Towel afterwards, like, I had been doing some other policy work related to adult and medical use cannabis at the time. And so I'm like, oh, Rep. Presley, do you know, like, my dear friend Shalene Title? And all her staff were like, oh my God, Shalene Title is a superhero. And I was like, yes, Shalene Title is wonderful. And she was one of the cannabis commissioners, just a wonderful advocate who helped draft the adult use law in Massachusetts. Very informed, erudite, kind of cogent regulator who wards off like corporate consolidation in order to protect small businesses. And like in America, if you know, the decline of small businesses is a big problem. So the way you ward off corporate consolidation is through kind of preventing companies from taking over too much of the market. And so it's like a pro-free market regulation approach in the sense that consolidation is anti-laissez-faire. Like market consolidation is anti-free market. It's like fundamentally anti-free market if you consolidate the market and no one can participate in it. So regulations in kind of like a moderate way are used to prevent market consolidation to allow smaller businesses to operate. And that's what Shalene Title does. She's amazing. Oh, Vandy Strong, God bless you, dear friend. It's so great to see you this morning. I don't think I get Zelle notifications, but I will look at my phone as soon as I can. But yes, we're talking about why there's a picture of Towel with the greatest picture actually in my repertoire of Towel, Jim Browdy, and Marjorie Egan, and then Towel and Rep Presley. Notice how respectful Towel is of Rep Presley. Towel would not put his arm or touch Rep Presley, of course, unless she initiated contact. That's the diplomatic procedure. But Marjorie and Jim, not only did they want to put their arms around me, we had this great picture where we all were we have these wonderful facial expressions. And let me zoom in on it for you a little bit more. Do you see how Jim like looks down at me? He's like, huh? And then Marjorie's like kind of like doing a wave. Like they knew we were like, it was like all of us knew how to be in front of all those people and get pictures taken. It was really awesome. But yeah, so all of this ties in because Marjorie interviewed Hank Brennan after the first Karen Reed trial. So, Little Towel's like, okay, first Karen Reed trial, the Whitey Bulger trial. Goodness. Marjorie Egan did not interview Hank Brennan after the first Karen Reed trial because he wasn't involved. Marjorie Egan interviewed Hank Brennan after the Whitey Bulger trial. So as Little Towel, I'm like, I could interview Hank Brennan once all this is kind of, relaxed. I think based on Hank Brennan saying I can call him Hank, I think I would never, first of all, I've never talked to Hank Brennan. I would never approach him during the trial, but after the trial, when the gag order's lifted, whatever, I think she's going to get convicted, even during appeal, if he's allowed to talk, I would interview Hank Brennan. I would sit down with Hank Brennan, however style he wants to do it. I don't know. I feel like a long form kind of Socratic conversation between Brennan and I would be ideal because I don't want, he doesn't need to soundbite this. I have no desire for him to give one sentence quips. I want him to be able to do an explicated oratorical treatise. I want him to orate his thoughts in a way that are true and authentic to his position in a non-truncated format. So I think we should do some kind of long-form interview. Maybe we could do it. I think we'd be able to smell the what? The pot. Okay, so before we get into the review of yesterday, because it is early in the morning, it's coming up on 8 a.m. We're 1 hour away from the start of session in today's John O'Keefe and Karen Reed trial. A really funny moment happened yesterday that I didn't even know about. So, I was just doing my towel thing in the courtroom. I don't know if you all heard. I was taking vociferous notes on KF's testimony, John's niece, in the morning. Then as soon as we came back into session, I was in the courtroom running my broadcasting software with the Karen Cam, all of that in the courtroom. So I was responding in the YouTube chat, telling the towel friends what what I observed of the jurors in accord with the rules. So I couldn't describe anything about them in a way that was identifiable. I think we're limited to age, not age, age range, race, and gender. So I have never said anything about these jurors, and I don't intend to, other than the age, their race, their gender, and then not even their age. I gave ranges. And then I am not describing their physical characteristics, but so for example, the rules are more about identifiable physical characteristics. So you could argue that someone reacting like that is a physical characteristic, but I just want you all to know, no, that's not what it's more like, are you describing them in a way where someone could identify them? And when I said to you yesterday, after that video clip of Karen played for jurors, and we can watch it again, I have the clip saved somewhere. One juror, John DePetro, was completely right. These jurors hate Karen in the sense, he didn't say that, but he said some of them actually viscerally react, and Katie Benoit said it as well from NBC 10. And John was right. At least 14 to 16 of the 18 jurors do not like Karen. They won't look at her. She won't look at them. She knows they don't like her. It's really awkward. Oh my goodness. It is Sheffield Towel. Oh my goodness, that's my birthday. Oh my goodness, Sheffield Towel, on my birthday, I will watch that with you, friend. I'll stream it somehow. I think I actually have a coverage through one of my TV stations of a lot of the English games because I really like them. I will figure it out, Towel friend. Oh, that is a great Towel birthday. Yeah, Hank is very, very, very attentive. Obviously, yesterday, now I have to call him Hank. I feel so weird. I was like, sir, okay, I will call you Hank. I don't know how to react in this moment. I am a towel. But look at friends. I have the whole summary of KF's testimony, and the reason why I'm bringing this up, towel friends, is we should save Towel's voice. Today's going to be a long day. So since I already talked about this all yesterday, and now I just posted it on X because I was so tired last night, I literally fell asleep without even setting up this morning's stream or anything. I just went to bed. Yeah, Mandy Strong, the way I would describe the jury's reaction, dear friend, towel friend, and what did we call it? Allegorical towel spouse, even though I'm afraid of commitment. Oh, God bless you, Mandy. I did get the notification through text. You just made little Towel's day. Towel is getting so nervous. And all of you, don't think that all of your support is to Towel Stream is going for naught. I've been like using these month-to-month rollover lending programs that have really helped me build up my credit. But like, I have spent so long just constantly worried about like how much I've been under. Like, I do this at a loss, and some of you were getting to the point where like I've actually got caught up on some of these things. Like even today, I would have had to like close out a $200 like advance from last month, and I think I did it. Like, and so it's just, folks, you all are inspiring, little Towel and Mandy Strong. I made a commitment to look down to my phone, and I did, and God bless you, Towel friend. Okay, but before we do this, before I get too sidetracked, it's not even 90 minutes in. It's not time for our public information service reminder. It is time for me to tell you my name's Grant Smith Ellis, and if you missed yesterday, media testimony in the John O'Keefe and Karen Reed trial was blacked out from John O'Keefe's niece. But guess who was there? Guess who took 11 pages of handwritten notes? And not just that, ladies and gentlemen, I have something more for you. I didn't cover this yesterday. Oh, you tuned in at the right moment. Oh, folks, wait till you see what I have in my little towel folder. Oh, goodness. I forgot that I had all this. I did this by hand. Oh, my goodness, I'm such a towel. Hold on, I dropped my water bottle again. I'm such a towel, friends. Wait till you see what I have for you here. Oh my goodness, it's my actual notes of what the jury... Look, no, okay, I can prove exactly what was going on. So first of all, I have handwritten notes of all 18 jurors, not anything about them, just what I told you I'm allowed to write down, which is their name, their, not their name, God, I don't want to know their name, their race, their general age, and... their sex. God, do not tell me. I don't want to know their names. I have no idea. I'm not looking. I don't care. I do not want to know. And if anyone even tries to ask, we will shut that down. That's not happening. The integrity of the court system is literally paramount on Towel Stream. Okay, I have it. And by the way, that's why I was, I think things were so calm in court yesterday, because there was no one in the courtroom that was going to violate any of the decorum rules or like the rules about what you can write down. But yes, I understand why it's such a sacred space, folks. Don't get me wrong. All right, so here's more. Okay, so here we go. Should we do this? Okay. Front row from left to right. White man, 30s, in the first position. Number 2, white woman, 30s. Number 3, so this is left to right, front row, looking at the jury head on. Number 3, I said Spanish, but I couldn't really tell. Spanish woman, 30s. Number 4, white woman, mid-40s. Number 5, white male, 30s. Number 6, white male, late 20s. Number 7, white female, mid-20s. Number 8, white female, mid-30s. Number 9, white male, 60 or above. Number 10, white female, early 30s. Back row from left to right. Black male, mid-30s. Black woman, mid-30s. White male, mid-40s. White female, mid-30s. White male, mid-50s. White female, mid-30s. White male, 40s. Black male, mid-30s. So that's the best you're going to get. That's all I'm going to give you. Oh, Murder Bar Maestro, God bless you for sharing that in the chat. But that's all I'm going to give you about that. That's in line with that's all I'm allowed to say, sex and general description of age, and that's all you're going to get from me. And then I won't even describe their characteristics, the features or anything, nothing like that, but I will describe their reactions. So we've talked a little about that. Now, I have the juror notes, my juror notes for KF's direct and cross. Okay, I'll take you through it minute by minute right now. So right away at 9:40 a.m., I have that 14 of 18 jurors were taking notes. At 9:50 a.m., 16 of 18 jurors were taking notes during direct. At 9:55, 16 of 18 jurors were taking notes on direct. The only jurors that weren't taking notes were maybe 15 out of 18 were 18, 17, and 14 as of 9:55 a.m. As I mentioned, juror 2 was the one who gasped at Karen when the clips played. I have that denoted in real time, so that's a real-time recorded recollection. 9:58 a.m. All 18 jurors are taking notes during KF's direct. As of 10:01 a.m., all 18 jurors were still furiously scribbling during KF's direct. As of 10:07 a.m., all 18 jurors were taking notes. I didn't look up at every minute between 10:01 and 10:07, but at 10:07, all 18 were taking notes. Okay, 10:10 a.m., jurors all hanging on KF's testimony about the morning of 1/29/2022. The early morning, like 4:30 a.m. 10:15 a.m., only 4 of 18 jurors taking notes during Jen McCabe questions from, I don't know if that was on direct or cross. That was on cross. No, might have been on direct about like the basketball coach thing. So not a lot of jurors taking questions during the Jen McCabe question, whether on direct or cross. It was just about how did KF know Jen, who was her basketball coach and her childhood mom's friend. So 4 of 18 during the Jen McCabe question. 10:28. The DY cross begins and only one juror was taking notes. 1, 2, 3, 4. This one. So I'm not going to reveal which one. It's tactically useful to the defense. 10:28, one juror, and then 10:35, only 2 jurors were taking notes in the middle of DY's cross, and then by redirect, I was not taking notes anymore, and who was taking notes. So there you go. No, it was an hour of, we're going to listen to my review of it now. It was an hour or so. It was quick on direct, 30 to 45 minutes, 15 to 20 minutes on cross, very brief redirect, and then it was basically over. And then that was it. That was it. David Dianetti, forget it, like he was not bombastic. First of all, he did not like be pedantic or pejorative towards her. He was like, he was all business, but not in a rude way. Like he didn't like try to show fake compassion or whatever, or even like show authentic compassion. I think that would have been inappropriate. He stood up there and started it, by asking about, he didn't tell KF not to call Karen the defendant. He just asked I think he asked something along the lines of like, did you call her the defendant before 129 or something, which didn't even make sense because she wasn't charged with a crime. But anyway, no, and it wasn't like, he wasn't like aggressive. He was just like, didn't you get your nails done? And like, I think he slipped up once because he was like, didn't she take you to get your nails done once a week? And KF was like, no, it was like once a month, and she didn't like come in, like it hurt her nails, so she didn't like coming in. And then Dianetti was like, oh, well, but didn't she take you to some doctor's appointments, like an eyeglasses appointment? And KF was like, no, like the only person who took me to my eyeglasses doctor was JJ, my uncle. Like she was like, Dianetti was, he had to be gentle, and even in the way he was asking questions, she was out maneuvering him, and he knew it. Like he would say something and she'd be like, no, like what do you, like Karen didn't, like Karen's in my relationship was cold a lot, like what are you talking about? And at one point Dianetti asked this convoluted like 6-part question. When KF responded this way, I literally smirked. She was like, what? Like genuine, and I think most of the jury agreed with her. She was like, what are you saying? Like what? And DY had to like break it down and start again. But let's listen a little. I'll do the overview. Hold on. I don't think I'm glitching. I'm not seeing any dropped frames. I'm seeing a pretty stable frame rate, and my stream audio is coming through fine. So yeah, let me know if there's any glitches. And we are gonna. Oh, you're gonna get a Murder by Maestro. We have a whole clip to watch, dear towel friend. We're gonna watch it together now. And yeah, please let me know if there's any glitching or anything like that. I appreciate all you dear towel friends. And actually, let's throw up a poll. I'll do it in the middle of this clip we're gonna watch, and let's yeah, exactly. Watch how not just buy their love. Karen would like use them emotionally against John. You're gonna hear one point where John and Karen are in a fight, and John has to leave the home because Karen would like pound on his door, and she would just be very abusive to him. He would ask her to leave, tell her to leave the home, like he wanted to end the relationship. She wouldn't go. And at one point, they were in January of 2022. Karen was yelling at John. John left to go for a ride to clear his head or a walk. KF and PF, so the niece and the nephew, didn't even know John was gone. And Karen called John, and KF heard Karen say over the phone, "Oh, PF and KF are worried you're gone, you know." No, they didn't even know he was gone, and they weren't worried. You know what I mean? It was like that kind of stuff. So let's listen, folks, because I have the clip here, and Little Towel wants to rest his voice. So here we go. And hello, towel friends. My name is Grant Smith Ellis, or as some people call me, Grant Howard Cosell, David Attenborough, Towel Ellis. If you missed it today, testimony in the John O'Keefe and Karen Reed trial did resume after Karen Reed's health scare yesterday, which is still not fully understood, but her father did confirm was indeed, yesterday's court being canceled was indeed a result of Karen's health. Testimony picked up today with a damning series of clips that were played by prosecutor Hank Brennan. And folks, before we listen to the testimony from KF, John O'Keefe's niece, on this recap, why don't we also listen to that damning series of testimony, or those damning videos, because this is, if you were a juror, folks, this is what you would have saw right before John O'Keefe's niece took the stand. Hank Brennan arrived into court, and right as the court began for the day, ladies and gentlemen, the very first things jurors were presented with were these two clips, which shows just how much Karen's willing to lie.
As Amy went over here, that you guys have really been going at it. And this was sort of had like a last date element to it. Was that going on?
That was not going on. John made it clear to me, I'm never breaking up with you. You know, not never that we're in this good or bad, but you're the best person I've ever.
The Commonwealth would ask to show clip 19.
Okay.
I don't see how John would have known about my text with Brian. And I'm not sure if he knew he would have reacted very strongly. I think we would have broken up, but I don't think John would have lost it and caused a fight. I didn't feel like John's emotions with me got really strong.
Okay, thank you.
Sure.
And so, ladies and gentlemen, that is when then court cut out. The very next thing that happened in court is what you're about to see on your screen, folks, which was the testimony of John O'Keefe's niece. And ladies and gentlemen, we are going to take a look at that now. I have extensive towel notes. No one in the courtroom was allowed to record. There was no cameras, no audio recording. We could take handwritten notes, or we could use our cell phone to take notes. There was no live posting. This, folks, is the only record. And so that's why we're going to read it together. So my notes begin. Grant Smith Ellis, the media blackout notes during testimony on day 16 of the John O'Keefe and Karen Reed retrial, 5/24/25, 9:40 a.m. The direct of KF begins. She is calm and composed. Laura McLaughlin does the direct. KF begins with background details and hobbies. KF lived with John, who she called JJ. John was not married. John dated Karen Reed. KF then identifies Karen Reed in court. John and Karen started dating around 2020. Karen would stay over with John in Canton once a week or so in the beginning, but that got more frequent as the relationship developed. Karen at her own home as well. KF had a day-to-day relationship with Karen. KF says that some days the relationship was okay, but some days we weren't on good terms at all. John's niece then goes on to tell jurors that Karen would be cold to me. Karen was also closer to John's nephew, PF, who did not testify today, than she was to KF. KF then describes the defendant's vehicle as a black Lexus. Karen's car had a backup camera, KF testifies. It is now 9:48 a.m. Eastern. 8 minutes to go through that part. KF testifies that John was a Boston police officer. KF is asked how she would describe the relationship between the defendant and John. Like when, is the niece's reply. The niece then explains that the relationship between Karen and John was okay, but it changed a lot in 2022. KF testifies that John and Karen started to fight a lot at the end. The arguments happened in John's home in Canton, and those arguments were normally at night, the niece testifies. Arguments between Karen and John also occurred outside the home. Those arguments would usually happen over the phone. During those arguments, John would get frustrated with Karen, but Karen would not argue with KF herself. The defendant, says KF, would be much louder than John during the arguments. It is now 9:51 a.m. and the jurors get multiple instructions from Judge Cannoni about John's state of mind and about statements from Karen before the next section of testimony begins. Then jurors get another instruction, this time regarding Karen's motive and intent in the context of statements made by John and Karen in the weeks leading up to John's death. At that point, KF resumes her testimony by talking about the breakdown in the relationship between Karen and John. At this moment, the courtroom goes entirely silent as all 18 jurors take notes furiously as testimony about the Aruba incident begins. Karen saw John hug a family friend and then screamed at John for cheating on Karen before Karen then apologized for her behavior. After the incident, says KF, John came back up to his hotel room to check on KF and her brother, PF, to make sure they weren't on their iPads. Then Karen came into the room and started screaming at John in front of the children that John had cheated on Karen, the hallway hug mentioned earlier. Karen was screaming at that John had kissed the family friend, and John was saying he did not do so. Then Karen continued to scream at John, said KF, leading John to seek refuge in KF's room so that John wouldn't have to be around Karen after she screamed at him. Then Karen and John slept in separate rooms over those next hours, and KF got out of her bed and went to the couch so that John could sleep. Over the following weeks, KF then testified, more arguments happened between John and Karen. At John's house, in the weeks after the Aruba incident, so this is between December 31st, 2021 and January 29th, 2022, the day of John's death. This is in those weeks in between. More arguments happened between John and Karen. At John's house, in the weeks after the Aruba incident, the defendant and John were in the kitchen of John's home. Quote, I remember JJ telling Karen that the relationship between Karen and John was good, but it had run its course. Upon hearing this news, KF explained Karen became very upset and started screaming at John again. Karen yelled loud enough that KF could hear the argument through the walls of the house. It is now 10 a.m. Eastern. Now KF tells jurors that John asked Karen to leave the house again during the argument in the kitchen. Again, Karen refused to go. John was upset because Karen was screaming in front of the children, KF testifies, and John told KF that as the argument was happening, Then KF heard John go back to the kitchen and sternly tell Karen to leave the home for a third time. At that point, John went upstairs into his bedroom and closed the door. Karen, KF tells jurors, then follows John upstairs. John would not open the bedroom door, so Karen started pounding on the door with her fists. Karen never left the home that day as John had requested. There were then more arguments in the lead up to John's death. Quote, I could tell there was tension. Karen and John were cold towards each other. Quote, towards the end of January of 2022, KF tells jurors. John and Karen were fighting a few times per week by that point, KF went on to say. During one of those arguments, KF says, things got so bad that John had to leave the house to clear his head by going for a walk or for a drive. During that argument, KF heard Karen call John. Karen, on this phone call, told John that KF and her brother PF were worried about John. However, neither PF nor KF knew John had gone for a drive at that point. Karen lied and used the kids as emotional leverage, and the jurors took notes on every second of this testimony, all 18 of them. This was a big moment for jurors, as they were told in all but these words that Karen was emotionally abusing John as the relationship ended. At this point, KF then tells jurors that John again told Karen that the relationship had run its course. At that point, around 10:05 a.m. Eastern, the direct moved on to the events of 1/28/2022 and 1/29/2022. KF had a friend visiting that night until about midnight, and then KF went to bed. When KF and PF went to bed, like as a regular thing, PF wasn't home that night. There was a rule in John's house that they had to put their phones on a charger in another room of the house. KF did so on that night of 1/28/2022 into the early morning of 1/29/2022. During that evening, before she went to bed, KF got a text message from John asking if she was okay, as was John's normal routine, and KF let John know she was okay. KF then fell asleep, as mentioned, around midnight without her phone. The next thing KF realized, the defendant, Karen, was waking KF up by shaking her in her bed around 4:30 a.m. on 1/29/2022. Karen yelled for KF to wake up, and then Karen told KF that her Uncle John had, quote, never come home the night before. Karen then asked KF to call John. JF tried to call John and then tried to text JJ, but KF did not hear back. At that point, Karen started using her own phone and began running in and out of KF's room frantically. Next, Karen asked for Jen McCabe and Kerry Roberts' phone numbers from KF. Then KF called Jen McCabe for Karen. KF then put Jen on speakerphone and handed the phone to Karen. Karen was making other phone calls at this time on her own phone. It was as Karen was on the phone with Jen that KF heard Karen make statements about what could have happened and if Karen could have done something to cause John's death. Then Karen started asking if John had been hit by a plow. This was a wow moment for the jury, all 18 of whom were still taking notes during KF's direct examination, and some jurors had their mouth open in clear shock, in particular Juror 2. It is now 10:12 a.m., and KF gets her memory refreshed as to a statement made by Karen that KF discussed at a prior proceeding. KF recalls Karen saying, "Maybe I hit him," while Karen was on the phone, but KF doesn't remember if this was said to Jen McCabe or Kerry Roberts. And then KF, I think, also didn't remember that Karen said John's dead to Kerry, because I think even Karen might have admitted that before. At this point, KF is asked if Karen made a statement about the last thing that happened between her and John being an argument. Oh, I talked about this earlier. David Yannetti jumps up furiously and objects to the question. Judge sustains the objection. David Yannetti asks for a curative instruction. Judge Cannoni tells jurors to disregard the last question. Now, KF then says Karen Reed told someone on the phone that the last time Karen saw John was when Karen dropped John off outside Fairview Road on 1/29/2022 at 12:32 a.m. KF then says she had never seen Karen act in this way before, in the moments before Karen left John's house around 5 a.m. This is when Karen, between 5:07 a.m. and 5:35 a.m., potentially went back to Fairview Road to confirm John was dead on the lawn where Karen last saw John earlier that morning at 12:32 and 16 seconds a.m. Eastern, before Karen went to pick up Jen McCabe and Kerry Roberts after 5:35 a.m. Those 17 minutes between 5:07 a.m. and 5:35 a.m. are going to end up becoming very crucial in this trial. After 5:35 a.m., Karen, Kerry, and Jen drove back to John's house. This is when Karen drops off the alleged murder weapon with a broken taillight. While Karen, Jen, and Kerry were at John's house, remember, Kerry drove her car, or somebody drove Karen's car back to Fairview, and then Kerry's in her own car. So they dropped Karen's car with the busted taillight off. Then Kerry, Jen, and Karen go inside John's house. At 5:35 a.m., Karen, Kerry, and Jen drove back to John's house. This is where Karen drops off the alleged murder weapon with a broken taillight. When Karen, Jen, and Kerry were at John's house, only Jen McCabe went to check on KF. Jen was trying to console KF and keep her calm. Jen was KF's childhood friend's mother, and also KF's basketball coach. This was a heartbreaking moment, and some jurors seemed close to tears, as KF relayed that Karen did not check in on KF at all during the return trip to John's house after 5:30 a.m. that horrifying morning. KF then says again that Jen McCabe was the only person who comforted KF during that time after 5:30 a.m. KF notes that she was nervous because of how Karen was acting. Karen then left with Jen and Carrie Roberts without ever speaking to PF. Now, the afternoon of 1/29/2022. Karen arrived back at John's house after 12 p.m. Karen was sent to the hospital after 8 a.m. after making threats of self-harm and admitting to hitting John O'Keefe at the scene of John's death. KF had isolated herself in her room at that point in time. However, KF did come downstairs and Karen said, "I feel like I am living in a nightmare." Karen's family, while they were in John's home, said nothing to KF, and then they left, even though KF had met Karen's parents and Karen's brother previously. David Yannetti objects to the question as to if Karen ever spoke to KF again after 1/29/2022. Yannetti doesn't say it, but there was a no-contact order put in place a few days later when Karen was charged initially on February 2nd, I think, of 2022, maybe February 1st. Judge sustains Yannetti's objection and issues a curative instruction as to that question. This is how the direct ends. So the jury was left with the impression that Karen never talked to KF again, regardless as to Yannetti's objection. Now, a 2-minute sidebar before David Yannetti begins his cross. David Yannetti begins by asking KF if she referred to Karen as the defendant before John was killed. KF looks confused and says no. Then, on cross, Yannetti asks if Karen would take KF to nail appointments. KF says, quote, "Karen didn't take me to get my nails done once a week. It was once a month. Karen didn't stay with me during the nail appointments. Karen didn't like getting her nails done because it hurt her hands/nails. KF then says, Karen didn't take me to my eyeglasses appointments either. That was my Uncle JJ. David then asks about the Aruba trip after spending 15 minutes on nail appointments and basketball games. DY asks about the night of 12/31/21 in Aruba. KF says, I had just gotten dumped by my 8th grade boyfriend, so I was in a crisis. This was said in a playful way, and the jury gently laughs alongside KF. David then begins asking a very confusing multi-part question that confused the witness. The witness says, what? And David tries again with shorter questions. The witness then confirms there was not physical violence between Karen and John. It was more Karen abusing John emotionally. But Karen did bang on John's door during an argument where Karen was told to leave the home and refused to go. David then asked KF if John and Karen spent the same amount of time together before and after the Aruba incident. KF says it was the same amount of time, but it wasn't the same. And the way she said it wasn't the same vibe after the Aruba trip. She may as well have said the word vibe. She really should have. She didn't, but I got what she was saying. She put an emphasis on the word same. She was like, it was the same amount of time, but it wasn't the same. This is when David, she didn't say it that way. She wasn't like, she wasn't being like a jerk about it. She was just saying it wasn't the same, and she was really trying to say the vibe had changed. This is when David Yannetti ends his cross. It was about 15 minutes and 20 questions. Now, on redirect, KF says that things got worse between John and Karen after the Aruba incident. There was a lot more tension and a lot more fighting, KF tells jurors. Between 1/1/2022 and 1/28/2022, there were a lot more arguments and fights between Karen and John than previously. Karen again was asked by John to leave the home and would not go. Brief recross by David Yannetti around 10:41 a.m. The kids, Karen and John, went to a Bruins game on 1/20/22. This was the end, and there was no further redirect. And this was my closing notes. KF then leaves the courtroom. KF stayed calm and in control for the entire time while she was on the stand, but as she walked out of the courtroom, she was in tears. The jury didn't see it, but I did. As she was walking from, the room behind the benches to get to the exit, she got off the stand, got past the jury, immediately started crying. I looked at her eyes. She was in tears, but I was so proud of her. And then I said, KF was so brave. She is a super towel. Oh, ladies and gentlemen, it was it was really hard for me to just be emotionally stoic. I had to completely detach myself because when I'm too emotionally invested, I can't take notes like that. I was only able to take those notes because I detached myself and I said, I'm going to do this for her. If she can get up there and tell it, I can put myself to this and record as much as possible. Not record, but literally with my hand, write down as much as possible. And I did in real time, folks. Let me just tell you, it was very, very difficult Yeah, I do need to rest my voice, but I also think it's important that this get read. This information is important. And we're also doing our recap, folks. It was a devastating delivery of testimony, and I want to show you now because we've seen these clips before today. But for the folks who are just watching this recap, let's see the reaction by Karen Reed, her father, and then we'll close the clip with Hank Brennan's clip after that was played. After that devastating series of clips and testimony from KF. Well, the clips were Karen, and then the testimony from KF. Let us look at how Karen Reed reacted. Do you think it went well, folks? Do you think she no commented? She no commented. Straight up no commented.
Karen John's niece was on the stand. Any reaction to her testimony?
No comment.
What would you like to see her?
No comment.
We've heard a lot of talk about
Are you feeling better, Karen? Hi, Esty. Hi, Miss Reed.
Hi there.
You better watch yourself.
All right, folks. Oh, God bless you, Mandy Strong. Fantasy Towel Hubby. Oh, God bless you. How do we even phrase this? God bless you, fantasy. God bless you, fantasy towel spouse. You are a wonderful super towel. Oh, goodness. Towel's afraid of commitment. Ladies and gentlemen, this is a recap. Now let's look at Karen Reed's father, Reed, after that devastating testimony, and his daughter saying that she had no comment.
She's a fighter, and a stronger person. And so she just got she needed more sleep than she got, I guess. That's what she's doing fine.
It's not related to her long-term health issues.
Well, I mean, she does have MS, as you all know, right? So anything that wears on that ability to maintain your health and maintain your strength is in the simple. It's something that is very strong. So, no, it wasn't. It was just she was going down everything that they worked through the weekends. I mean, so people have a tremendous amount of pride and working to free Karen Reed from all of this persecution. And as you can see, they're doing one hell of an effective job.
Bill, what do you make of the hair on the bumper that made it out to Dighton and back in a snowstorm?
Well, listen, I'm a reasonable man, and I drove the vehicle there, and I did, by the way, clean off that bumper with my hand. I'm sorry, I didn't get to bring that off from your hand, but, so it's pretty remarkable, right? Glass traveling, as well as the hair. I mean, it's pretty remarkable. Conversations that they had hurting, and I was hurting for him. And my daughter was crying, and she hugged me, and they were both crying. And the rest I'll reveal if Jay wants to call me. I'm on the list, so we'll see if he wants to call me. Well, I wasn't sitting on a stool, dangling my legs and pouring a cup of coffee in my lap. Thank you.
Thank you. Be well, Mr. O'Keefe, Mr. Reed.
So there you heard that, friends. You heard it, towel friends. That was Mr. Reed's reaction. And now, folks, the clip that so many of you have been replaying. Apparently, this was quite an endearing moment, although Little Towel doesn't really understand why so many people found this endearing. Here was Hank Brennan's exit from court. And if you're wondering, ladies and gentlemen, did Little Towel somehow get permission to call Hank Brennan Hank? Yes, it was a moment. It was a moment.
You as well, Mr. Brennan. Okay, sir, I will, Hank.
Grant had a towel moment.
You as well, Mr. Brennan. Okay, sir, I will, Hank.
I don't even know if that's towel giggle worthy or what, but that was the day, folks. It was wild. It was intense. My name is Grant Smith Ellis. Tune in tomorrow. I don't know how we're going to do this coverage. I think I need to stay home. I was exhausted today. YouTube.com/@Grant Smith Ellis. No matter what, we'll have Karen Cam coverage. We'll have coverage of the full day's court tomorrow, Friday. It'll be May 15, 2025. My name is Grant Smith Ellis. I am going to finish this clip now. Tune in. There you go, folks. There you go. We got our clip. We played it for the towel friends. We are towels. All right, so if you missed it, by the way, I think those last clips were a little out of sync. Let's just watch the Karen clip one more time. If you're just tuning in, this was Karen leaving court yesterday after John's niece's devastating testimony that was blacked out from the media and the public, but Towel saw it in person and it was bad. Let's watch. I'm a towel.
Karen John's niece was on the stand. Any reaction to her testimony?
No comment.
What was it like to see her?
No comment.
We've heard a lot of talk about
Slow, Brandon. Slow. And the hearing is in that came up prior, correct?
Are you feeling better, Karen? Hi, SD. Hi, Miss Reed.
Hi there.
You better watch yourself.
All right, hold on, pause. Dear Towel Dewdrop said that I got the look from her, from the Karen, in her natural habitat. Let's watch it, shall we? Let's watch. How does Karen react? Oh, God. Now, just so you know, I wasn't that close. That cameraman on her other side and I were probably similar distance, but my camera does a tight shot if I set it to 16:9. So I was probably like 4 or 5 feet from her, but the actual camera angle was good. A wider shot wouldn't have looked as good. It was good that I had that camera angle on, or that camera style, but the way it did like make it a little bit cropped, like it would have been higher def if I had it zoomed out to a natural resolution. Not why, like if I had a better resolution, I think on the angle, the quality would have been higher. But no, the veneer of proximity is so much more intense. Because remember, she's looking at me from a few feet away, but it appears as if like I'm like in her face, which makes it even more interesting. So look at this look. I say, how are you
Feeling better, Karen?
She's not upset. Nope. She's not mad. She has lip filler, but she's not mad. Nope. That's not an angry Karen Reed. Sorry, I burped. She is genuinely pleased that I asked. And the only thing she wanted was for me just not to ask her really absurd. Like, she knows I'm asking her speaking questions. So she just wanted me not to, I think, like, she never said it to me, but I got the sense from her people that all she wanted was for me to just not, on days like that, ask her questions that, like, make her upset. Like, she's already upset. So, like, look at that. She's not upset. No, like, that's her. And she's not gonna talk to me no matter what, because, like, she can't. I think she wants to, but she can't be seen as countenancing what I'm, like, my view. Like, she knows that I have her. She knows that I know what happened probably better than anyone else. No one was there but her, John, and some.
Karen Reed trial
hold on.
So we know that you're true crime fans,
Hold
but
on.
are you also in a business of some kind? Well, if so, I want to tell you about
You know what
They're
this means?
sponsoring this live trial stream. So
This
Odoo
means,
is an
folks,
incredible all-in-one.
The Karen Reed trial is about 30 minutes, maybe 15 minutes or so away. But listen, let me just talk while we're waiting for that to come into session. Let me talk a little bit more about this, okay? There's something about it, like, that's not her. Like, yeah, okay, you want to listen to some of my questions from last year compared to this year? We can do that. Like, it was very different last year. We can watch some of these towel questions to Karen. Hold on. Let me bring up, I have to actually search for it, but let me bring it up for you. Do you want to see the type of questions I used to ask Karen Reed, folks? My word. Like, that was not a look of anger. That was a look of, okay, like, thanks, Grant. Like, I'm not going to respond to you, but thanks for being concerned about my health. By the way, I was not kidding. I'm one of the only people who persistently has been saying, stop wishing this woman harms herself. Stop wishing bad things happen to her. That's not why we punish. Part of it is, like, retribution, whatever, like, and repentance, but part of it is, like, rehabilitation, and it's meant to be like this restorative process where you're trying to get someone to criminally charged so that they understand they did something wrong. That's why plea bargaining is such a big part of the process. Like, it's not about just tormenting someone, and that's in the Karen Reed context. I've seen situations where people literally obstruct the criminal process, leading to, like, ongoing, very high level investigations to try to weaponize the criminal process to hurt people. That's even more egregious. I don't even like when people do it to Karen Reed, who I think was responsible for John O'Keefe's death. You don't need to do that. You need to understand why we punish if you're intending to hold Karen Reed accountable through the justice system. Otherwise, you're just being ridiculous. You're actually being ridiculous. Like, you're undermining the whole point of the justice system, and you're creating a toxic atmosphere. And that's why I think she smiled at me. Like, she knew, like, she probably would have said in any other world, like, thank you for asking. Like, I could have said anything I wanted to right there. Like, that was devastating testimony from Kaylee. She knew I had all the questions in my head that I want to ask her. But instead, the only thing I wanted to say, and this is why she showed, like, it wasn't an angry look. It was like, are you feeling better? Like, the only thing that I actually wanted her on camera to react to, knowing she wouldn't answer it, was like, how are you doing? Because that's what was on my mind. And, like, she got it. It was authentic. She got it. Even a mind like hers was like, oh, like, this towel, like, has got me, he knows that I did this. That's how I think she thinks. Like, he knows I did it. He kind of broke down a lot of my PR apparatus. He even figured out the federal stuff. There's a lot of resentment there. But then there's also this kind of, like, okay, but he's not gloating. Like if the shoe were on the other foot and Turtle Boy were, like, doing this to the state, like, it would be brutal. But he's not doing that. And so I think she's like, okay, so he's the one that broke the cycle of all this, so there's this kind of, like, I don't know how to explain it. She's like, okay, I don't think Grant gets, like, I think she understands that, like, I'm very analytically intelligent but not emotionally intelligent. So she's like, he just cares, like, unconditionally. And so, like, she's seen it tested over and over and over again. And so she's like, okay, he actually cares. Like, what do I do in the face of someone, like, one of the few people who doesn't want anything, like just actually cares. Like, what do I do? Like, you're staring into the eye of like actual goodness. And so, like, she knows, she wasn't going to react virulently. And like I'm saying, like, she knows. But you want to hear some of my previous questions? Let's check this. Went back. I think I asked her if she went back to, it was in April. No, it was on February 26, 2024. I asked her this question outside of court. It was a really good question, too. And Turtle Boy looks like an absolute idiot, by the way. Because she just walks by him. It was like the day he got released out of jail, like 3 days after or something. She just walks by him with Alan Jackson. Alan Jackson puts his arm around her, and they completely ignore him. It was actually really embarrassing. But there's a very specific, I think I may have actually said returned to. I have to actually get the clip. I don't want to go into my archive. I want to see if I actually have the clip, because I know it's the right clip, because the screenshot at the beginning is Turtle Boy sticking out his tongue like a moron, which just makes me laugh like a little towel. We're just a few minutes away, by the way, from the start of court here. Hold on. I know I have it. Let's see. What did I actually ask? Maybe I said at one time I said ask tough questions or something. I know that I reposted this at one point. Oh, I found it. Ladies and gentlemen, I am a towel. Look at this. Who asked for us to watch what the questions that Towel used to ask Karen were like? I found it. I'm a towel. Oh my goodness. I'm such an excitable towel, ladies and gentlemen. I am an excitable towel. Let's watch this. Look at what I did. By the way, folks, I want to point out that this was in February of 2024. I was asking Karen if she went back to Fairview Road before she went to Jen McCabe's. I knew she did. I knew it. And then listen to the second question. Karen, why'd you go back to Fairview before going to Jen McCabe's? Karen, why'd you hook Aiden Kearney up with the FBI? Well, that was Mr. Yannetti, wasn't it, Karen? Don't poke me.
Karen, keep going.
Oh, hold on. This is Murder by Maestro's literally all-time favorite moment. I want everybody, I want everyone to compose themselves. Murder by Maestro, try not to fall out of your chair, because I'll have to say, oh my God, he fell.
Keep going.
Oh, she took a different way. Oh my dear God, he fell. Richie, are you okay? Gonna take the plea, Karen? Do it. Hi, Alex. Yes, I know, but listen. You don't gloat. You don't gloat. You do not gloat. I don't, like, the whole point is the defense was being ridiculous, and now you want me to go out there and take a victory lap by asking her questions when she knows how bad it is? Why would I do that? That is unbecoming. It is profane, and it is uncouth, and I won't do it. I don't feel comfortable. You don't punch down. Why would I do that? Like, I don't like that. I don't understand. That's what I'm saying. Like, there was a time. No, Drew Drops. I know what her look there was. Like, she didn't say it, but like, I've seen a lot of her facial expressions. I know what they mean. That was like, thank you for actually being concerned. I know it's weird, but that was genuine. There wasn't, like, I know when she's faking it. I know when she's angry. It's her eyes that say it. Like, you can't look at her lips and you have to look at the smile a little bit because it will give things away, but she speaks through her eyes. Like, it's like a Mona Lisa smile almost. Like, sometimes it will be like a half and half, like one eye saying one thing, the other eye saying another. But no, in that moment, both eyes were saying the same thing. There was no processing of an internal emotion and then obfuscating it through a facial expression, and then there was no betrayal of the latent emotion through an uncontrolled facial expression. It was an authentic, genuine smile, and it was compassionate. It was reciprocally compassionate. I think she also knows my dad just passed away. It was literally like, I'm telling you, like, there are things that happen in that courtroom, I'm not going to describe them, where, like, that whole defense team was being compassionate to me. I'm telling you, that was compassion. Okay, ladies and gentlemen, what was the what do inquiring towels want to know, Eva? I don't. What was your question? Oh, okay. There was also other. We can watch another question that JLR asked her. That it used to be really brutal for her, and I got this clip, so this is actually my footage. Look what it was like on the day that JLR went up to her when she arrived at court one day. I think this was before the buffer zone. Hold on. I have to open this in its own tab. Even back then, like, I was polite when I was asking tough questions, but I would say this day JLR was not very polite.
Good morning.
This is explicit.
Hey, Karen, are you prepared to spend the rest of your life in prison, Karen? How's it feel to be known as a cop killer, Karen? How does it feel to be known as a cop killer? You're going to prison, aren't you, right? Do you have any remorse, Karen, for what you did to the O'Keefe family? You have any remorse, Karen, for what you did to the O'Keefe family, huh? Will you denounce your supporters harassing the O'Keefe family? Will you denounce your reporters harassing the O'Keefe family, Karen? Shame on you, Karen. That's what people say. Karen, anything to say, Karen? You're going to spend the rest of your life in here. Don't touch me. Don't touch me. Don't touch me. Karen, you're going to spend the rest of your life in prison, ain't you, Karen? Yeah, you are, Karen. Karen, you are, aren't you? Karen, watch out for Karen, you're going to spend the rest of your life in prison. Right, Karen? How's it feel to be known as a cop killer, Karen?
How's it feel to be known as an asshole?
How's it feel to be known as a cop killer, Karen? How does it feel to be known as a cop killer, Karen? How does it feel? How's it feel, Karen? How's it feel?
Karen, how did you manage to walk into Josh Levy's office in November of 2022? Do you know him? Does your father?
Karen, how's it feel to be a cop killer?
Mr. Jackson, did you go to Mexico with Melanie Little in the recent months?
Karen, aren't you? How's it feel to be a cop killer, Karen? How does it feel to be a cop killer, Karen? Shame on you for what you did to their O'Keefe family. Shame on you, Karen.
How was the trip to Mexico with Melanie Little, Alan Jackson?
I felt bad about that. By the way, and I'm only playing that for full context, but eventually we realized it was just Melanie Little was talking, who's a YouTube attorney and commentator. Melanie Little was talking about somewhere Alan Jackson had gone in Mexico, and eventually Melanie Little did something that was very honorable and stood up in defense of a vulnerable person and their family. And I never said anything about Melanie Little again. In fact, I apologized to Melanie Little, not because anyone asked me to, but because I thought Melanie Little was being honorable. But yes, ladies and gentlemen, that was the context. I thought the Josh Levy question from me was more interesting than the follow-up question. And then at some point, someone was like, "You're next to Alan Jackson, and that's what you ask?" And I'm like, "I'm a towel. You are literally asking a man who thinks he's an anthropomorphic towel, who thinks he's a horse racing announcer towel, that also thinks he's some kind of auctioneering announcer towel. You think that I care what your perception of my questions that I asked Alan Jackson are? And furthermore, why would I care about what Alan Jackson thinks?" Like, one time I looked at Alan Jackson in the bathroom. I didn't say it, but I was like, "Welcome to Massachusetts, Alan Jackson." Like, it's an absurd place with this very interesting juxtaposition of like an intellectual, like, elite, and then this like very wonderful, like, authentic, like, working class population. And like, Towel is the bridge between those two. Very entrenched, systemic, institutionalist with a lot of tentacles in a lot of places. And then also, like, I like being around regular people. I never want to lose touch with that. I struggle. I'm sure I'm going to struggle my whole life due to my executive dysfunction. I have like issues with like some day-to-day tasks, and like I'm a little clumsy, obviously, and like I don't manage money well, and I'm just always, it's like a very fundamental issue with the way my brain processes information. I can analytically understand concepts and stuff like that, but I can't manage like certain things. Like, my brain just doesn't think that way. So you all, like, I don't want you all to feel like you're gratuitously just helping me and it's not useful. What you're doing is you're helping me to like get caught up, because for years I've had this executive dysfunction disorder, and it's only recently been formally diagnosed, like in 2020 or 2021, and that, along with my physical issues, just like makes me go into this cycle where I want to just distract my brain from how much pain I'm in from my optic and facial nerve issues and my swallowing issues and my colitis. and I want to distract myself from the fact that I don't manage my day-to-day life well because I can't understand how to do it. And so I focus on like stuff like this. And now it's actually starting to come together. Like I was doing this for years, and I think people appreciated it, but I don't think a lot of people, like, obviously were like, you know, we didn't have the YouTube broadcast like this, and it just wasn't as engaging. And I don't know, you're seeing a side of me I'm glad I can share. So yes, JLR did have some great questions. I will definitely say that. Okay, so let's, you know what we're going to do now? Let's take a little look at, over at, first let's look at Towel, Jim, and Marjorie again. Well, we're not going to watch the Hank Brennan clip today, by the way, right now, because we are about to come into session. But you know what I'm going to check for you? I want to see if they took the feed of Karen's arrival. Nope. No live feed of Karen's arrival today, folks. It's been pretty boring and mundane. Oh, no. Ladies and gentlemen, I forgot. Christina Towell sent us an update. We're going to do it now. First of all, ladies and gentlemen, Sue O'Connell tried to apparently make a tweet or post about how Towel over lunch, she didn't mention me, I don't think, but Towel over lunch couldn't eat without his medical cannabis, which I am prescribed under Massachusetts state law. So I used a little bit of cannabis, and then 45 minutes later, after I sprayed myself with something that smelled like clean cotton, although I don't think it really worked, I went back in the courthouse. And ladies and gentlemen, Sue O'Connell was like, I can't think, posted, she was like, I can't think with cannabis smell around. No, I will go to the lawmaker, Sue O'Connell. I will make an explicit provision in state law stating that there shall be accommodations provided. You can't bring medical cannabis into a courthouse, but you can certainly use medical cannabis and then go into a courthouse. To deny me that ability would mean I can't eat all day. I barely ate as it was, Sue O'Connell. I had like one bag of trail mix until the afternoon. I am an incredulous Towel. I am an incredulous Towel, ladies and gentlemen. Yes, ladies and gentlemen, sometimes Towel's common sense is not very good, so you may tell Towel something like, you should do a YouTube channel, and it doesn't always, like, get through to Towel, because Towel's just very one-track minded, well, multi-track minded, but I just want to do things. I don't want to think about administrative things. I don't know how to do that. So but I'm smart enough to only have people around me that won't take advantage of that, so, ladies and gentlemen. I am a Towel. Okay, so that was Sue O'Connell. How dare you, Sue O'Connell? You shall not discriminate against medical cannabis patients. Ladies and gentlemen. Oh, Courtney Myers is here. Great to see you. Lisa, so dab pens are hard. We've talked about this before. Most dab pens are just THCA, which is only one of a complex set of 70 to 80, I think, total cannabinoids in the full cannabis plant. One, it's not medicinally helpful to just rip THCA, which is primarily a psychoactive compound, and I don't want that. I'm not using cannabis to get high. I'm using cannabis because it has, when you use the actual plant, and there are some vapes that are full plant extract, when you use the plant, it reduces inflammation, in particular for people with the condition I have, and then I can eat. And so then I don't have to be on prednisone. So it's not for me about the odor. Like that's why it's incidental to me, and I do think it's discrimination. I'm going to consume the plant in the way that allows me to eat. That's what my doctor prescribed it for. I have one of the conditions that's specifically enumerated under statute for access to medical cannabis. Like my medical record is as long as the day is long. So I don't know. Like, I don't think anyone would say anything because, first of all, I helped write and implement the adult and medical use law. Second of all, I know the regulatory framework, 935 CMR 500, 935 CMR 500,000, 935 CMR 500,001 better than anyone else. And two, if they did something, I would go to lawmakers and be like, how dare you? We need anti-discrimination provisions. You may not ban medical cannabis patients from the courthouse if they smell like their medicine. That's outrageous. Now, I'm not saying we should have medical cannabis in the courthouse, which I did not have. I would never do that. But you can't tell me I can't use my cannabis to eat over lunch. That's literally discrimination. Folks, the Karen Cam is about to go live. Ladies and gentlemen, we're switching screens. Stay with Little Towel. We have an update, by the way. We're going to do it during the break. Ladies and gentlemen, look what happened to Chewbacca. Oh, my God, ladies and gentlemen. David Yannetti deployed. Yeah, prednisone is so rough in so many ways. Harvard Yard, God bless you, dear friend. Pilgrim Shadow, I agree. It's so intense. Folks, listen. I have gotten this update from Christina Towell, ladies and gentlemen. David Yannetti deployed the spaghetti, and Chewbacca, right as the Stay Puft Marshmallow Man was preparing to do his cross, or his direct of Chewbacca. Well, no, I guess it would be a cross. His cross. I forget who's the lawyer and who's getting called in that situation. One of them is a lawyer, the Chewbacca, who's actually a dog named Chloe in a wig. And so the Stay Puft Marshmallow Man is the lawyer. And Chewbacca, who's actually a dog named Chloe in a wig, is getting called to the stand. David Yannetti puts out bowls of spaghetti, and Chewbacca, yes, and then, of course, David Yannetti used the pink shirts towel distraction technique. Very classic defense, folks. Studied in law schools throughout the country, clearly. But, ladies and gentlemen, you can't. How do you respond to that? Look at the Stay Puft Marshmallow Man. He is like, what do I do with the fact that Yannetti has put out spaghetti for the Stay Puft for the dog in the Chewbacca costume? Of course, the dog's gonna want to eat the spaghetti. Oh my goodness. I understand. No, don't worry, bossy Texas chick. Court's about to come into session anyway. I think what I'm saying is we are still there. I'm still very analytical. But first of all, we have to remember what's going on in the trial. Bob Alessi is about to go back into this cross that for an hour didn't go anywhere. I don't expect anything to actually come up until Hank Brennan goes back up on redirect or the next witness comes in. But yes, Eva, do you mean, do Kevin and I get in fascinating debates about the 4 different types of testing methodologies for total yeast and mold in cannabis, like qPCR versus PCR versus plating, and the way in which those various methodologies might be manipulated on the client end, the lab end, when they're buying these kits or testing methodologies in order to artificially manipulate pass-fail rates to help clients like large dispensaries and producers get product that's dangerously contaminated with total yeast and mold above the 10,000 CFU per G threshold mandated under state regulations. Yes, I know, Kevin, and we discussed that a lot. Eva, if you tell your son, if you were like, oh, I'm in Grant's YouTube channel, I promise you, if Kevin replies back, and then if you say, oh, then Grant told me that you and him get into interesting debates about the nuances and distinctions between qPCR, PCR, and plating methodologies in the context of total yeast and mold testing, and Grant apparently has a lot to say about the manipulation of total yeast and mold testing to benefit very wealthy corporate cannabis interests, and he thinks that there might be an ongoing federal probe across a number of jurisdictions that's going to ensnare a number of regulatory and corporate players. But then again, I'm just a towel. I don't know what you're talking about. And let's go about our day. Yes, Eva. So I think what folks may not realize is all of this towel persona and demonstration you've seen, the folks in the Massachusetts, well, nationally, I guess internationally, now that I think about it. Basically, anyone who covers cannabis has been watching me do this in the cannabis sector for a very long time. Kevin McKiernan he runs, his company is Medicinal Genomics. I think his family came out of like biopharma money. They're some like big equipment manufacturer for biopharmaceutical companies or something. But anyway, he runs a company that produces kits, the Medicinal Genomics kits. I think they are a PCR methodology. I don't think it's a qPCR. It's either qPCR or PCR methodology, which is a form of testing. There's 2 ways that you can test cannabis for the presence of total yeast and mold, I'm speaking very generally. One is you can use something which is more like the industry standard, which is this plating method using Petri film, where you incubate a sample over 72 hours on a Petri film, and then you're culturing it, and then you test for the presence of total yeast and mold. That's the only real way to do it, or at least for a long time. But even that way can be cheated, because if you run your culture for like 48 hours instead of 72, you can easily get an artificial pass for the presence of total yeast and mold when there is actual yeast and mold on the product. But Kevin's company created a different kind of testing methodology, which is good. It's either PCR or qPCR, and it's like a poly something chain reaction, polyisonomer chain reaction type of testing methodology, and it's quicker. It's efficient, it's accurate, but it's quicker. Now there was, I think, medicinal genomics is a good industry actor. I have faith in them overall. But there was just a lot of issues, not necessarily with the kit itself, but with how some of the labs would deploy these different kits. There's also another process entirely, which is called the microarray hybridization methodology for testing adult use cannabis. And that is operated by a competitor to Kevin's company, and that's Pathogen DX out in Arizona. A guy named Milan runs that. Anyway, so that method is like this black box process. And so the debate right now in the adult medical use cannabis world, which is bubbling up nationwide, is there testing lab fraud occurring through the manipulation of the implementation of these various testing methodologies, whether it be manipulating plating by running the samples for a shorter amount of time than required while incubating them, whether even Kevin's methodology, and I've looked very intensely into this, it doesn't happen anymore, but at a certain point you could kill off the live and dead DNA using something called the Grim Reefer, allegedly, and then therefore you could always return a result that was favorable to your client. Kevin wasn't doing that, but the labs were trying to manipulate the implementation of the methodology. And then Kevin, I think, is a good industry actor who wants to hold people accountable. His methodology has been refined over the years to ward off this kind of manipulation. And then, by the way, court's not in session. I'm just telling you about how these different methodologies can be manipulated. Now, the microarray hybridization methodology by Pathogen DX, that's the most controversial. These methodologies are accredited by something called the AOAC. Now, the AOAC is accredited plating, obviously. It's accredited, it accredits, there are different accreditation bodies, but the accreditation body for this type of microarray hybridization methodology that's on file, at least in Arizona, and with Pathogen DX as a company, is from AOAC. Now, what's weird is Pathogen DX, unlike other testing methodologies, the microarray hybridization methodology uses a black box process to interpret the data, and then it gets, so the client, the cannabis grower or whatever, sends a product to a testing lab. Testing lab samples it, sends it to Milan. Milan's company puts it into a black box process, interpolates the results, sends it back to the client. It did get accredited by the AOAC, but even that accreditation process was a little weird. I've looked into it. There was just some weird document swaps that happened. Like, I don't think the methodology, just in my opinion as a lay towel, is as accurate. And I think there's a lot of questions among the scientific community as to the validity of the results produced by this black box microarray hybridization process, but that's one of Kevin's competitors. But anyway, a good way to explain this is all of this stuff that I'm doing with this trial, I do in other contexts as well. You all just happen to be catching me do it in this context, and I know a lot of you, but by the way, so you were talking about like PCR in a different context than that other stuff that you're talking about. This is very specific laboratory-based PCR assays of cultured adult and medical use cannabis samples. It is, for that purpose, it is very good. Now, there are some nuances, as I mentioned, a competitor to Kevin, but we don't need to talk about all this. I appreciate the sidebar. The only reason we're talking about this, by the way, is because we're not in session yet. And by the way, as soon as you ask Towel a question like that, if you inadvertently go into Towel's repertoire, we are just going to shoot off like a rocket ship, ladies and gentlemen, and that's exactly what you got. Court's supposed to start at 9 a.m. And by the way, look, folks, we're about to transition over to our favorite screen. The Karen Cam is about to come into session. Oh, ladies and gentlemen, yes, Trevor McIntyre, it was a little weird that Karen got a day off. But I say, ladies and gentlemen, your favorite screen has appeared. I'm a little towel. My name's Grant Smith Ellis. No, Eva, it's not a worry. I hope you enjoyed me providing that interesting explication of those testing methodologies and the implementation thereof and how it can be manipulated in a way that is a threat to public safety and public health, and why regulatory intervention by way of informed and more erudite secret shopper programs, and then furthermore informed and more erudite standard operating procedure check and balances will be the solution. And I'm working on that right now because I'm a towel. I'm a multitasking, efficient towel. We have the fan. Oh, my fan. And look, ladies and gentlemen, we don't actually have to watch the fan because Christina Towel got us a Stay Puft Marshmallow Man fan stopper. It may cut him into little pieces, ladies and gentlemen. It may make us sad little towels, but he stopped the fan. Oh, yes, ladies and gentlemen, I rhythmically conduct. I am a towel. I repeat, ladies and gentlemen, I am a towel. And you may say, sir, you cannot possibly be a towel. You are actually a man. No, if I can be a horse racing announcer, if I can be an auctioneering announcer, if I can understand various testing methodologies in the context of highly complex scientific overview, regulatory frameworks related to adult medical use cannabis in the presence of total yeast and mold therein, then I can be a towel. Ladies and gentlemen, we're about to go into session. I'm a towel.
Okay.
Let's now open an AC.
You are unmuted. I was told counsel wanted to see me. Okay.
Sidebar! Sidebar! I repeat, we have a sidebar. Ladies and gentlemen, sidebar alert. Oh, we can get rid of the chew. Well, I mean, we might actually need the chewy. There is no one there. Oh, my goodness, it's empty. Look at those empty seats. There is no one there. Look at that. Oh, my fan. I am a towel. There's John DePetro. I could have been hanging out with that court officer. I'm so tired. I couldn't do it. I needed to be with you all today. I'm a towel. Ladies and gentlemen, I am a towel. I repeat, we are about to go into session, and you might be saying, sir, this level of energy is like Bob Alessi failing to read the room. No, folks, we need the energy. We're going to have to listen to Bob Alessi cross. We must get intensely ready. We must ready the towels. Judge Canoni is like the horse racing official. She's standing on the sideline. Oh, my word, the lawyers are at the ready. The lawyers are actually towels. And I mean horses in this analogy. Some of them can be towels. Bob Alessi, instead of apparently doing what horses are supposed to do, will most likely run around in a circle. There you see Bill Reed. He looks a little tired. His head is hunched. It is only 9 in the morning, and he's already tired. Yes, Your Honor, says Stacey Gardner, the defense would like to object to the fact that Hank Brennan is brilliant. Judge Canoni would say, Mr. Alessi, that is not a valid objection. Then Mr. Alessi would be like, I need to come to sidebar. And the judge would be like, you can't come to sidebar to tell me that Hank Brennan is brilliant. Nobody Pilgrim Shadow. I think there's a lot of us that some days don't go. And then at 10 o'clock, I think like the AP or whatever can go in and take the empty seat. But yesterday there was more empty seats than reporters. And so as long as you were on the 10-person list or the 3-person alternate, maybe you had to wait a little bit, but you could have gotten in yesterday. Oh, there's the court officer. I told the court officer that people really like her. She smiled. I told the other court officer that people like him too, the big guy who stands in the middle, and he was like, oh, that's sweet, and then he blushed a little bit. One of the court officers was reading our chat, the guy in the suit. And then I was like, I saw him reading over my shoulder, so I started typing in chat. He was reading over my shoulder. And then all of you were like, we love you, court officer. And then I saw him smile. Long sidebar. Don't forget, folks, this is Towel Stream. You have a beautiful Karen Cam about to start up as the day resumes. You all like the Karen Cam. We all like the Karen Cam. It should be turning on as soon as court goes into session. I'm a towel. We are monitoring closely. We're watching. There's the O'Keefe family. We see Dougal there as well. And then we see the family and supporters. We should be coming up on Miss Peggy O'Keefe any moment now. There's Tara Kerrigan, one of John's dear friends. We await, folks, the further pan of the camera. Okay, the sidebar might be ending. Ladies and gentlemen, ready your towels. Bob Alessi's going to go into the infield grass. He doesn't know how to run around in circles like he's supposed to. He is not a good towel. Oh, look at that. The media pen is just empty. It's 5 people, ladies and gentlemen. They've given up. They don't want to listen to Bob Alessi. Oh, ladies and gentlemen, the humanity. Oh, the humanity. The good ship Hinden Reeg. Oh, no, the good ship Hinden Reeg is going down in flames. The good ship Hinden Reed. Oh, ladies and gentlemen. Oh, it is. Oh, the humanity. Oh, the humanity. We have to wait even longer now. And we have to look at the fan. Oh, ladies and gentlemen. The good ship Hinden Reed is collapsing. Oh, the humanity. Oh, ladies and gentlemen, there's like 4 people in the gallery. Oh, the media has abandoned hope. Abandon hope, all ye who enter this room. Oh, ladies and gentlemen. I heard that Turtle Boy has something in Stoughton today. But ladies and gentlemen, let's take a look at Stoughton District Court. And let's take a look, because we can look at Stoughton District Court daily list. Let's see, and then we can go to mass courts. We can go to mass courts. Court TV can send anyone they want. When you have an outlet like that, it's your choice as to what reporter you send. They're not going to micromanage your reporters. Hold on. Let's see if Aiden Kearney. Yeah, hold on. Kearney's got something at 9 a.m. in Stoughton, but hold on. It's not like he's on the media list this week anyway. Let's figure out what this is, because these might have been the charges that got bound over. If they got bound over, then all that's going to happen at that hearing is they're going to say they got bound over. I don't think they can move to revoke bail. Sorry. Towel's monitoring, though. Who's he? Oh, yeah, I think Karen comes in. I think Karen monitors this stream a little bit. I think she likes to watch, and I think she also finds me interesting. I don't find her interesting. She's a little scary. I think she's smart. Well, I shouldn't say I don't find her interesting. She just kind of, like, she's scary. Like, that's not, like, okay, people like that exist in the world, but, like, I'm not into that. Like, I don't like intelligence games. All right, let's find out what's going on, folks. What is going on today at Stoughton District Court? Yeah, so this isn't a noticed hearing on his doc. Oh, it's just a pretrial hearing. So, listen, these are the 2 charges. This is the charge that was bound over. So, my guess is that I don't see any specific motions to revoke bail or anything. Yeah, it just says pretrial motion. So my opinion is that Aiden Kearney is going to walk into court. The judge is going to say to him, or the prosecutor is going to say, these charges have been bound over to Superior Court, and then we're going to go from there. But yes, we have to keep a close eye on this. Kearney also lost his motion to dismiss this case. So, we're watching closely, folks. We're still at sidebar. Well, we're not at sidebar. We're in recess as the jurors get brought over. No, Ed Jobs, I don't think the jury really was paying attention to that part. What I think jurors were waiting for is, okay, so this woman collected all this evidence. What happened to it? And we're going to find out next probably what the results were. So, no, I didn't get the sense the jurors were thinking about that at all. They were more, I think, trying to figure out, as I was saying, what was this? Okay, so you found a hair, you found this, you found piece of plastic in John O'Keefe's shirt, tail light. Does it all line up? And now we're waiting for the results. That's the vibe I got. And this witness doesn't give the results. It's outside the scope. This witness just collects evidence and sends for result. Yeah, we're waiting, though, folks. We obviously know all the parties are in court. We're just waiting for court to come back into session. We got the Karen cam ready to go. That'll turn on right after court comes into session. Yeah, you can't really predict what a jury will do, but they don't like her. That's a big indication. And not liking the defendant is the worst thing that can happen for a defendant. The jury not liking the defendant is the worst thing that can happen for a criminal defendant.
You are unmuted.
Okay, we're about to start. Hold on, folks.
Hey. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. We thank you for your patience. Once again, we worked out something here this morning rather than having you watch us over at sidebar. So we appreciate your patience. I do have to ask you those questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you. May we have Ms. Hartnett, please?
I'll remind you, you're still under rule.
Yes, thank you. Good morning.
Good morning.
Go right ahead, Mr. Lessie.
Thank you, Your Honor. Good morning, Ms. Hartnett, and welcome back this morning.
Good morning.
Your Honor, if I could please have Exhibit 145 that is in evidence published.
Yes.
Mr. Wolk. Ms. Hartnett, you will recall discussion about the taillight from the Lexus that was discussed on both direct and cross-examination yesterday?
Yes.
And you recall the discussion with regard to the weather that was in existence on or about January 29th. I'm not going to go into it at all. I just want to sort of refresh and reorient to where we were on that topic. You recall that?
Yes.
And I am now going to reference specifically what you referred to yesterday, I believe, as the inner part of the taillight, sometimes the inside of the taillight. Do I have that parlance correctly?
Yes, that's correct.
Thank you. So my question is, did you find any sand or salt or any other debris in the inside portion of that taillight?
No, I did not.
Now, and you can take that down. Thank you, Mr. Wolf. You recall discussion about shards of taillight? Do you recall that discussion at all in your testimony?
No, I'm sorry, I do not.
Okay. I wasn't certain whether we had that parlance. So my question is, to your knowledge, was there any testing of any taillight alleged to have been found at 34 Fairview for biological material?
No, there was not.
And could you just please state what your definition is, inclusion, when you refer to biological material?
Those items were not processed in the criminalistics unit for any type of biological, meaning they would not tested for blood, semen, saliva, or a skin cell collection.
I'm sorry, I missed the last part that you...
Or a skin cell collection.
Now turning and changing topics. There was a T-shirt and a hoodie of the decedent. Do you recall that?
Yes, I do.
And are you okay with my parlance of T-shirt, the yellow or orange T-shirt on the one hand, and then the gray hoodie sweatshirt? Is that an acceptable parlance for you?
Yes.
So with regard to those two items, if I could, Your Honor, have published what is already in evidence, Exhibit 151 and 150, and Mr. Wolk, if we could please put those side by side. Alrighty, so is it correct that what's on the left is the right sleeve of what we refer to as the hoodie, and on the right is what color would you like to call that T-shirt?
Orange, please.
All right, so the orange T-shirt. Is that what we're looking at up on the screen?
Yes, so it's the right sleeve of the gray hoodie and the back of the orange T-shirt.
Thank you. Am I correct that you included a handwritten note on your report that you found, quote, debris from each of these two items, or from these two items collectively?
I don't handwrite notes on my report, so I'm just confused about where you're asking that.
Okay, I'll ask a different question. Hopefully it will be clear. Did you find debris on either of those two items of clothing?
Yes, I performed a debris collection on each of those items and combined them.
I'm sorry, it's not your fault, it's mine. There's a HVAC noise I can't hear. If you
So
could
can we
speak up
turn
just
the
a
air
little.
conditioning off, please?
I'm okay with
I can
it.
speak
It's
up.
just
I'm
if you could
sorry.
speak up a little. I don't want to
Of course.
discomfort people. Can you move the mic?
Yes, I can speak up. My apologies.
If you could speak a little louder, that'd be great. Thank you.
Yes.
Can you repeat your answer, please?
Can you repeat the question? I apologize.
Sure. Did you find debris on these articles of clothing?
Yes, I took scrapings from each of these items of clothing and combined the debris. Yes.
With regard to scrapings, can you describe how the term scrapings relates to these two items of these two items that are on the screen?
Yes. Scraping is the mechanism I use to remove any debris that was remaining on both the sweatshirt and the T-shirt. I held each up over my lab bench. I took a long metal spatula and scraped any debris that was on these items into a small glassine packet.
Is it correct that you do not know where the debris came from specifically, other than it came from one or both items of both of these two items?
Yes, that's correct.
So the debris could be from just the hoodie, it could be just from the T-shirt, or it could be a combination of the both?
Yes, the items were packaged together, so they were already commingled. So there was no way for me to determine which debris came from which item, and it would be misleading to label them as such, so I combined them.
Exactly where my next point was going to go to. Thank you. And my next questions. So what, if anything, were these two items contained in when you got them?
They were contained in a brown paper bag, and they may have been contained in a larger box, but I don't remember off the top of my head.
So when you got them and you saw them for the first time, using your term, they were commingled together, correct?
Yes, that's correct.
And was there any debris in the bottom of the bag?
There may have been. When I examine something on my bench, I also shake out the bag to ensure that nothing is left behind and that everything is examined and accounted for.
Now, am I also correct that there is no description of the actual debris that you found? For example, you didn't specify whether it was little fibers, little hair, little pieces of this or that. Do I have that correct?
Correct. I did not do any examination on it. I just packaged it.
And therefore, you didn't note whether any of the debris was a plastic or a plasticine nature, correct?
Correct. That would not be part of my analysis.
And there was no marker put on any part of the debris that was recovered. Is that also correct?
I labeled the debris with an item number. I'm not sure what you mean by marker, if that's what you mean.
Parts of debris, in other words, there wasn't separate identification or markers for separate pieces of debris.
No, I did not separate out the debris.
There was no photograph taken of the debris?
Not by me, no.
Do you have knowledge of whether there was a photograph taken of the debris by anybody?
I do not.
So you have, as you sit here today, you have no knowledge that there's a photograph of the debris?
That's correct, I do not.
When you received the hoodie and the T-shirt that's depicted as 150 and 151, they came in together, commingled with some debris at the bottom in an evidence bag. Is that correct?
I'm not sure if there was debris at the bottom of the bag. What I can say is that there was debris on the items, and I did shake out the bag. I don't have a memory of anything coming out of the bag. I don't know.
Okay. So there could have been debris at the bottom of the bag when you shook it out. You just don't recall.
Yes, correct.
If we could, Your Honor, please have Exhibit 154 already in evidence published.
Okay.
And let's keep it there for a moment, and then I'm going to ask Mr. Wolk for you to zoom in. Ms. Hartnett, do you recognize this generally, and then I'm going to have it zoom in so you can read it, as an evidence bag?
Yes.
Now, Mr. Wolk, could you please zoom in starting from the top so that Ms. Hartnett can fairly read this. And if you could, Ms. Hartnett, just take a moment to read it, and then I'm going to ask you some questions, but I want you to have a fair opportunity to read it. Let me know when you're done.
Okay.
And if we can then scroll down, Mr. Wolk, so that Ms. Hartnett can fairly read the rest of what's on there.
Okay.
Thank you. Now, Mr. Wolk, if you could just leave it where it is now. With Your Honor's permission, I don't see a need to keep the lights off. Can have that on, but if Ms. Hartnett needs it,
please.
You'll just let us know. So, is this the evidence bag that the T-shirt and the hoodie were in when you received those items?
To the best of my recollection, yes.
You see the name of collected by someone there. Can you read who that states it was collected by?
Yes.
And state what that is.
It says TPR Proctor.
And are you able to conclude what the TPR stands for?
Generally, we use that to abbreviate trooper.
Right. So that is former Trooper Proctor that it says collected by, correct?
That is what's written on the bag, yes.
And the date of the collection, if we can just, Mr. Wolk, just focus in on that. Thank you. The date of the collection is January 29th, 2022, correct?
Yes, that's correct.
Is it a fair conclusion from this evidence bag and your experience on the matter to conclude that former Trooper Proctor was the person who collected the evidence and put it in the bag?
I have no knowledge of who actually collected it and put it in the bag. I can only read what I see on the monitor.
In terms of, and if we could, Mr. Wolk, please take that down and put back up the side-to-side images and depictions of the T-shirt and the hoodie. Do you know the journey, if you will, of those two items before you received them?
No, I do not.
The debris that you ultimately saw on the hoodie and the t-shirt, and that which may or may not have also been additionally in the bag, do you know where that debris would have been picked up from?
No, I don't know the source of the debris.
And you were not provided with information as to the potential source of that debris, correct?
No.
Were you aware of whether or not the debris, whether those items had been on the floor of an ambulance or a floor of a hospital?
No, I did not have any information like that.
Is it important to maintain the sanitary condition of evidence generally to avoid contamination?
We do our best to avoid contamination once we receive items into evidence, yes.
And what are some of the protocols that are used to avoid contamination of evidence, generally?
Generally, wearing gloves, putting items in packaging, bleaching any materials or utensils that we're going to use, or using disposable materials, sterile materials when possible or necessary. We also wear lab coats when processing evidence.
Is another protocol or technique to separate out pieces of evidence to prevent cross-contamination?
Sometimes we will separate pieces of evidence. If the items are already mixed in with each other, then the items are kept together, can be kept together.
Do you know the chain of custody of either the hoodie or the t-shirt?
I only have record of the chain of custody from when it was delivered to the lab.
So before any delivery to the lab, you do not have knowledge of the chain of custody of either of those two items?
No, I just know which detective unit dropped the items off.
And which detective unit was that?
Norfolk Detective Unit.
What I would like to now do is to, we could now take that down. Thank you, Mr. Wolpe. I want to sort of speciate, if you will, separate out the evidence that you have talked about so far so that it's clear what you submitted and what may have been submitted by others to the lab. Do you understand that concept generally?
Yes.
Thank you. So what I'm going to do is to give categories, and if you would be kind enough to say, I submitted it by some other person, that would be helpful. Any items that were collected from the vehicle, who submitted those to the lab or brought them to the lab?
I did.
The swabs from the red Solo cups.
I submitted the swabs.
The drinking glass that you were presented with at Canton PD.
I submitted that item.
The two clothing items that we just saw on the screen, the hoodie and the t-shirt.
Those were submitted by the Norfolk Detective Unit.
Were there also any fingernails that were part of the investigation and that you had knowledge of?
Yes.
Describe what those were, please.
Fingernails may be collected at the medical examiner's office, and there are clippings from the top of the fingernails of the victim.
And were those submitted to the lab?
Yes.
And by whom?
By the Norfolk Detective Unit.
And the phrase known blood standards, are you familiar with that phrase?
Yes.
Can you tell the jurors, please, what that means?
A known blood standard is a sample of blood that is collected from an identified person.
And which person were those known blood standards related to your knowledge in this matter?
We received a tube of blood that was identified as belonging to John O'Keefe.
And with regard to the fingernails and the known blood standards, who submitted those to the lab?
The Norfolk County Detective Unit.
So am I correct to conclude that for those items that you submitted to the lab, you knew about, you knew sort of their journey, if you will, but that those items that were submitted by, I think you referred to as Norfolk County, was that your parlance?
Yes, correct.
You don't have knowledge about those other than that they were submitted by them?
Prior to them arriving at the lab, correct. I have no knowledge of what occurred, where they were stored or anything like that before that.
And no knowledge of those items not submitted by you would include no knowledge of the chain of custody of those items, correct?
No knowledge prior to them being received into the lab. That is correct.
Your Honor, if I may have a moment, please. It'll probably be 30 to 45 seconds. Thank you. Bear with me, please. So the questions I have for Ms. Hartnett at this time, thank you for answering my questions, Ms. Hartnett.
Thank you.
All right, Mr. Brennan, any redirect?
Yes. You mentioned that you had an opportunity to observe a paper bag that had red Solo cups in it.
Yes, that's correct.
And the red Solo cups had a coloring of red in the cups?
Yes.
You'd never seen blood preserved in cups like that before?
Objection, Your Honor.
To the form. Sustained.
Had you ever seen blood stored in cups like that before?
No.
Do you know the circumstances of storing that blood?
Can you rephrase that question, please?
When the blood was stored in the cups, do you know the circumstances?
Sorry, Mr. Brennan. Your Honor, objection. Can we have a sidebar, please? It's important.
Okay.
The coloring in those cups, do you know firsthand what that comprised of, what the item was?
Are you asking me if I knew what the contents specifically of the cup
Yes.
were? No, I do not.
And so the red cups with the red spots stored in them, do you know the circumstances surrounding the effort made to try to preserve that evidence?
Can you just be more specific in what you mean by circumstances?
Sure. Do you know where those red cups came from?
I was told they were collected from the scene. I don't have firsthand knowledge of the collection.
And you weren't at the scene that morning, were you?
No, I was not.
Do you know that what the circumstances or the challenges were that morning?
No, I'm not aware.
You said that you respond to active scenes and sometimes, like in this case, after the event happens?
Yes, that's correct.
Is there a difference when you're at an active scene as opposed to when you arrive at a scene that is past the event?
I would say multiple units are working at the same time, attempting to document, preserve, and collect evidence.
You were asked a few questions about the top back of the Lexus SUV.
Yes, that's correct.
When you were first asked the question, you were asked if you had studied that area, and you said you didn't recall if you looked at that area.
I did look at the area. I looked over the entire vehicle, but I didn't know anything specific in that area, no.
When you say you looked over the entire vehicle, did you look over the back of the vehicle as well?
Yes, the only part I did not look at was the roof of the vehicle.
Did you study all sides equally? Did you spend time with the entire vehicle?
I believe I made an effort, yes, to look at the entire vehicle.
When you studied the back of the vehicle, not the right side or left side, the back, middle, did you find any hair?
I did not note any hair, no.
Did you find any scratches?
The only scratches I noted were ones that I had spoken of previously on the right.
When you looked at the left side of that Lexus, did you find any dents or scratches?
Nothing that I noted, no.
Did you find any hair on that side of the car?
Not that I noted, no.
Did you find any dents, scratches, or hair anywhere but on other than the right side quarter of that Lexus?
I did not note any. I also did not examine the interior of the vehicle.
You said that you removed the hair. What do you do after you remove the hair?
The hair is placed into a small glassine envelope, then placed into a larger manila envelope, and then I signed and sealed it, gave it the appropriate case number and item number, and then secured it in our storage room.
Can that hair be further tested?
Yes.
Is that something you would do or a different person?
I don't perform testing on the hair. I performed a microscopic examination of it, and then additional testing can be performed by a different unit.
Let me ask you some questions about where you found the hair. You saw the two different angle pictures yesterday that you described?
Yes, I saw 2 pictures of that hair yesterday.
You were also shown some video where the car had snow and ice on it. Is water a conduit? Does water ever act as an adhesive?
Objection, Your Honor.
Can we stop that, please? And can you see that's 5:51:54 p.m. on 1/29/22?
Yes.
When you first saw this vehicle, it didn't have that snow on the right back near that taillight, did it?
Objection, Your Honor.
Ask it differently, Mr. Brown.
When you saw this vehicle for the first time, did it have that snow packed into the back right of the car?
No, to the best of my recollection, there was no snow on the vehicle when I saw it.
And the hair where you found it, you see the red back taillight, the piece of red that's showing?
I do see that, yes.
In reference or relative to that red, was the hair to the right, left, below?
I don't recall at this time.
Okay. Do you see the ice or snow on the right side quarter panel of that Lexus?
I don't see it on the quarter panel. I'm not sure what you're speaking of.
If we could move that video forward, please, to 702. And then to 749, please. Stop. Go forward just a little bit, please. Stop. Okay. There's still remnants of snow. Did it look like that when you first saw it?
No, I believe I did not see any snow on the vehicle when I saw it.
If you could fast forward, please. Thank you. You can take that down. Thank you. You were asked if you had any information about when damage occurred,
Yes, that's correct.
and you offered us you don't have no idea, right?
Objection, Your Honor.
I'll allow that.
No, I do not know when the damage occurred.
You were asked whether or not damage existed on that car prior to that day, prior to January 29th, 2022. You remember that question?
Yes.
Did you know there are ring videos of that car from January 28, 2022?
No.
I want to show you some photos and ask you a few questions. If we could have 147C, please. If you could close up. Do you remember what that's a picture of or a photograph of?
Yes.
What is it?
That is a tear that was on the right sleeve of the gray sweatshirt.
The threads coming from the side of that hole?
Yes.
Those threads, could you pull those threads and pull them out by hand if you wanted to?
Can you repeat that question?
If you pulled on those threads, could you pull thread from that hole if you wanted to?
Objection, Your Honor.
I'll allow that.
I don't know. I didn't attempt to pull at them at all.
Did you examine them to see if they were woven or loose, those threads?
Yes.
Okay, and what were they?
They were loose. The fibers had started to separate up from the shirt. Separate and weave. I don't want to say they were separated from the shirt completely. The weave was starting to separate.
If we could have photograph 57. '57, 57. Are those the red cups that you saw?
Yes.
And what color is the fluid inside?
I noted there was red-brown stains inside.
Okay. And do you see that white object, the rag or the paper towel?
Objection, Your Honor. Scope.
Yes, sustained.
Well, you were asked about, you can take that down, you were asked about who had custody of items. You only have custody of items once you receive them, right?
Yes, that's correct.
If somebody had access to that rag and dipped it in those cups and then smeared it on the taillight, and you went and tested, would you potentially be able to find that red liquid on the taillight?
Objection, Your Honor.
It's sustained.
If strands of cloth were pulled from those clothing and placed in the taillight area, would you know when they were placed?
Objection, Your Honor.
Sustained.
When you get to a scene and you examine an area, if you don't see it firsthand, is there any way you can date when items are placed on an object?
I'm sorry, can you ask that one more time, please?
Sure. When you look at an area like a taillight, if you found blood or cloth or another item in that area, would you know when it was placed in that area?
Objection, Your Honor.
I'll allow that.
I think there are really just too many variables to say either way.
And if an item like blood or cloth was placed in that area, is that something you would be looking for in your examination?
In which area?
Say the taillight, for example.
If there was an object placed in the taillight, would I be looking for that? I'd be looking for any item evidence. I'm not specifically looking for anything. I'm just looking for anything that could potentially be evidence.
Thank you. I have no further questions.
Anything further, Mr. Lisson?
Briefly, Your Honor. If we could, Your Honor, have 147C republished. Would it be acceptable to move it along if Ms. Gill, oh, you have it? Okay. If we could have Ms. Gilman, I have just one question, Your Honor. Thank you very much, Ms. Gilman. 147C, I believe it.
Okay, I think you already had it up there.
No, it's this one. Yeah,
Okay.
Exactly. Thank you, Your Honor. Do you recall Mr. Brennan asking you just moments ago a question about this depiction?
Yes.
And to be clear, this is the right sleeve of the gray hoodie, correct?
Yes, that's correct.
You didn't perform any analysis of this area of the right hoodie, did you?
I performed damage analysis on each of those tears on the sleeve.
Right, but you didn't perform an analysis as to the source of that item, what it could be, correct?
Can you rephrase that question, please?
Sure. You didn't do any analysis of what could have caused that hole in the sweatshirt, did you?
No, I did not.
No further questions. Again, thank you for answering my question.
All right, Ms. Hartnett, you are all set.
I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that.
Okay. Do you recall which lawyer asked you the question?
Yes, Mr. Alessi asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you outside?
Thank you.
All right, so Ms. Harnett, I am going to let you step down because questions from both sides are completed.
Okay,
so
thank you.
though. Okay, Mr. Brennan, who is your next witness?
Next witness is Dr. Scordigella.
Okay.
Matt?
Yes.
Thank you.
Why don't I see counsel at sidebar, please?
Grant Smith Ellis here. I'm sorry, I actually laid down during Bob Alessi's cross and almost fell asleep. Literally. I literally laid down and almost fell asleep. I think I'm also just a sad towel. I don't know why. I got hit by a wave of sadness. I just feel, I don't know. Oh, sorry. I wonder if you can hear that in the background. I have the stream on my phone, and then I heard my own voice. So, folks, hold on. Well, yes, I'm still here. My name is Grant Smith Ellis. We are waiting for court to come back into session. The next witness is Dr. Irene Scadorti-Bello, who is the state medical examiner. Sorry, and the state medical examiner will testify about John's traumatic brain injury and the reddening of John's pancreas that led to the finding of a cause of death of traumatic brain injury and hypothermia, because Karen Reed allegedly hit John with her car, causing John to hit the ground and then go incapacitated and then die from hypothermia in a blizzard over the next 4 hours or 5 hours. Yes, yes, ladies and gentlemen, Karen Reed is there. We look to be about to ready to come back into session. Here we go.
Yes.
You told us by the other speaker of the court and jury in the case down here, the truth, the whole truth, and nothing but the truth, so help me God.
I do.
Thank you.
Good morning, Doctor.
Good morning, Aaron.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning. Could you please introduce yourself to the jury?
Good morning. My name is Irene Scadorti-Bello. That's spelled IRINISCORDI-BELLO. I am a medical examiner employed by the Commonwealth of Massachusetts.
How long have you been a medical examiner for?
In the state of Massachusetts since December of 2016. In general, I have been a medical examiner since 2008.
Did you attend medical school?
Yes, I did.
Where did you attend medical school?
I completed medical school in New York City at the Mount Sinai School of Medicine, now known as ICANN School of Medicine.
Did you attend a residency?
Yes, I completed my residency in anatomic pathology at the Mount Sinai Hospital.
Is that what you specialized in during your residency?
Yes.
After your residency, did you go right to the medical examiner's office or did you work anywhere else?
After my residency, I completed a one-year fellowship in forensic pathology that was done at the Office of the Chief Medical Examiner for the City of New York, and then I went to work as a medical examiner.
Is there a certain type of doctor you are? Do you have a particular...
Yes, I am a forensic pathologist.
What are your duties at the medical examiner's office?
My duties and responsibilities at the medical examiner's office include performing examinations and autopsies to determine the cause and manner of death in cases that fall under our jurisdiction.
How many other doctors work with you at the medical examiner's office?
I think there's close to 20 of us. I don't know the exact number.
The medical examiner's office, are you responsible for all counties in Massachusetts as far as doing examinations and autopsies?
No, I work, my primary location is in Westfield, Massachusetts, where one of our satellite offices is, and we cover Worcester County and the entire western part of the state. There's 3 offices in the state, the one in Westfield, the one in Boston, and the office at the Cape, in Cape Cod.
You mentioned that part of what you do is to try to determine manner and cause of death?
Yes.
I use the word autopsy generally without too much detail. Can you describe for the jury what the process is when you're trying to determine the manner and cause of death?
You would like me to explain what an autopsy is?
Please.
An autopsy is a large surgical procedure with 2 main parts. The external examination, which is an examination of the outside of the body, where we document physical characteristics such as hair color, eye color. We document any identifying features such as scars or tattoos, height, weight. And then we also document any signs of disease or any signs of injury on the body. The second part of the autopsy is the internal examination, where we make surgical type incisions on the body and we examine the internal organs of the neck, the chest, the abdomen and the pelvis, as well as the head and the brain. Part of the autopsy procedure, and this depends on the kind of case we're doing an autopsy on, might include other studies such as taking evidence, toxicology, which is done on almost every case, and any additional dissections or any additional steps we might feel we have to take. But that's, in general, what an autopsy is.
Do you ever seek the assistance of any other doctors or professionals that have specialties in your determination in an autopsy about manner and cause of death?
Yes, absolutely. We often, well, like I mentioned before, we perform toxicology on almost all our cases, and those samples are sent to the toxicology state lab. We also have a board-certified neuropathologist and cardiac pathologist in our office, and very often we will consult with them in determining cause and manner of death.
Are cause of death and manner of death the same or 2 different things?
They're 2 completely different things.
Can you explain to us what the difference is between the 2 of them?
Yes. Cause of death refers to the disease or the injury that initiates a sequence of events that ultimately leads to someone's death. So that disease or that injury can be a natural disease such as atherosclerosis or coronary artery disease, or it can be some sort of injury. The manner of death has to do with the circumstances that led to the death. So there are 5 manners of death that we use in our practice. The most common one is actually natural. Natural means that the person's cause of death, the disease that killed them, was due to natural causes. And that would include heart disease, diabetes, cancer. All those are natural processes that take place in the body that lead to death. And so the manner of death is natural. If trauma or an injury, then let me back up. If trauma or an injury is involved, then the manner of death is no longer natural. And therefore, it could be that the trauma was inflicted in an accidental manner, in which case the manner becomes accident. If it was inflicted by another person with the intent to cause harm, then the manner becomes a homicide. And if the trauma, and when I say trauma, I should include both physical and chemical trauma. Chemical when it comes to intoxications due to drugs, etc. If the trauma was self-inflicted, then the manner of death is suicide. So we have natural, accident, homicide, suicide, And then the fifth one is what we call undetermined or could not be determined. That is when the circumstances in a case are not entirely known or clear to us, and the information that we have does not support one manner of death over another. In that case, we classify the manner of death as undetermined.
When you are conducting an autopsy and making an analysis and attempting to reach a conclusion, you said when you looked at in a case, is your case and what you do different than the procedure in a prosecution's case?
Can you repeat the question? I'm not sure I understand.
I can. When you're making your determinations about cause or manner of death, do you have any limitations?
Okay, so the cause of death is something that is determined by the autopsy. That is my opinion or our office opinion as to the disease or injury that led to that person's death. So that is, I don't have any major limitations unless we're dealing with cases where, the body's decomposed and we're not able to do, all the testing necessary. But in most cases, the cause of death depends on my findings during the autopsy. The manner of death, yes, there are limitations because it's circumstance driven. And so the circumstances might not be known to us at the time of the autopsy. They might not be known to us ever. And therefore, while the cause of death is my medical opinion, the manner of death depends on information I get from other people.
Are you always able to reach a conclusion on manner of death?
No, that's why I said that in cases that we cannot, that manner of death is classified as undetermined.
I want to now ask you about whether or not you examined John O'Keefe.
Yes, I did the autopsy on Mr. O'Keefe.
When you examined Mr. O'Keefe, did you work with a team or by yourself?
No, we always work in a team. The team is made up of the medical examiner and a medical examiner's assistant that helps with the actual performance of the autopsy, especially when we examine the head. And then, of course, we work with the toxicology lab and, in this particular case, our neuropathologist.
The medical examiner's office, is that a division of the Massachusetts State Police?
No.
Is it a division of the Norfolk County District Attorney's office?
No.
Is the medical examiner's office independent?
Yes.
When you conduct an autopsy, are representatives of law enforcement or district attorney's office able or allowed to attend an autopsy?
Yes, they're usually allowed to attend the autopsy if they wish.
Is that an uncommon practice?
No, it's not uncommon.
Would you remember when your autopsy of Mr. O'Keefe occurred?
Yes, I performed the autopsy on January 31st of 2022.
If you have notes,
yes, I do.
I think you'll be able to use them, but we'll just want to indicate that you're reading from your notes if that's the case. Thank you.
So you can use your notes, Doctor. Just
thank you.
Thank you, Your Honor. When you began the autopsy of Mr. O'Keefe, do you know who, if any, representatives from the Massachusetts State Police or the Norfolk County District Attorney's Office were present?
I don't remember their names. I do believe there were two individuals, and every person who attends an autopsy has to sign a log, and their names would be logged in our records. I don't remember their names.
What is the role of law enforcement relative to the actual physical autopsy? Do they have any role?
No, they're not part of the autopsy. They don't have a role. Their role is to observe. Sometimes they will ask questions, and based on my findings, they might, go on and do their investigation.
Does your office photograph things of interest, like injuries on the person that you're doing the autopsy on?
Yes, we do.
Is law enforcement allowed to take their own photographs as well?
Yes.
Did you, in fact, memorialize your findings in this case?
I did.
Are there a number of different ways in which you memorialize your findings?
Yes.
I'm sorry.
I took notes, physical notes, pen and paper. There's a report that's issued within 90 days of the completion of the autopsy, and then photographs, digital photographs.
You mentioned a report is due in 90 days. Is that often referred to as an autopsy report?
Yes.
Why 90 days?
That is the standard that is set by the National Association of Medical Examiners. We're part of NAME, and therefore we try to have a finalized report for all our cases within 90 days, because we know that families are waiting for these reports, and therefore we do our best to finish a report within 90 days.
Did you in fact complete a so-called autopsy report in this case?
Yes, I did.
In addition to the autopsy report, well, included in the autopsy report, do you make handwritten notations about locations of injuries?
Yes.
And share with us how's that done. Is there a picture or a graph?
There's a diagram, a body diagram that we use to mark the location of injuries.
May I approach, Your Honor?
Yes.
May I?
Yes.
Do you generally recognize what these documents are?
Yes, these are my diagrams from Mr. O'Keefe's autopsy.
And did you just...
Body diagram, a lot of things have been whited out, but it's the diagram that I would use to make note of any injuries. The second one is a diagram of the face and the skull. I would also use this diagram to make notes as to any injuries on the face. And the third one is a diagram of the inside of the skull, what we call the base of the skull, as well as different views of the brain itself. Again, I would make notes to point out different injuries.
Thank you. As you are noting injuries in your autopsy report, these diagrams, they start off blank?
They start off blank, and then they're filled out as we go along.
And you fill out all the details you find important in your report?
Correct.
For reference, and to assist us, I have some blank diagrams that I may ask you to point out things on the blank diagram for us.
Okay.
And Your Honor, I'd ask permission. I've spoken to defense to use these simply as a chalk.
Sure.
No objection, Your Honor.
Before you begin an autopsy, do you seek any medical records if available?
Yes. When a case is called into our office, depending on the time and the day that it is called in, our intake department, who are the people initially on the phone taking the information, will start asking for both medical records as well as police reports. So in the morning when we start the autopsy, it's possible that we have some records. Sometimes if a decedent is brought to us from the hospital, there might be some records that come along with the body. But to answer your question, yes, we always ask for medical records, what we call PCP records, which are primary care physician records, any records from a hospital where the decedent may have been, and investigative reports, police reports.
Do you recall whether you had access to John O'Keefe's medical records from Good Samaritan Hospital?
I did have access, yes, in the day, I believe the day of and the following day.
May I approach, Your Honor?
Yes.
Subject to any later reactions, I would move the Good Samaritan medical records.
No objection, Your Honor.
Exhibit 155. Thank you.
This time I would move for identification all photos of Mr. O'Keefe's injuries at Good Samaritan Hospital. This is for identification.
Okay. Exhibit JJ for ID.
Further, this time I'd move for identification all OCME, Office of Medical Examiner photos.
Okay. Exhibit KK for ID.
Thank you. Your Honor, at this time I'd move all CSSS 5-copy photos for identification.
Can I just have an understanding of the acronym?
With the court's permission, Ms. Gilman, if you could put up the diagram, full body. If you could enlarge that a little more. Thank you very much. Could you explain this to us?
Yes, this is the diagram that we use during every autopsy. As you can see, we note the name of the decedent. Every case has its own number. In this case, it was 22-1697. And then we take note of, as I mentioned, during the external examination, physical characteristics such as hair, eyes, teeth. And then on this diagram, we would note any scars we see on the body, any tattoos we see on the body, any injuries we see on the body, and any therapeutic interventions. Those would be things that are sometimes done either by emergency medical personnel or at the hospital. Everything would be noted on this diagram.
Now, if you could take us through, I'm going to ask you, we'll go body part by body part, if that's okay. I'm going to ask you to begin with Mr. O'Keefe's face, the front of his face. And if you could enlarge that, Ms. Gilman. Thank you very much. Did you notice any injuries on Mr. O'Keefe's face? And if so, could you, I think there's a pointer available for you, Doctor? If you could point out on the diagram what you observed.
So on the diagram, well, first of all, there was medical intervention on Mr. O'Keefe that included an endotracheal tube that had been placed to help him breathe. But once all the intervention, all the medical devices were removed, I observed on his right upper eyelid a 1 centimeter laceration. So as we're looking at the diagram, this is the right side and this is the left side. So on his right eyelid, there was a small laceration. I also observed abrasions on the anterior and the left aspect of the nose. So the nose would be here on the front and the left aspect. Abrasions are scrapes. Lacerations are tears in the skin. I should probably explain that. Then there was some bleeding and some swelling of the eyelids of both eyes.
Does that complete your analysis?
For the front of the face, correct, yes.
May I approach, Your Honor?
Yes.
Doctor, I'm showing you a photograph. Do you recognize what's in that photograph?
Yes, this is a photograph of Mr. O'Keefe's face.
Does that photograph depict any of the observations or injuries you made that you just described to the jury?
Yes, it shows the small laceration that I noted during the autopsy on the right eyelid. You can see some of the swelling and some of the bleeding over his eyelids, and that's pretty much all I can see because it's a side view.
Is there an apparatus?
There is what we call an endotracheal tube, as well as a C collar or a C stabilization collar. That's something that would have been placed on him by medical personnel.
All right, move this into evidence. I'd ask for instruction.
Okay.
No objection, Your Honor.
All right. So, folks, during the testimony of Dr. Scordi-Bello, photos will be introduced to you. They're photographs of John O'Keefe that Dr. Scordi-Bello from the autopsy. So you'll have them in the jury room with you. I'll put them in an envelope, or I'll ask that they be put in an envelope. So if you don't want to look at them now, you don't have to. At some point, we'd ask that you make sure you look at it. These photos are not pleasant, and you may find that they're graphic. But what's important for you to know is that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence. And
The last exhibit is Exhibit 156.
thank you.
Ms. Gilman, could you show the jury? And doctor, can you point out the injuries you were describing by using the diagram, or when you were using the diagram?
So the laceration, the small laceration that I previously described would be here on the right upper eyelid of Mr. O'Keefe. You can see some discoloration that's bleeding under his eyelid and what I would describe as swelling. The endotracheal tube and the neck collar are also present here, and the other injury which I noted was on the front and left side of his nose, which you cannot see here because this is looking at the right side of his face.
Okay. Take that down, please. You mentioned that there was something about his eyes that was notable?
Yes, there was bleeding or hemorrhage, as we call it, on the eyelids, as well as swelling.
I'm going to ask you more detail about that later, but was that observation important in your ultimate diagnosis or conclusions? Yes. May I approach, Your Honor?
Yes.
I'm showing you another photograph. Do you recognize that?
Yes, this is another picture showing Mr. O'Keefe's face. Again, the medical intervention is present, and you can see more clearly now the discoloration on the upper eyelids.
Is this vantage point helpful for your ultimate conclusions and diagnosis?
Yes.
Your Honor, move this into evidence.
No objection, Your Honor.
Exhibit 157.
With the court's permission, I'd like to show this to the jury.
Yes.
P645, please. Doctor, could you point out what was significant regarding Mr. O'Keefe's eye area?
So I noted that there was discoloration, that's bleeding, that's blood, that's under those eyelids. The eyelids appear puffy, that's what we call edema or swelling. And then also there were two abrasions, two scratches on Mr. O'Keefe's nose. You can see one here and then the other one on the more front part of his nose.
Okay, could you take that down, please? If we could move down a bit to the chest and stomach area, did you make any observations about this area, Dr. Scorbello?
The observations that I made on the chest were that there was, as I mentioned before, there were defibrillator pads on the body, and there was an abrasion that's very commonly seen in people who have undergone resuscitation. Internally, that abrasion and the whole resuscitation apparatus was associated with some anterior rib fractures, which are also seen in cases of resuscitation, but I didn't make any other notes in terms of trauma on the chest or abdomen.
Okay. I'd like to move to the arms and the hands. If we could come down just a little bit. Let's begin with Mr. O'Keefe's hand or hands. Did you make any observations regarding Mr. O'Keefe's hand or hands?
Yes. On his upper right arm, I noted that he had a superficial abrasion. So it would have been, you can
we move that down a little bit?
Move it down a little bit. Yeah, thank you. You seem to be doing a very good job. Okay, somehow doesn't want to
Sorry
work.
if that's not working well.
It's projecting here, but not on the actual picture.
Okay. There may be a second pointer.
I can do it here.
Okay, great.
Yeah. So on the right upper medial arm, that would be the inner side of his arm, there was a superficial abrasion. Again, that's a scrape. Then on his right posterior arm and forearm, so not exactly on this aspect of the arm, but on the back side of the arm, which would be in the back of the diagram, there were multiple abrasions, which I described as ranging from 2 to 3 millimeters and up to 7 centimeters. Then, if you could move the diagram down, please. Again, there is a back to this diagram. I don't know if you could put that on the screen. There we go. So this is now the right side, and this is the left. I noted that there were 2 bruises on the back of his right hand. Also a faint scratch on the back of his left hand. And then moving down to the lower extremities or the legs, if you could please show the front, there was a small abrasion, a small scrape on the side of his right knee.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a photograph. Do you recognize it from that photograph?
Yes.
What is it?
This is the back of Mr. O'Keefe's right hand, I believe.
Is that a fair and accurate depiction of how his hand appeared when you examined him?
Yes.
Will this is evidence, please?
No objection, Your Honor.
Okay.
Exhibit 158.
With the court's permission, I'd show P647 to the jury. And could you explain, you said there were 2 bruises. Could you point those out for us?
Yes. There's one here and one here.
Did you attempt to assess those, determine whether you could conclude or opine on a cause of those?
No, I did not. Well, I take that back. I'm sorry. So this particular one has two small little pinpoint defects in the middle, which we sometimes see when emergency personnel tries to get access to a vein for fluids, for intravenous fluids. So, but I did not put that in my report. I just described it as a contusion.
Is it common to see that type of coloration where medical personnel put intravenous or other types of support into somebody's hand?
Yes, it's very common for the skin to bruise when someone tries to get access to a blood vessel.
The other coloration that is unrelated to those two small points, would you have a description of what those are?
No.
I'd also like to show you exhibit number 1. Exhibit number 1, please. Thank you. You use the word superficial. What does that mean?
Superficial means that the abrasion is on the superficial layers of the skin, usually the epidermis and sometimes the dermis, but there's no penetration of the skin.
When you're assessing to determine whether there's any penetration, do you measure the length of the wound or the abrasion?
Penetration would be measuring the depth. If there was actual penetration, I would have to measure how deep into the skin. For example, when we assess stab wounds, we have to measure the depth of the wound. In this particular case, you can see that these are scrapes or scratches, and there's no exposed underlying fat or muscle. And therefore, to answer your question, I measured their length and gave a range, but I did not measure their depth.
As a routine practice during an autopsy, doctor, if there was penetration or depth, would you, as a routine, measure that?
I would make a note of it.
Are there any such notes in any of your autopsy findings or reports about depth?
No, I did not make a note on the depth of these ones.
Do you have an opinion to a reasonable degree of medical certainty as to how those superficial abrasions occurred?
I do not.
And I asked you about the hand, which we just saw, and I should ask you the same question. Do you have an opinion to a reasonable degree of medical certainty how that coloration, aside from the medical intervention, do you have an opinion to a reasonable degree of medical certainty how the other discoloration happened on Mr. O'Keefe's hand?
I can state to a reasonable degree of medical certainty that that's a bruise, a contusion, but I cannot tell you how it occurred.
And to summarize finally what we've been through so far, regarding the scrape on Mr. O'Keefe's right eye, can you provide an opinion to a reasonable degree of medical certainty how that scrape occurred?
No, I cannot.
You mentioned for us that when you looked at Mr. O'Keefe's legs, you observed bruising on his, or a small scratch on his right knee.
Correct.
I don't want to summarize it. Can you describe that more specifically? Thank you.
Yes, I described it as a 0.5 centimeter abrasion on the right lateral knee.
Did you see any marks or abrasions on his left knee?
No, I did not.
Was the mark, scratch on Mr. O'Keefe's right knee on the inside or the outside of the knee?
It was on the lateral aspect, which would be the outside.
Thank you. May I approach?
Yes.
Doctor, I'm handing you a photograph. Do you recognize what's in that photograph?
Yes.
What is it?
This is a picture of Mr. O'Keefe's lower extremities, his legs.
Is it a fair, accurate depiction of how his knee appeared when you did the autopsy?
Yes.
All right, we'll get to the evidence, please.
No objection, Your Honor.
Okay.
159.
Thank you.
With the court's permission, I'd like to show the jury 9467.
Yes.
You used the word lateral and you talked about abrasion or a scrape. Could you look at this photograph and could we enlarge it, Ms. Gilman, and could you point out to the jury and explain what it is that you saw?
Yes, you can see the abrasion here with a little bit of adjacent discoloration, but this is what I was describing.
If you could zoom back out, please. And you didn't see any similar type bruising or abrasions on the left knee?
No.
During your autopsy, did you notice any injuries internally to Mr. O'Keefe's rib area?
Yes, I did note that there were rib fractures on the anterior, that would be the front, of his fourth and fifth ribs.
And so would that be his left or right side?
It would be both the right and the left, and it would be the part of the rib that is closer to the sternum.
Is there a number of ribs that had fractures, or are they connected as one?
The fourth and the fifth, both on the right and the left, close to the sternum.
Have you, in your experience, seen ribs fractured during first aid or medical intervention?
Very often, yes.
Given your experience and your study of Mr. O'Keefe's body, do you have an opinion to a reasonable degree of medical certainty how those rib fractures were obtained?
I believe those rib fractures were due to resuscitation.
And you have that opinion to a reasonable degree of medical certainty?
Yes.
I'd like to show you a different diagram, one of the head area. If we could enlarge the bottom right. Thank you. Using that diagram, could you assist us, doctor, and explain to us any observations you made about the back of John O'Keefe's head?
Yes. The main observation was a laceration that is a skin tear on the back of Mr. O'Keefe's head to the right of midline. So this would be the midline. The laceration was somewhere here, is what we call the right occipital area, and associated with that there was an abrasion over it that would have been here. So this was what we call a compound injury, an abraded laceration.
We'll turn in a few moments to your autopsy observations about the inside of Mr. O'Keefe's skull. But first I want to just show you a photograph relative to what you described to us. May I approach, Your Honor?
Yes.
Showing you a photograph. Do you recognize what's in that photograph?
Yes, this is a picture taken at the time of autopsy. This is the back of Mr. O'Keefe's head. The hair has been shaved off so that the injury can be clearly photographed, and it's a laceration with an associated abrasion.
Thank you. Your Honor, move this into evidence.
Okay.
No objection, Your Honor.
Thank you.
Exhibit 160.
When you examine the laceration, do you measure it?
Yes,
And did you measure it in this case?
I did measure it.
How long was the laceration?
I measured it as 2.5 centimeters, which is close to an inch.
Do you examine a person's body before you begin to intrude? Do you examine the outside of a person's body first, or is there a certain procedure or order?
Yes, the external examination is done first, and the internal examination is done second.
I want to show you that photograph that you just recognized, and I would like you to explain what you see to the jury. Ms. Gilman, with your assistance, thank you.
This is the laceration that I noted, and this is the scrape that's associated with it.
Take that down, please. After you make observations, what are your next steps in an autopsy?
The internal examination, after the external is performed and pictures are taken, then we proceed with the internal examination of both the, as I mentioned before, the torso, the body, as well as the head.
I'd like you to take us through the internal examination. Did you have a chance to look internally behind the laceration you saw on the back of Mr. O'Keefe's head?
Yes.
And when you did that, could you describe for us what you saw?
Yes. The way we examine the head is we make an incision with a scalpel behind the ear from one side to the other. That allows us to reflect or pull back the scalp, and that will expose the skull underneath. We do this carefully so that we don't disfigure clearly the face. And when we reflected and when we pulled back the scalp, I noted that there was blood, what we call hemorrhage, under the laceration or associated with the laceration on the back of the right head. And then furthermore, there were skull fractures associated with that laceration, abrasion on the right side of the head.
Were the skull fractures in the same or different area?
The skull fractures were in multiple areas of the skull, what we call the base of the skull. Imagine the base of the skull is sort of a bowl, and the brain sits on top or in the bowl. When the brain is removed, you can have a very good view of the base of the skull. So when the brain was removed and we were able to look at the base of the skull, I noted that there were multiple fractures that appeared to be originating from the area of the laceration, or what would correspond to the area of the laceration.
When you made your examination of the fractures in the skull, did that lead you to your opinion, or was there more you needed to look at before you came to an opinion about the cause of death?
Well, that was part of the findings that led to my opinion. But yes, I removed the brain, and as is our protocol, I saved the brain in a special solution called formalin that allows the brain to become a little harder so that our neuropathologist in Boston could go ahead and examine it. Because when I did look at the brain, I noted that there were injuries. There was bleeding on top of the brain. And therefore, I saved it. The brain ultimately went to our Boston office, and our neuropathologist, Dr. Stonebridge, examined it and issued a report.
Did you engage in any type of analysis on your own about any injury to Mr. O'Keefe's brain?
I noted the kind of injuries I could see superficially on the brain, and I have looked at the brain after it was fixed and pictures of it, but I did not issue a report on it. The whole point was for our neuropathologist to examine it closely and issue a more detailed report.
I have a few more photos. Would now be an appropriate time for a break, Your Honor?
Yes.
Jurors, morning recess.
Take 15 or 20 minutes, okay?
Morning recess. Morning recess. My name's Graham Smith. That was agonizing. Yes, ladies and gentlemen, we are in morning recess in the John O'Keefe and Karen Reed trial. Allow me to mute the courtroom sound. I will come back on the screen. We just saw the lead up to what we know is going to be devastating testimony about John O'Keefe's injuries to his knee, which Karen Reed herself said in a clip, did I clip him in the knee? Ladies and gentlemen, and then into the media. And then, ladies and gentlemen, we heard testimony about John's head injuries. And we're going to hear testimony about the reddening of John's pancreas. John left to die alone on a lawn, allegedly after being struck by Karen's car, which backed up while Karen had a BAC of 0.14 to 0.28, which is 2 to 4 times the legal limit, after Karen admitted to consuming 9 drinks. Ladies and gentlemen, Karen backed up that car to 24.2 miles an hour at around 12:32 a.m. and 16 seconds exactly on January 29, 2022. And ladies and gentlemen, when Karen Reed backed up that car, at the moment of alleged impact with John's body, it would reduce to 23.7 miles an hour in a millisecond, with a 4.7 degree steering wheel correction to the right. Oh, ladies and gentlemen, I am a fluffy-headed towel. 1 second. I had to be a fluffy-headed towel in court yesterday. I don't have to be a fluffy-headed towel with us today. Ladies and gentlemen, that was just absolutely agonizing. And by the way, Sue O'Connell has rubbed arms with Karen's parents outside of court. Please don't, when you're reading her, just remember she's trying to help Karen. So anything you read there is likely just trying to help Karen. There's no objectivity. John DePetro is the only person in that courtroom that I would trust to be, and David Bienick and Christina Rex and Abby Patkin. Those are the people that I would be reading. And Penny, if she's in there, and Katie Benoit. Those are the people I would be reading if you want to know what's actually happening from in the courtroom. No, absolutely not. I would not be reading Sue O'Connell. No, listen, anyone, I have notes, and I watched all 18 jurors taking notes multiple times yesterday. Maybe one juror takes notes less than some of the others, but it cannot be said that there's any jurors who have at any point never taken a note, because I saw all 18 of them. Yeah, in my opinion, that's true. But anyway, we are going to be back in session in just 15 minutes. Let me end this clip. My name's Grant Smith Ellis. This has been heartbreaking testimony about John O'Keefe's injuries, and there's more to come. We'll be back into session at 11:15 a.m. youtube.com/@GrantSmithEllis. All right, I'm a towel. Folks, we're back. This has been absolutely devastating. Yeah, no, Mandy Strong, I saw that juror. It's not... I talked about it yesterday. I wouldn't call it a weird look. His mannerisms are weird as a person, but he's not showing like deference. Like, he just makes weird facial expressions. I don't know if he's trolling the jury or the media or what, but it's not it makes, in context, it's not odd. It's just it's an odd like person. Yeah, exactly. Sue is in my opinion, she does. Sema, let me show you this video, and then you tell me whether you think this is very clear. And I've never seen Sue do this with John O'Keefe's family. Okay, and I don't think I'm ever going to see Sue O'Connell do this with John O'Keefe's family. But while we're on recess until about 11:15, let us take a look, folks. Let us take a look at Sue O'Connell, okay? Shameful Sue, as I call her. And you can say all you want that, oh, Grant, show me her rubbing arms with Karen Reed's parents. Okay. Challenge accepted. One second. Let me bring your comments back up. Now let me just bring this down. Okay, so we don't need our Chewbacca. We'll talk more about Chewbacca and David Yannetti spaghetti later. Let's get rid of that. Okay, hold on. Okay, now let's get rid of the fan. We don't need to look at the fan. There we go. Now what's this? Why, yes, that is Sue O'Connell rubbing hands with Karen Reed on the back. Now, listen, I've said hello to Miss Reed, I've said hello to Miss Reed, so. Ed Jobs, I don't know what happened with Stephen Scanlon. I think that he approached the Reed defense. They tried to give him a $1,500 check. He wouldn't take it. His story was probably nonsense. I agree. I think it was nonsense from the beginning, and so it went nowhere. A meeting of Karens, says the inside man who is now an honorary towel. If you're just tuning in, folks, we are on recess. We are on recess until 11:15 a.m. I am a towel. My name is Grant Smith Ellis. I am a towel. I appreciate you tuning in during this difficult day. Please remember that this is a public information service, and you can support Towel Stream by liking or subscribing. Also, did you know we have towel ads now? I was watching on my phone today, and ads started running. Folks, we have towel ads. I don't really know what that means. I don't really know how to do anything about it. I clicked the button to turn them on, and then it said, do you want to show a lot of ads or a little ads? And I said, don't do either of those. Show a customized, balanced amount of ads that doesn't interrupt the viewing process. So I don't exactly know what it's supposed to do, but I let the whole YouTube thing figure it out, and I think it's wonderful if you want to turn your ad blocker off. But it is heartbreaking to listen to this, and I just... It's very overwhelming. We're in a recess, so let's compose ourselves. Let's get a little bit put back together, and then let's have. Here is the testimony from. Here's the testimony leading up to morning. We left off right before learning more about John's head injuries, and we will be back in session at 11:15 a.m. Eastern. Okay, ladies and gentlemen, this is just heartbreaking. It just breaks my heart in so many ways. Oh goodness, to have to know that John's family has to witness these moments. Oh, ladies and gentlemen, let's keep them in our prayers. Let's keep the O'Keefe family in our prayers during these horrifying moments. Nothing can prepare any human being for having to talk about autopsy photos. Oh, folks, like there was stuff we heard. I don't even want to repeat it. It was. I know that this is a trial, so part of what comes with this process is people have to be aware that you have to present evidence. Even Judge Cannoni said it. Some of this evidence might be very hard for you jurors to look at. We understand if you don't want to stare at these pictures now, but you must look at it. It's the evidence in the case, in some ways, although we didn't see the graphic stuff, thankfully, you do have to think about the evidence as the jury is thinking about the evidence, and they are going to be shown this. And obviously it's hard. It is impacting me, okay, as a towel. It's very hard to listen to. I'm replaying in my brain now some of the quotes I was just listening to in court. I mean, oh my God. Some of the things that were being said right there, they were bringing tears to my eyes. Like, I guess you have to be a very strong-willed person. We need people in this profession, in the profession of medical examiners, who can be like, okay, so I received a person's body after a very sad incident. This is what the injuries were. I documented the process, and then I did an autopsy, and then I did this. But my word, when you hear an autopsy described, folks, it's I mean, you're literally saying, you're literally saying like I removed the brain and like I had to send it for examination, and we end up finding that John's brain suffered a traumatic brain injury, like it banged off the skull, probably from Karen's car or the ground, and then the high reddening of John's pancreas. John's phone data, of course, showed he never moved from the spot on the lawn where he was allegedly hit by Karen and left at 12:32 a.m. in 16 seconds. Never moved. John's phone never moved. Someone asked, Sema asked how I was doing. I struggled yesterday physically, and then today I felt so tired, and I only had M&Ms this morning. I need to go eat later after this morning recess. I'm going to let you all continue to watch this. I'm going to watch for a little bit while we get the conclusions, which are going to be very sad. Then I'm sure Alessi will do his cross. But ladies and gentlemen, as a reminder, this is Towel Stream. We talk. We have the towel friends. Even in these hard moments, we're here for each other. And it's so hard, but we do need people who can be medical examiners. It's so sad to think about, but the foundation of the criminal trial process is you have to actually build the evidence, and the evidence includes, unfortunately, in a death or homicide or murder case, or a manslaughter case, a body. And this is what it's not an option. The foundation of the evidentiary process is the introduction of this evidence, but it is very sad. Yeah, it's very sad. Thank you, Linda. I'm gonna listen. I know. So I just want to say a lot of folks have been supporting Towel Stream. Don't think your support does not go. It's not underappreciated. It's just the way YouTube does support. Like, we have to keep, like, it like collects it all, and then eventually you get it. So I'm just trying to, we're going to get there in a few days, I'm sure, but for now, let's focus on helping Little Towel. I also had a lot of things to get caught up on last month. So if you've been thinking about supporting Little Towel, if you like Towel Stream, if you like the Karen Cam, I actually lose money running the production software to do this. I don't mind. I do not mind. But you could, the things are, I need to go get lunch after this, and I need to, just Towel has to recompose. People have been sending a lot of help. I got somewhat caught up on last month, but then I use these services that help me with my credit. They'll like charge you like a $9 fee and lend you $200 for a month, and then you pay it back. But I didn't realize one of them was yesterday, so I have to just. Anyway, people have been very kind. Don't donate if it would put you in a difficult position. But this is a public information service, and public information services don't. I mean, now we have like YouTube ads, but I don't run any ads. There's no sponsors, although I will take 7-Eleven as a sponsor if they want me to sell their pizza, because I really like 7-Eleven pizza. It only costs $1.50. But Murder by Maestro, the wonderful, amazing Super Towel himself, who speaks binary and is 24 years old. Murder by Maestro gave these amazing links, and if you do, please, again, do not donate if it would put you in a tough position. Don't donate if you have family members or friends or people who are in need of your support. That would make Little Towel sad. Oh, Luisa Ramirez, God bless you, dear friend. But I'm going to send along, and I also want to so I'm going to special thank you to Luisa Ramirez for the wonderful super sticker. I love the dancing hippo. Towel loves nothing more than dancing hippos, I assure you. But I also want to send a special thank you to honorary Towel spouse, although Towel's afraid of commitment, Mandy Strong, for sending a very kind Zelle over earlier. Little Towel is doing his absolute very best, I promise you all. I don't understand why my brain can keep track of analytical concepts, but is so weak on emotional intelligence and so weak on executive function. So I trip a lot, I drop things, I don't know how to manage money, I don't know how to manage my day-to-day life, and I don't really understand human interaction. But my word, I have a good memory, and I know how to talk about the courts. Oh, yes, ladies and gentlemen. And by the way, I did finally get caught up on the YouTube chat. So in about a second, you should be seeing Murder by Maestro's one of, oh no. Okay, so Wicked Uma. this is please, thank you for the feedback. This is the first time that I set this up, because there's some weird, like when you do a live stream at a certain point, they ask you about how you want to do these ads. I have no control right now, but I'm glad you're giving me feedback, because it gave me 3 options, and one of the options was tailored for the viewing experience. It was not designed to run a lot of ads. Trust me, there were options where you could just run a lot of ads. I was not going to do that. My goal was to tailor the ads to breaks in the viewing experience, so I clicked an option that runs a lower amount of ads but tailors it in the context of normal breaks. If you are getting more than like 1 or 2 ads an hour, please tell me, because yes, WD-40, I'm going to try to do that tomorrow, because I have to go to my my father's services this weekend, so yes, I have to do that. Oh, God bless you, Luisa Ramirez. I saw your chat pop up again as I was in the back scroll. The buffer zone update, Drew drops the buffer zone is staying intact. You can check out the motion on my feed. It's not really much of an update. It's just Judge Cannone added a clause of the buffer zone that has to do with the intent requirement. The buffer zone is the exact same as it was before, friends. It is the exact same as it was before. I just want to remind folks about that. And then also, yes, the notes from the niece's testimony were very intense. I want to show you folks, so where you can find the buffer zone update is on this post right here on my feed, okay? And all it does is Judge Cannone issued a supplement to the buffer zone. It stays in place. It's exactly the same. What had happened procedurally at the federal court was Mark Randazzo, one of these lawyers for the FKR people, challenged the buffer zone. He motioned the federal court for a preliminary injunction. It was denied. That denial was appealed up to the First Circuit Federal Court of Appeals. The Federal Circuit Court of Appeals First Circuit did not overturn the denial, but they remanded it. They vacated it and remanded it for further proceedings. Part of the further proceedings was under a case called Cox v. Louisiana from 1962 or 63. You really have to have a mens rea requirement when you have a buffer zone. So the First Circuit Court of Appeals said, before the lower federal court reconsiders the motion for a preliminary injunction, during which time the buffer zone stays in place exactly as it is, Judge Cannone or the state should update their buffer zone. So the buffer zone got updated, but it didn't change anything. It's the exact same parameters. It functions the same way, but there's a mens rea requirement now, and you can appeal to a justice of the Superior Court in the context of an enforcement action. Now, ladies and gentlemen, there you go. It's the same buffer zone. It will be staying in place, and that's the procedural posture of it all. But yes, folks, that is the update. You can see it right there. It's a short update to the order, and it's I can't find an update as to Turtle Boy yet. He was in Stoughton District Court, but remember, folks, he was on Stoughton District Court to be bound over. To be bound over, folks, on a charge. That was the charge out of Stoughton District Court that was bound over to Norfolk Superior Court the other day. So normally what happens is you just go into court and the prosecutor says, we're binding this over to Superior Court in Norfolk County. Well, it is Norfolk County, but we're binding this over to Superior Court, and then you get sent up to Superior Court. You see what I'm saying, ladies and gentlemen? You see what I'm saying? I'm being a little towel. So, therefore, we'll check the TB docket, but I know what happened. I don't need to go. I don't even need an update. I'll tell you that it got bound over to Superior Court, okay? That's what happens in these kind of things. Now, one other thing we can do is we can go to Daily List, Stoughton District Court, and we're coming back into session in just 5 minutes here, ladies and gentlemen, and I am checking my phone, because sometimes people are like, Grant, you didn't see it? Well, if you send a support, I will see it today. But I'm going to Stoughton District Court, and then I am checking, and I need to get the arraignment session number. I got it. Okay, let's check. I don't think, maybe there'll be an update. The dockets don't always update in district court right away. The clerk's got to take them back and they got to update them. It's not like the Superior Court. All right, ladies and gentlemen, what do we see? Nothing. No update yet, but the court was held at 9 a.m. this morning for Aidan Kearney, but this was the one that got bound over, as I said, so we're going to be keeping an eye on that. Now let's check the Norfolk County docket, ladies and gentlemen. Let's check the Superior Court docket. Let's see. We'll check the indictment that came down yesterday, and we'll see if there's any moving papers or anything else that happened to come down related to that indictment, or if anything else has happened related to indictments in Norfolk County. So Little Towel pulls up the records, and what do we see? So we see the Kearney one. Paul Lawrence Byrne. No, doesn't look like there's anything else. David, no, that doesn't. So Aiden Kearney's indictment, the new one. Go ahead and pull that up. And we just see the indictments return. We don't have an arraignment date. Doesn't look like there's any movement on either docket. All right, so that's what we got, folks, there. That's what we got. And Hank Brennan does have Turtle Boy's phones, and obviously we don't know what's going on with Aiden Kearney posting pictures of the kids. But listen, this wasn't pictures posted of the kids shared with permission, or like shared with the faces blurred out. Karen sent these pictures in text from KF to Aiden. That's wrong. She has a no contact order with them. Like, that's wrong. So I don't like it. Whether, like, Sema, I have gotten a picture of John with his niece and nephew at a ball game. I chose to blur their faces out. Like, it was shared. Okay, there was no problem with sharing it. No one's saying you can't share a picture showing that John loved his kids, his adopted double orphan niece and nephew who are now thrice orphaned, allegedly because of Karen's actions when she drove drunk and struck John with her car around 12:32 a.m. and 16 seconds on January 29, 2022, and then left John for dead with a head injury in a blizzard on a lawn where his phone data showed he never moved from that moment until after 6 a.m. when he was found. Ladies and gentlemen, it's so sad because Aiden Kearney was not publishing those photos because he wanted to show John O'Keefe or anyone was a good, loving person to KF and JF. It was that KF testified in a way that hurt Karen, and then immediately those photos came out as punishment for KF, quote, flipping on Karen, although all KF was doing was telling the truth. And you know what? I hope KF looked at that. I don't know KF, but I hope KF looked at those pictures from Aiden, and if her immediate reaction was, oh, that was how he punished me, that's how Karen wanted to punish me, I hope she was like, wow, that's like, how desperate are they? You know, that's what they have to do. They have to publish pictures of children, not in a supportive way. Sema, it's about intent. You think folks sharing those pictures, are doing that? No, it's about intent. And so the intent, in my opinion, of sharing those pictures was malicious. And therefore, you have a situation where Aiden Kearney could very well, he's putting himself, I think the judge called it, on thin ice. And I think he continues to do that. He has a bad habit of putting himself on thin ice. But yes, my name is Grant Smith Ellis. Thank you to everyone who has been so kind to each other and to Little Towel on today's stream. We are marching forward, Little Towels. We should be coming back into court any session. We're waiting for the court to come back into session. We're going to bring up the fan. I know you all love the fan, but I have good news. We don't have to watch the fan because, look, David Yannetti pulled out his most important trick yet, according to reporter Towel Christina. Yes, ladies and gentlemen, David Yannetti unleashed the spaghetti, trapped, ladies and gentlemen, Chewbacca, who's actually a dog named Chloe in a wig, and then the Stay Puft Marshmallow Man, who is actually Chewie's lawyer, and I want to prove this to you all. Look at this, ladies and gentlemen. I have photographic evidence, and I'm going to have to move it up for you on the screen. I have photographic evidence, folks, that Chewbacca and the Stay Puft Marshmallow Man have been working together. Now, do you see what I'm saying? Ladies and gentlemen, oh, no, we're not coming into session. But do you see what I'm saying, ladies and gentlemen? Look at that lawyered up Chewbacca. Now, they switched sides, and eventually Stay Puft Marshmallow Man became the lawyer and Chewbacca became the witness. But ladies and gentlemen, these folks, you are talking about a dog named Chloe in a wig who's hiding in a Chewbacca costume, and the Stay Puft Marshmallow Man. They do not come to play, folks. When they show up, now, yes, I realize that Chewbacca eventually got so distracted. Sorry, I brought up hold on, it's going to shift out the images here. I realized that Chewbacca got so distracted by, and we're going to see it in a second here. And I realize that most Chewbacca's, if you just show up, oh, Val, you figured it out. God bless you, dear friend. Ed Jobs, Jill D, Hot Coffee Chats, Jezebel Star, look, oh, hold on, Black Star, look, Backstar, look at the membership parade. We were waiting for a membership parade, Val. Well, not just me, but you, Val, and you came through, and look at it. Look at the towel friends who now will be raining down towel emojis as if there were no tomorrow. Yes, towel friends, make sure to say thank you to Val for her wonderful support of Towel Channel. Follow Val as well on social media. Val is an excellent and insightful commentator. Yes, ladies and gentlemen, the towel membership parade that we waited for, it has finally landed. You have your emojis. If you got gifted a membership by Val, you now have unlocked your towel emojis. Enjoy them. Make them rain down upon the towel faithful, the washcloths, the towelettes, the hemp towels, the beach towels, the soap dispensers, the flannels, the Sheffield flannels, the microfiber towels, whatever kind of towel you are welcome among this towel fold, and we appreciate you being here. I know Ed Jobs has waited forever for their towel emojis. I know it is a glorious day. Oh, ladies and gentlemen, it is a glorious day. Use your emojis wisely, ladies and gentlemen. You do not want to end up like David Yannetti having to put spaghetti on the table to distract a dog named Chloe who's actually in a Chewbacca costume by way of a wig and being defended by the Stay Puft Marshmallow Man, who is very, very perplexed. I don't even know what to tell you, ladies and gentlemen. Look at that Stay Puft Marshmallow Man. He's like, what the hell have I found myself doing? Oh, Modelo Macy has made it rain towel emojis. Oh, we must have towel emojis, Val. We must have the towel emojis. I agree. Towel emojis make this somewhat more tolerable, ladies and gentlemen. Oh, Val is truly a super towel who is appreciated by towels far and wide. Oh, look at the flood of towel emojis. They continue to rain down upon us. Oh, we even are starting to see some Chewbacca emojis. Oh, what has happened? Oh, this is what you tune in for. Towel is just so overwhelmed by what he's seen. He turns into a horse racing announcer and starts talking about Chewbacca and the Stay Puft Marshmallow Man as a coping device. And some people are like, Grant, I was interested at points, but then you talk about this. Well, do you know how hard this is? It's agonizing to listen to, not just for us, but to the O'Keefe family, certainly. Miss Peggy O'Keefe, John's mom, is not even in court because of how agonizing this is. And if we need moments of levity to help us and help our souls get through this moment, then God bless us, that's what we will do. And if it comes at David Yannetti's expense, and if it involves spaghetti in a joking manner, not in an insulting manner, and if it involves the Stay Puft Marshmallow Man and Chewbacca, then by God, friends, towel friends, and the like, that is what we are going to do. And no one is going to say, Grant, I enjoy your analysis about all the timelines of the case, but I don't want to talk about Chewbacca. Not that anyone did that. But no, you get both. The price you pay for this public information service is you see wonderful towel friends chatting with each other, and you get to listen to moments of levity. Oh, dear God, the humanity. Yes, absolutely. Christina Towell is a reporter, and Christina Towell collects all these images. Now, ladies and gentlemen, I might even have one more image while we're waiting for court to come back into session. I make no promises or provide no warranties, and I disclaim all liability in the world of towels and the normal human world. I'm not really sure if that even happens, if just because I'm saying I'm going to put a picture up. But I disclaim anyway. I disclaim, ladies and gentlemen. I do, therefore, thus disclaim. Look, folks, I have a real-time reaction shot from Christina Towell of what it was like when jurors were listening to the devastating testimony about Karen Reed yesterday. Look at this, folks. Have you ever seen a more shocked scene? Oh, Boss Texas Chick, welcome to Towel Stream. You became a Towel member at the perfect moment. Your name, becoming a Towel fan, is right above the shock Chewbacca and the Stay Puft Marshmallow Man. I tell you, folks, this is what it's like when people listen to Towel, even during mundane moments of otherwise very overwhelming and intense court hearings. Yes, folks, you tune in because you hear a man who thinks he's a horse racing announcer, Towel, talking about the real-time reaction of Chewbacca and the Stay Puft Marshmallow Man to yesterday's bombshell developments. Yes, ladies and gentlemen, it wasn't just the jury who were left aghast. It was the Stay Puft Marshmallow Man and Chewbacca. Look at that reaction. Oh, my word, the humanity. Oh, ladies and gentlemen, the good ship Hinden Reed is collapsing. Oh, ladies and gentlemen, the humanity. No, Sema, listen, hold on. I am not Chewbacca in a wig. That is Chloe the dog, clearly. Secondly, I didn't bring up the Stay Puft Marshmallow Man. Alan Jackson brought up the Stay Puft Marshmallow Man. Do not make me defend my honor. I will defend my honor just to prove you wrong. Listen, ladies and gentlemen, Semelina might be, Sema might be our emissary to Latin America to help us facilitate towel production and spread the love of Jesus Christ. But ladies and gentlemen, let me make something clear. I did not introduce the Stay Puft Marshmallow Man into a criminal trial. I will not stand by and have my honor besmirched and have accusations fly that I, of all people, a man who thinks he's an anthropomorphic towel and a horse racing announcer, introduced a Stay Puft Marshmallow Man into a criminal trial. I didn't do it. I will not take responsibility for it. I will not be blamed for it, ladies and gentlemen. Listen, I must defend my honor. We must watch the clip. We must show Semelina that it was not Towel who introduced the Stay Puft Marshmallow Man. When I do such a thing, use a sardonic mimetic device to mock the content of a criminal trial, I might have done that with Chewbacca, but I did not do that with the Stay Puft Marshmallow Man. That was Alan Jackson. How dare you? Ladies and gentlemen.
Not to get too colloquial, but a puffy coat is like, it's got down and stuff in, right? Correct. Looks kind of like Stay Puft Marshmallow Man, right? Yes, sir. Okay. Not to get too colloquial, but a puffy coat is like, it's got down and stuff in, right? Correct. Looks kind of like Stay Puft Marshmallow Man, right? Yes, sir. Okay.
Have I made my point? Have I made my point? Okay? It was not me. Ladies and gentlemen, it was not me. It was Alan Jackson. Sema, I swear my honor has been thus defended. It was Alan Jackson.
You are unmuted.
Okay, here we go, folks. We're back in session. I'm a towel.
Thank you for asking. We're back in session. You may be seated.
So you wanted to see me?
Yes, please, Your Honor.
Okay, over here or?
Sidebar! Ladies and gentlemen, sidebar! It's your favorite time of the day. Not only does Towel get to come back and talk to you more, we are at a sidebar. Oh, ladies and gentlemen, yes, that was quite a moment. Sema learned that if you're going to ask if the Stay Puft Marshmallow Man is relevant beyond a sardonic mimetic device, yes, ladies and gentlemen, you will send me into horse racer announcer towel mode. Oh, the humanity of it all for the Stay Puft Marshmallow Man and Chewbacca. What did they do to deserve this? Although I respect that Sema has now understood it was actually Alan Jackson's fault. How did Chloe even get a wig to begin with? Firstly. Second of all, how did Chloe, a dog, think, oh, I'll just dress up like Chewbacca? There's no way Alan Jackson will find me if I dress up like Chewbacca. And then furthermore, how did Chloe, a dog in a Chewbacca costume, start thinking to herself, oh, I should retain the Stay Puft Marshmallow Man from the 1984 movie Ghostbusters to represent me as counsel if Alan Jackson files a Rule 17 subpoena. God help us all. Ladies and gentlemen, back in session, I'm a towel. Oh, I did Pilgrim Shadow, I did address the buffer zone ruling. Buffer zone ruling means that it's not a ruling. The buffer zone is just updated. It stays exactly the same as to its parameters and now is a mens rea requirement pursuant to Cox v. Louisiana from 1962, which means that after Mark Randazza filed for a temporary injunction and was denied at the federal district court in Boston and then appealed the denial up to the First Circuit Court of Appeals, that denial was vacated but not reversed, and now the buffer zone stays in place exactly as is. The status quo prevails. The federal district court, in light of the new ruling from Judge Cannoni to add a mens rea requirement, will rule again upholding the buffer zone. Randazza will appeal it again. It will go up to the First Circuit, who will review a more robust factual record and render a decision probably after the trial's over. Boom! I hope that made sense for you. I'm a towel. What chat am I reading? What am I reading? What am I trying to see? It is the best chat. Oh, I told you about the buffer zone ruling. I've done as much as I could. What has happened? You can't just say read chat. Has something developed beyond just asking me to ask about the buffer zone ruling? If there is a development, you must tell me, ladies and gentlemen. The chat goes so fast. Oh, ladies and gentlemen, it was actually Nick Rocco. No. Oh, no. Listen. I may have a picture for us. I don't know how long this sidebar is going to be. There's no victim. Nothing has happened. We're about to get to a very devastating moment in testimony. It's about to get really bad for Karen, as if it wasn't worse enough. So, yeah, correct, Pilgrim Shadow. It's the exact same as it existed before. The only difference is a mens rea requirement and the ability to challenge an enforcement action in superior court. But that doesn't really matter. Hold on. Someone asked a question about Nick Rocco. Listen, I have reason to believe that the reason why Chloe was able to get a Chewbacca costume was Nick Rocco. Now, you might be saying, Grant, that is outrageous. That is just absolutely outrageous. You cannot possibly claim that Nick Rocco was somehow involved in Chloe the dog getting a Chewbacca costume. Now, listen, I thought it was impossible, folks. I never thought this kind of thing was possible, but during the break, I have photographic evidence, potentially sardonic, of Alan Jackson, Nick Rocco, Chewbacca, and Karen Reed together. Now, you might be saying, Grant, you cannot possibly have found that. And don't we have serious things to talk about? Well, yes, maybe we do. But blame Semolina for this. Sema's the one who brought up Chewbacca and the Stay Puft Marshmallow Man and Alan Jackson. All I did was address the controversy, folks. I know. Listen, you tune into Towel Stream because some people watch sidebars and they're just like, oh, this is interesting. I wonder what's going on. Other people debate the intricacies of the Chewbacca and Stay Puft Marshmallow Man saga, which has been, I happen to feel, ladies and gentlemen, one of the most interesting subplots of the entire John O'Keefe and Karen Reed trial. And, well, yes, Pilgrim Shadow, it's on my Twitter. We read it already. It's not a ruling. It's a supplement to the First Order, and it doesn't actually change anything about the First Order. All it does is add a mens rea requirement. You can find it on my Twitter. I'm happy to continue to explaining it, but it does, since the status quo hasn't changed, there's nothing to explain. Nothing has changed. So, yes, I think, yes, in that picture, Chewbacca had been baited. Oh, are they eating spaghetti now? Listen, we know that David Yannetti is willing to deploy the spaghetti in order to trick Chewbacca so that the Stay Puft Marshmallow Man gets confused and starts screaming with incredulity. Now, whether or not David Yannetti has deployed the spaghetti at this sidebar right now in particular, I don't know. Maybe John DePetro can tell us. Someone should ask John DePetro, is it true that David Yannetti started cooking spaghetti at sidebar in order to distract Judge Cannoni so that Alan Jackson could bring in the Stay Puft Marshmallow Man, who's actually representing Chloe the dog in a wig, who's dressed like Chewbacca during a Rule 17 voir dire? Now, I'm pretty sure John DePetro would say, did Towel put you up to this? And then you should say, yes, absolutely. Grant told me that I should come ask you if David Yannetti started cooking spaghetti to distract the judge. Hold tight. Hold tight. I'm a towel. Bear with me. I am a towel.
Tori, I'm going to give you those. Those were both marked for ID, so one will be coming into evidence and one will be a chalk, so you may need to have them available for the witness.
Get ready. I am a towel. Ladies and gentlemen, prepare your towels in a loving and compassionate way. Fluffy towels for love and compassion. We see Adam Lally. We see Laura McLaughlin. We see Hank Brennan, the man himself, who I'm supposed to call Hank.
Stand wherever you're more comfortable, Doctor, for now.
And now we look at Bob Alessi's head. Bob Alessi does have a head, that is true. You can say a lot of things about Bob Alessi. You cannot say he doesn't have a head. I will defend Bob Alessi if anyone says that man does not have a head. Yes, ladies and gentlemen, Bob Alessi is not the headless horseman. Bob Alessi has a head. I know this is the kind of erudite analysis that you've tuned in for. I know that you are thrilled to learn that Bob Alessi, the rumors are false. Bob Alessi does actually have a head. Thank God. Imagine if a man walked into a courtroom without a head, ladies and gentlemen. First of all, how would he be walking? Second of all, what, does he have a brain in his heart or something? Third of all, oh, ladies and gentlemen, who allowed me to talk to you all? Just unfiltered. This is what you get. Oh, look at Hank Brennan and Bob Alessi discussing. Bob Alessi admires Hank Brennan. You can tell they have a mutual respect. Oh, God bless you, Colleen Henry. I'm going to try to get, as soon as session comes in, I'm going to watch the next important testimony. And then I'm going to try to, at 12 o'clock, go get lunch so that I can be back with you all. We're about to see some intense moments about the conclusions about John's injury and the reddening of John's pancreas. Please prepare yourselves. As much as I tried to calm your nerves over lunch and make you relax, it's going to get intense again. Even as a fluffy towel, you have to remember fluffy towels are there in good moments and bad, and that warmth that, and comfort you feel with your fellow towels will help get you through these intense moments, and a graphic warning will come up, although they won't show anything too graphic. If you are going to see something intense, your fellow towels will probably tell you it's going to get intense. Turn away, cover your little towels' ears and eyes. Especially children should not be watching autopsy photos. Although we don't have any viewers under the age of 24 according to the demographics, which is great. I don't want children watching coverage of these kind of cases. So, God bless you all, little towels. Continue supporting each other. It's these moments that make the fabric of the towel universe so intermeshed and important. The good moments, the bad. That's what life's all about, isn't it? You don't know good if you never knew bad. And you don't know bad if you never knew good. It is the yin and yang of towel existence. Fourth of all, you are a towel. That's true. I am a towel. David Yannetti doesn't have any spaghetti, but he is intently focused. Alan Jackson looks like a defeated man. He looks like he has no soul. Although I don't mean that literally. I mean, it looks like just the soul has been sucked. The life has been sucked out of him. No pun intended. No, don't. What is wrong with you all? What is wrong with your minds? I didn't mean that way. Oh, God, help you all. What is wrong with you? I'm going to send you all to some kind of reformation camp in a loving way so that you can learn about Christ and the virtues of the Bible. Here comes the jurors. Get ready, ladies and gentlemen. I have watched some of the Star Wars. I wouldn't say I love any of the Star Wars. Like, it's like I think they're great films, but like, am I like, oh, I want to canonize the Star Wars characters? Probably not. I don't. But yes, I think it's a well done film. The first few in particular. There we go, ladies and gentlemen. No, this is not the sentencing hearing. I wish we could jump forward in time. We were waiting for very devastating medical evidence about John O'Keefe's head injury and probably the reddening of his pancreas that led to conclusions that John was killed by Karen. All right, here we go. My name's Grant Smith Ellis.
Mr. Brennan.
Doctor, when we left off, you had described all the injuries to the exterior of Mr. O'Keefe, and we had talked about your observations of both the fractures in his skull and also your observation of Mr. O'Keefe's brain. You mentioned earlier that you use other resources, other testing. Did you ask for any type of assistance on toxicology analysis for Mr. O'Keefe?
Yes, it is routine and it is protocol to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
Thank you, Mr. President. Doctor, I'm handing you a document. Do you recognize that?
Yes, this is the report of toxicology from the State Police Crime Lab for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes.
Is that a fair and accurate depiction of the report we saw before?
Yes.
Do you want to introduce this as the next exhibit, please?
No objection, Your Honor.
Thank you.
Exhibit 161.
Thank you. I have that in front of me. Sure. Thank you very much.
Thank you.
In your experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
In the toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay. And was there any?
There were no prescription medications. There were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor?
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball. And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, doctor. After your autopsy and observations of Mr. O'Keefe's body, inevitably did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes. The cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit.
And what is a normal body temperature?
98.6.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes.
And what is that document?
It's the death certificate.
Did you do so in this case?
Yes.
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
Yes. There is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate in this case stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a document. Do you recognize that document?
Yes.
What is it?
This is the final or amended death certificate for Mr. O'Keefe, stating that the cause of death is blunt impact injuries of head and hypothermia, and that the manner of death could not be determined.
Do you recognize that document as accurate?
Yes.
Your Honor, move this in evidence, please.
No objection, Your Honor.
All right, thank you. Exhibit 162.
After issuing the death certificate and after the 90 days passed, have you done any further study or investigation on this case, Doctor?
No.
Thank you. I have no further questions.
May I, Your Honor?
Yes.
We have not had the pleasure of meeting, so good morning, Dr. Scordi-Bello.
Good morning.
With regard to cause of death as opposed to manner of death, is it correct that a forensic pathologist is tasked with determining that cause of death that includes contributing factors, injuries, and circumstances regarding the medical legal death investigation? Is that a fair statement?
Yes.
And I'm using the term medical legal. Is that a term that you're familiar with?
Yes.
And is it correct that medical legal means, particularly for medical examiners, that there's a medical aspect to the investigation that you perform, and there's also a legal aspect or a law enforcement aspect to it? Is that correct?
Correct.
And that's a little different than what physicians usually do, right? Because isn't it the ordinary course that it's mostly just medical, but medical examiners by statute and law need to have both of those prongs taken into consideration? Do I have that right?
Yes.
So, in other words, the forensic pathologist, which you've indicated you are, is tasked with determining the cause of death, which answers the question as to why, in more layman's terms, why did the individual's body stop functioning at a particular time, correct?
Yes.
So more broadly, the cause of death is generally defined as the disease or the injury that resulted in the death of a person.
Correct.
So let's now, if we could please, move to the manner of death. And I'd like to summarize, I know you covered it on direct, but I want to put it in a slightly different context, and hopefully I'll get it right. So medical examiners, as you've stated, are also tasked with, if they can, determining the manner of death or the circumstances under which the death occurred, correct?
Correct.
So manner can and does involve the circumstances under which the death occurred.
Yes.
And that causes one to go the medical examiner to go beyond just medical analysis. You take into consideration other factors which we'll get to. Is that correct?
Yes.
So you talked about, and I'm just going to go through them quickly, but if you could just check me on this, the 5 main categories of manner of death. So you talked about natural causes, correct?
Yes.
You talked about accident.
Correct.
You talked about suicide. You talked about homicide. And then the last category, undetermined. Do I have that correct?
Yes, you do.
So what I'd like to do is to focus on the undetermined category. And my understanding is, Doctor, that that's where you landed, that's where you concluded with regard to manner of death of Mr. O'Keefe, correct?
Correct.
So undetermined is a term that is used and that you use, and does that mean that when the information pointing to one manner is not more compelling than other reasonable possibilities, or the death investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed? Is that generally correct?
Yes.
So, as we've talked about, I'm just trying to follow or just develop some logic and see if this is in agreement with you, that as a medical examiner, you're specifically tasked with conducting that medical legal investigation, and what we've just talked about is a bit of the method of analysis that you go through for that, correct?
I conduct the autopsy, and I request information information from the investigative body that is out there investigating the other aspect of the case, not the body itself.
Yes. So, is it correct that there's 4 general components to a forensic pathologist death investigation? Is scene investigation one of the components?
It depends on the jurisdiction where you practice. Scene investigation is part of forensic pathology in certain jurisdictions, and it is the responsibility of the district attorney and law enforcement in other jurisdictions. In the state of Massachusetts, we are responsible for the autopsy, and the DA's office and law enforcement are responsible for the scene investigation.
Excellent. So, scene investigation in the state of Massachusetts is not within your domain in the office of the medical examiner. That is the domain of the district attorney and law enforcement, correct?
Correct.
How about another aspect, forensic autopsy and laboratory testing? That's within your domain, correct?
Correct.
And how about police reports and witness statements?
That is not under my jurisdiction. That is under the district attorney's office and the police.
Do you consider information, nonetheless, from police reports and witness statements in your analysis?
Yes.
And do you also consider, even though it's not within your jurisdiction in Massachusetts, do you also consider information about scene investigation?
Yes.
So it's correct then that you consider, whether it's within your jurisdiction or not, you consider scene investigation and police reports and medical statements, correct?
Yes.
And then forensic autopsy and laboratory testing is right within your jurisdiction, and therefore, of course, you consider that. And then lastly, medical history and hospital records, is it, therefore, am I correct that that's something within your jurisdiction and that you consider in performing your forensic pathologist death investigation?
Yes.
So now let's move on to the application of those principles. So in order to conduct a proper medical legal, if you will, is one of them being well-grounded in general medical knowledge?
Yes.
Is another appropriate training and experience in forensic pathology?
Yes.
In other words, you wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is that correct?
I would not want them to be conducting an autopsy, correct?
Right. Would you want a neurologist to conduct a death investigation?
Personally, or are you asking me that? No, I don't think every physician has their specialty and their training, and forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
Going back into the many qualities of a medical examiner and attributes, they also have to have the ability to form opinions based upon all the available information using the scientific method along with sound reasoning. Is that a fair statement?
Yes.
And you're familiar with the term scientific method?
Yes.
And is it fair to say that the scientific method generally is sort of a systematic pursuit of knowledge that involves recognition and definition of a problem? Is that fair?
Yes.
Is it also involve the collection of data through observation and experimentation where appropriate?
Correct.
Does the scientific method also include the analysis of data?
Yes.
Does the scientific method also include the formulation, evaluation, and testing of hypotheses?
Yes.
And does it also, where possible, include the selection of a final hypothesis after considering other hypotheses?
Correct.
So what we've just discussed is a fair explication, a fair explanation of the scientific method. Correct. And the scientific method is part of the autopsy and forensic pathology analysis, correct?
Correct.
Now, applying one concept, that medical legal concept we talked about, just holding for a moment, if you could, the medical and going to the legal, if you will, law enforcement that you said in Massachusetts is not under your jurisdiction, but nonetheless you consider information arising from it.
Yes.
Are you familiar with a person named Michael Proctor? Is that name familiar to you?
Yes, it is.
And at one time, Michael Proctor was a trooper, correct?
Correct.
And so, did former Trooper Proctor inform you of the working law enforcement theory at the time of the investigation of this matter, namely his working theory, a collision of a motor vehicle with a pedestrian? Did he inform you of that?
He informed our office of that, yes.
He informed your office. And is it fair to say that he informed your office or provided that information to your office in or about February of 2022?
That information, part of that information was provided to our office at the time of the autopsy. One of the pieces of information that had come in, and there were multiple sources calling into our office providing information, was that this was a possible person struck by a motor vehicle.
And the time of the autopsy, if I have it correctly, was that around the end of January of 2022?
The autopsy was January 31st.
Your Honor, if I could, with your permission, please publish a photograph which Your Honor has and the parties have stipulated, or that's in evidence. And this is the one. May I approach, Your Honor?
Yes.
May I show that to the witness?
Okay. All right, so we will mark this as the next exhibit. There's no objections to Brennan?
No objection.
Okay, so we'll mark it first and then you can display it.
Thank you, Your Honor.
Exhibit 163.
Thank you. May I, Your Honor?
Yes.
Thank you. Dr. Squirty Bello, if I can hand that to you, please. You can take a look at it, and when you've had a fair opportunity to look at it, you can just look back up, and I'll proceed at that time.
Yes, I recognize the picture. Well, I've never seen this picture before, but I know what it's depicting.
Thank you. What is depicted in that picture?
It's a picture of two individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Thank you. Mr. Wolf? And if you could please zoom in on the two individuals in that picture. Dr. Squirty Bello, do you recognize any of the individuals in that picture?
To be perfectly honest, no, I don't.
With regard to the person on the right, do you recognize that person?
No, I don't.
And you said you recognized the set. You testified earlier, if I recall correctly, that the autopsy was performed at the Cape Cod facility of the Office of the Chief Medical Examiner?
Yes, he was.
And you're normally in, as I recall, the Westfield, in an office that covers Western Massachusetts and Westfield?
Correct.
But you were at the Cape Cod facility, as I understand it, because there was a staff shortage and you had to travel down to Cape Cod for this. Is this correct?
Correct.
So you were at your normal home-based sort of facility. This is a facility that you went to for this autopsy, correct?
For this autopsy and multiple others, yes.
Yes. And you were covering a staff shortage, and that was the reason you went to Cape Cod, correct?
Correct.
And what's depicted in this picture are two individuals. For two individuals to be present, is there a protocol that they had to follow to be present for that? Like a sign-in or an authorization?
Yes, there is a sign-in sheet that individuals have to put their name and their shield number and before they can come into the autopsy room.
So they have to put a shield number down, correct? You mentioned a shield number.
Yes.
And does that therefore mean that even though you don't know who they are, that they are with law enforcement? Are you able to determine that?
Correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who they are?
I don't know who they are specifically and what their actual position was.
But they were with law enforcement.
I believe, if my memory serves me right, there was a person from crime scene investigation and someone from state police.
Thank
But I'm working on a 2+ year memory.
Fair. That's fair. That's fair. I'm not going to ask you more questions to probe the memory. We can take that down. And yeah, we are finished with that. If you could hand that to the, thank you. Now, we were speaking about former Trooper Proctor. Do you recall former Trooper Proctor sending you a copy of scene photographs and wanting to schedule a phone call with you so that he could explain the status of his investigation? Do you recall that?
Yes.
And that occurred approximately in March of 2022?
Yes, approximately.
Right. And the method of communication of that was that by email, to the best of your recollection?
I requested that our medical legal investigator, we have our own investigators at the office that are responsible for obtaining medical records and sometimes being the liaison between us and law enforcement to get reports. I requested that she contact whoever was in charge of the investigation and set up a meeting, a phone call. So since it had already been a few weeks since the autopsy, I wanted to make sure that if there was any additional information that could be provided to me, I could take it into account, because I had 90 days to issue a report and a death certificate on this case.
Now, you've mentioned the 90 days on direct. You just mentioned it now. Is the 90 days a hard and fast rule, or is it just something you aspire to as a matter of good practices?
It's not a hard and fast rule. It's something that as an office we try to achieve. Again, the reason being that there are family members, next of kin that are waiting for these reports and these death certificates for various reasons. So is it possible to go over the 90 days? Absolutely, if necessary. But we do try to finish our part in those 90 days.
So it's possible to go past the 90 days, but there would, given the considerations you just articulated, there'd have to be a pretty good reason why you'd want to do that, right?
Correct.
And in this situation, you concluded that you had sufficient information on the medical side and the legal side to come to the conclusions that you needed to come to. Is that fair?
Well, I had sufficient information on the medical side because I did the autopsy and I had those findings. I did not have sufficient information that pointed to one manner of death over another manner of death, and therefore I stated that the manner of death was undetermined.
Exactly. So the manner of death is undetermined, and I want to, if I could with you, pursue that a little bit in a moment. But when you came toward the end of that 90-day period, you had information from the law enforcement side on their theory of what had happened, correct?
Correct.
Yes.
I'll let that one stand.
You had performed all of the medical investigation and analysis that you needed to perform, is that correct?
Yes.
There wasn't something more that you wanted to do on the medical side. You had mentioned, to be fair, you had Dr. Stonebridge involved as well. You had what you needed on that side, correct?
Yes.
And you therefore concluded on the manner of death that there was a not more compelling or more likely than other reasonable possibilities. Is that fair?
Yes.
So in furtherance of that, on April 14th of 2022, you issued a death certificate, correct?
Yes.
And please feel free to check your report of any dates or any other particular as I go through.
Okay. I issued my final report on April 14th, correct, and I would assume that the death certificate was on or around that same day.
Thank you. Now, to back up a little bit with regard to the autopsy, as you stated, it was conducted, I just want to do a little bit of a timeline, on January 31st of 2022, correct?
Yes.
And we discussed that the body of Mr. O'Keefe was presented to the Cape Cod location, correct?
Yes.
And you also discussed that you brought Dr. Stonebridge to work with you on this matter, correct?
She didn't physically come to the office. The way Dr. Stonebridge was involved is at the time of autopsy when the brain was removed, having seen that there were injuries, I saved the brain in a special solution, and then the brain was transported to our facility in Boston. That's where Dr. Stonebridge examines the specimens. And after examining the brain, she issued a report.
Who asked Dr. Stonebridge to become involved in the matter?
I did.
And Dr. Stonebridge is triple board certified, correct?
Correct.
She's a forensic pathologist, correct?
Yes.
That means she's achieved board certification in forensic pathology like you? Objection.
Do you know that?
I do.
I'll allow that.
Yes, she's board certified in forensic pathology.
And she is board certified in general pathology, correct?
Yes.
And she's board certified in neuropathology, correct?
Correct.
Can you briefly describe to the jury what neuropathology is?
Neuropathology is a subset or specific additional training in forensic pathology where the person spends a considerable amount of time, usually 1 to 2 years, examining brains and learning all about the diseases of the brain as well as trauma to the brain.
Now, you asked her to be involved, as you indicated earlier, correct?
Yes.
And you determined that she should be involved because there was a brain injury, correct?
There was trauma to the brain, correct?
Trauma to the brain. Is it a fair characterization that Dr. Stonebridge is sort of the brains of the brain area of autopsy? Is that fair?
I'm going to sustain the objection. Let's move on.
Look, so with regard to Dr. Stonebridge, would you agree that she's really uniquely qualified in some ways? Or how would you describe her qualifications, Dr. Stonebridge?
Sustained.
With regard to Dr. Stonebridge, what did she do?
I'm going to see you at sidebar on this, please.
May I, Your Honor?
Yes.
Thank you. Dr. Scorti-Bello, are you aware of an attorney named, or excuse me, a doctor named Zeke Wolf?
No, I'm not.
Now I'd like to move on to another category. Based on the information that was presented to you as part of your examination and analysis, is it correct that you presume that because Mr. O'Keefe's body was found in the snow and his body temperature was 80 degrees, that he died from hypothermia as one of the causes?
I reached that conclusion after performing the autopsy and after seeing some findings that were consistent with hypothermia, and then combined with the information that was provided to me about Mr. O'Keefe's body being found in the snow, I came to the conclusion that was one of the things that contributed.
Did you consider whether there may have been other reasons as to why his body reached that temperature of 80 degrees? Sort of applying the scientific method and seeing if there were other reasons?
Other than being out in the snow? No, I did not.
Do you know whether there are other alternative reasons how his body could reach the temperature of 80 degrees?
People can become hypothermic for other reasons, such as sepsis. But in this particular case, I didn't have any reason to believe that that was part of the circumstances.
You're familiar with the medical phrase differential diagnosis, correct?
Yes.
And a differential diagnosis is a term that's used by doctors to pursue other potential causes of a medical injury. Is that a fair general statement?
Yes.
So, for example, if somebody is having difficulty breathing, a doctor may say, I think it's the heart as their primary hypothesis, but they may want to differentially diagnose this and look at the lungs. Is that an example of a differential diagnosis, that let's look at the lungs to see if that may be the problem? Is that a good, fair example?
In the example you're giving, yes.
So applying that concept, and do you believe the concept of, well, applying that concept to this situation, did you perform a differential diagnosis as to the cause of the death and question whether there was hypothermia as any cause of the death of the decedent? Did you make that analysis?
I looked at the anatomic findings that I had at the time of autopsy, the information that was provided to me based on the circumstances and where the body was found, and I came to the conclusion that there were hypothermic changes in Mr. O'Keefe's body.
So you just used the phrase hypothermic changes. Did I hear that correctly?
Yes.
Can there be hypothermic changes without a cause of death being hypothermia?
Yes, of course.
So you can have signs in the body of hypothermia, but you can also conclude that a cause of death is not from hypothermia, correct?
If the person is deceased and I am examining the body and there are multiple things that I believe contribute to the death, then I tend to include all of them. Meaning that if this was a drug intoxication and the body also showed signs of hypothermia, I would include both of them on the death certificate because there is no scientific way of teasing out whether it was just one or the other or both. In this particular case, I had two processes that were going on. One was the head trauma, and the other one were these hypothermic changes. I put all that together, and again, included or took into account the investigative information of where the body was found, what the temperature was when the body was found, whether the person was still alive or not, and I came to the conclusion that the cause of death was blunt impact injuries of head, and I included the hypothermia because I saw during the autopsy that there were changes consistent with hypothermia.
So I want to break that down a little bit, if I could, with you. So you testified on direct, and I think you alluded to it here, that the primary cause of death, use that phraseology on direct, was blunt force injury. Is that correct?
Blunt impact injuries to the head, yes.
Blunt impact injuries to the head, and that's the primary cause, right?
Correct.
And then there's, and I'm not clear on what you referred to on direct as a secondary cause of death of hypothermia, but you've used a little different phrase in some of your answers, and I want to make sure I got it right. Hypothermic considerations. Can you repeat what it was?
I said hypothermic changes.
Hypothermic changes, and we agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
As you sit here now, with regard to, you used the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to further information. We got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death. And you said in one of your answers that you relied upon law enforcement information, correct? Is that part of it? It was you brought that up. You're the one who said you relied upon that, correct?
Yes.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So,
Sustained.
So now what I'd like to do is to ask you whether, using the concepts of differential diagnosis, scientific method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and been moved and placed in the snow? Did you consider that?
Objection. Sustained.
May we approach, Your Honor?
Move along with this. We can approach in a bit.
Thank you. What, if any, alternative diagnoses did you apply to Mr. O'Keefe?
I don't understand your question.
What alternative scenarios did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
I'll allow that question. What, if any?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances, and at the end of the investigation, or at the end of, my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner. The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with hypothetical scenarios on how those injuries occur. I try to state the injuries, describe the injuries, state the cause of death and why that person died. And then I use all kinds of other investigative information that is provided to me to determine if I have enough to make a determination on the manner.
Did anyone provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
Did you ask for any alternatives to the nature and location of the injury or death of Mr. O'Keefe?
I asked for all the information that was available.
Understood, but my question is, did you ask for any alternatives to the information that was provided to you as regards the location of the injuries? Did anyone provide you any alternatives to where the injuries could have occurred?
No.
So
I'm going to let the answer stand. So the answer is no, so there's no evidence of that. So next question.
So you talked about the information you had at the time. What time is that?
The information at the time was a preliminary police report and verbal communications regarding the circumstances of how Mr. O'Keefe's body was found.
And when I asked about the time, I'm not calendar time. Was this January, February, March, April of 2022?
The preliminary police report was on the day of the autopsy, and then information, I don't remember exactly how long, but in the weeks following, information was coming in.
Do you have the ability to amend a death certificate?
Yes, I do.
And you can amend a certificate if you obtain further information with regard to the circumstances surrounding the death. Is that correct?
That's correct.
In your previous answers, you were talking about the information you had at the time. And I'm concluding that the latest that would be is April of 2022. Is that correct?
Correct.
Have you obtained or been provided with further information, in other words, information after April of 2022 regarding the cause or manner of death?
What do you mean, have I been provided? Has someone physically provided me with a report on different circumstances?
Well, what I'm just talking about is any other information that you have received or considered in terms of the analysis with regard to the cause or manner of death.
Received in what way?
Here's what I'll do. I'll be a little more specific. What I want to do is to get at the head injury of the decedent, okay? Is it fair to say that the head injury, you called it a traumatic, state what you phrased that as, because I want to use your phraseology.
Blunt impact injuries of the head.
So blunt impact injuries of the head. Is it fair to say that that was a very severe injury?
It was a severe injury, correct.
And would Mr. O'Keefe had been rendered unconscious nearly instantaneously with death following shortly thereafter?
It's very possible, yes.
Is it more than possible? Is it probable that that's what would have occurred?
I can't tell you how quickly he would have been rendered unconscious, but at some point after that injury, yes, he would have been rendered unconscious.
Is it possible he could have been rendered unconscious immediately?
So she's answered it this way. I think you need another person for that. Let's move on from that, Mr. Lessie.
You made your own determination of the cause of death, correct?
Yes, that's my job.
Understood. And what I want to do is to pursue the basis of your determination. So you used the phrase brain impact injury.
Blunt impact.
A blunt impact injury. Have I got that correct?
Blunt impact injuries of head, yes.
Of head, right. And that's your conclusion, correct?
Yes.
Based upon your conclusion, did you make any determination as to whether the decedent would be able to carry out any purposeful movement after that injury?
Define purposeful movement.
Sure. I'm talking about the ability to perhaps manipulate their hands.
I don't know.
Did you make any determination as to whether they would be able to engage in any cognitive functions, meaning processing things and making decisions?
I did not make that determination, no.
Did you observe any pattern to the injuries to the head of the decedent?
A pattern? I observed that there were injuries to the back of the head as well as other internal injuries to the base of the skull, as well as the brain.
Your Honor, if we could please publish, I'm just going to check to make sure they're in. If we could, Your Honor, publish 160 that is in evidence. But before we do, Mr. Wolf, I would like to approach Your Honor and let you know in case there's anything further that needs to be done. Thank you. You can show this.
Did you show it to Mr. Brown?
It's already been agreed to as in evidence.
Okay.
And it is in evidence.
Oh, it's in evidence?
Yeah, I just wanted to make sure if there was any statements that Your Honor wanted to make, and if not.
So why don't you come over here, because why don't you come over a second?
May I, Your Honor?
Yes.
Thank you. With Your Honor's permission, I would like to publish Exhibit 160.
Yes.
Thank you. Dr. Scorti-Bello, if you could please draw your attention to what is depicted on both screens. Pick whatever screen is most convenient for you. And what I want to do is to go over what is depicted there, and I'd like to start with just some basics. What is that white rectangle that is on the photograph?
This?
Yes.
That's a ruler.
And what's the purpose of the ruler?
To show a scale. When I measure the injury, I use the ruler to document that.
And if you could please draw your further attention to what I will refer to, and you use your own term, but just to start it, the horizontal line that is appears to be a laceration. You know what I'm referring to?
This, yes, this is a laceration.
Right, so it's fair to say that that's a laceration.
Correct.
And just so we get all that's depicted on this, you referred to earlier up above that, the red area. Is that an abrasion?
Yes.
And do you also denote to the left almost like a J-type item going vertically up? Yes, and going up. Do you see that?
Yeah, that I did not note that specifically. I just noted the whole injury as part of the abrasion.
That's my point. So you didn't make a separate note of what appears to be a J, and it might be easier to see it in the screen over there. It's your conclusion, but is it easier to see there?
Yeah, I can see it.
Yeah, and so you didn't make a separate note as to what that was in your report, correct?
No, I did not.
Do you consider that an abrasion or something else?
I believe that's still an abrasion.
Do you conclude that that J is different in any manner from the abrasion that you've noted above the laceration?
I believe it could be part of the whole abrasion, or it could be something different.
Fair enough. Would a fall backwards on a flat frozen ground produce a circular and not a linear abrasion as depicted here on the back of an injured person's head?
Can you repeat the question?
Sure. Assume a fall backwards on a flat frozen ground. Would such a fall and impact present that type of pattern, or would it be a circular pattern, perhaps with type of pattern, or would it be a circular pattern, perhaps with...
I'll allow that. Can you answer that?
I can say that a fall backwards could very well produce that injury.
My question is more specific, and that is a fall backwards where the person impacts the back of their head on flat, frozen ground. Would you expect that type of a laceration from that type of a fall? Not just a general fall backwards, but specifically a fall backwards where the back of the head hits flat, frozen ground. Would you expect that?
I could, yes.
And under what circumstances could a laceration like that and an abrasion, all of it together, what circumstances could cause that type from a fall backwards on flat, frozen ground?
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on the type of surface, you mentioned flat, frozen ground, it's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury and a fall on someone's on the back of the head with a blunt surface.
Is there, are you familiar with the phrase pattern recognition in medicine?
Yes.
And isn't pattern recognition something that requires training with regard to being able to recognize certain patterns and determining what could be causing that pattern?
Yes.
And just merely recognizing whether there is a pattern takes certain specialty training, etc.?
Correct.
And isn't pattern recognition a principle that you apply in the medical examiner's office?
Yeah, we do.
And so example of pattern recognition could be a knife wound, correct?
Yes.
Could be a gunshot.
Correct.
And there's certain patterns that you see on a decedent that can be consistent with those types of causes of injury, correct?
Correct.
Assuming a fall backwards onto frozen ground and there being on a lawn with grass, would you expect to see any grass at all in the injury site?
It's possible to have grass.
Is it possible to have well, are you familiar with the height and weight of the decedent generally? And if you need to look at your notes, please do so.
Yes. Mr. O'Keefe was approximately 6'1" and 216 pounds.
So, assuming a fall backwards and an impact to head on a ground with grass, a person who's 6'1", there is going to be significant acceleration forces that occur as they're going backwards. Is that correct?
That's fair to say, yes.
And therefore, the more acceleration forces, usually there's a correlation with the force of the impact?
Correct.
And in terms of force of impact and assuming grass on the ground, would you believe it's more probable than not that one would then see some grass on the head? Okay.
Sustained is that form.
Given what you testified regarding the height of Mr. O'Keefe, and assuming what I just gave to you as a fall backwards and acceleration and forces, would you expect to see anything else on the back of his head?
You have to be more specific than that.
Right. I thank you. So, would you expect to see? Is it possible, if that was the manner of the fall, that there should be grass on the head? Is that possible?
Sustained.
Did you consider at all in your evaluation let me back up. Do you see any evidence of grass in this depiction?
No, I do not.
Did you recall ever seeing any evidence of grass when you were performing the autopsy?
I did not see evidence of grass.
Did you consider at all in performing your autopsy whether or not grass should be present given what was reported to you by law enforcement?
At the time of autopsy.
So the answer is no to that
No.
question. Thank you. Did you have any information regarding the circumstances that you said you look at in trying to determine manner of death as to whether there were any stones or rocks around the scene?
That I did not have any information.
So meaning you didn't have any information, you saw no information that there were any stones or rocks by the scene, is that correct?
Sustained in that form.
What, if any, consideration did you make in your assessment of cause and manner of death with regard to stones or rocks?
I did not make any.
With regard to any other potential causes other than ground, did you consider any other possibilities that could cause the type of injuries that are depicted on the screen?
There's a number of possibilities that could cause the injury.
My question is, did you consider, not whether there are, but whether you considered them at the time you were performing the autopsy?
I'm always considering at the time of autopsy what could have caused a certain injury.
Did you put in your notes or your autopsy report any of those considerations? Are they documented?
No.
Now, in terms of differential diagnosis that we talked about, did you determine whether there were any other possible explanations for the injuries to the decedent other than what law enforcement presented to you?
I'll allow that.
Internally, I consider all kinds of other explanations. I have to look at the findings and the possible ways that those injuries could have been sustained and decide whether I have enough information and whether I am satisfied with the information that I have in order to conclude or determine a manner.
Did you make any notes at all about the considerations you were just speaking about, other considerations, any notes whatsoever in any document in your autopsy report?
Not in my autopsy report, no.
Did you make any other notes of those considerations in any document that you created for this case at all?
No, these are I've had and discussions I've had with colleagues in terms of evaluating these injuries and
I don't want you to go into what other people said, but I want you to finish your answer.
Right, no, I did not make physical notes of my considerations.
Your Honor, I'm going into a different category, so I just wanted to alert Your Honor to it.
All right. And it will take more than 10, 15 minutes?
Oh, yes.
Okay. All right, jurors. Oh, we'll take the lunch and recess. So we'll see you in about 45 minutes.
Rise to the jury.
Goodbye.
Defense has nothing, Your Honor. Thank you for asking. Thank you.
Hey there, Karen Reed trial watchers. So we know that you're true crime fans, but are you also in a business of some kind? Well, if so, I want to tell you about Odoo. They're sponsoring this live trial stream. So Odoo is an incredible all-in-one business management software that provides you with a range of applications. One of their best applications, the sales tool. The Kanban pipeline, Game changer. Whether you're working with leads or full-blown opportunities, you can visually track every stage of your sales process. You just drag and drop to move deals forward. And it's fast and honestly kind of satisfying. When it's time to send a quote, it's literally a couple of clicks. The reporting, super clear. You get a live view of your pipeline, conversions, what's working, so you can focus on closing and not guessing. Right now, you can get a free 15-day trial of Odoo's all-in-one business solution and see how it can make your life a little bit easier. Just scan the QR code on screen or head over to odoo.com/LCLiveCRM.
I need my water bottle. I don't have a watch. Imagine if I had a watch. Let me mute this. All right, I'm here. Sorry about that, friends. I was a little bit late. I'm returning back, and you saw the law and crime commercial. But you know what? We like law and crime. Big shout out to Anjanette Levy. Big shout out to all the folks over at Law and Crime. On Towel Stream, we like it. We like Law and Crime. We support them. Go to their advertiser, whoever it was. I support them. All right, I'm here. Wicked. Yeah, so, okay. There are a lot of people who believe a lot of things that have, whatever. I think I think Sema really does care in some sense, but she also really likes getting a rise out of people. And I was willing to let her engage on the facts and okay, maybe her position gets a rise out of people. She just respected the atmosphere. It was okay, I'll move on. And then was okay, this doctor's testimony, whatever, I don't agree with it or whatever. But she didn't. She wanted to engage and troll. And listen, my limit is the people here are very nice to each other. They like each other. It's a very respectful, congenial atmosphere. I didn't even get to eat my pizza. I hope we don't do this again where I'm I want to eat my pizza and I can't. How about I take one bite of my pizza? It's good pizza. I had a good pizza. Towel's a simple man, or Towel, when he enjoys, more than anything in the world, a bite of $1.50 pizza. I watched all that testimony, by the way. Alessi's Cross was very boring. It did not go anywhere. What I want to do, though, is first, we are not watching The Fan. Ladies and gentlemen, oh my God, it's Chewbacca and the Stay Puft Marshmallow Man. Are you not entertained? But you know what I actually want to do? Let's go back and watch some of the highlights of the doctor's testimony while we wait for court to come back into session, which should be about 45 minutes to an hour. Alessi's Cross may have gone nowhere, but that doesn't mean we can't watch the update. Don't worry, folks. I will eat. I promise you, I'll pause the camera while I'm eating. And you know what we can do while I'm eating? Watch this. We can be good little towels, and we can get all caught up on what happened right before the lunch and recess, and then what happened after the lunch and recess. Now, first of all, if you missed the morning testimony, the witness was first of all, there was an update to the buffer zone. The buffer zone's in place. It's the same as it was before, same parameters. The only difference is now there's a mens rea requirement. It's a procedural thing in the federal courts. Nothing has changed. The status quo prevails. That's the update. Now, if we take a look, the very first update from today was John O'Keefe's leg injuries. Now, if you remember, Karen said, did I clip him in the knee? Talking about John's injuries. Ladies and gentlemen, I will say, no question in my mind, it's because I think Karen did hit John. Look at that knee injury. Maybe she did clip him with her car in his knee. That's certainly damaging evidence, folks. That was certainly a damaging moment. And we saw that moment occur at 10:43 a.m., so we'll run that back later. And then we'll take a look at the clip of Karen saying, could I have hit him in the knee? Yeah, there's a lot of moles around, people for different sides going around. It's crazy. But this is a peaceful chat. People can do that stuff elsewhere. Now, let's listen to the pre-lunch testimony, if you missed it. Excuse me, the pre-morning recess testimony about John's injuries, and then we'll conclude with the clip from after recess, and I'll eat my lunch now.
head to the right of midline. So this was the midline. The laceration was somewhere here, is what we call the right occipital area. And associated with that, there was an abrasion over it that would have been here. So this was what we call a compound injury, an abraded laceration.
We'll turn in a few moments to your autopsy observations about the inside of Mr. O'Keefe's skull. But first, I want to just show you a photograph relative to what you described to us. May I approach, Your Honor?
Yes.
Showing you a photograph. You recognize who's in that photograph?
Yes, this is a picture taken at the time of autopsy. This is the back of Mr. O'Keefe's head. The hair has been shaved off so that the injury can be clearly photographed, and it's a laceration with an associated abrasion.
Thank you. Your Honor, move this into evidence.
Okay.
No objection, Your Honor.
Thank you.
160.
When you examine the laceration, do you measure it?
Yes,
And did you measure it in this case?
I did measure it.
How long was the laceration?
I measured it as 2.5 centimeters, which is close to an inch.
Do you examine a person's body before you begin to intrude? Do you examine the outside of a person's body first, or is there a certain procedure or order?
Yes, the external examination is done first, and the internal examination is done second.
I want to show you that photograph that you just recognized, and I would like you to explain what you see to the jury. Ms. Gilman, with your assistance, thank you.
This is the laceration that I noted, and this is the scrape that's associated with it.
Take that down, please. After you make observations, what are your next steps in an autopsy?
The internal examination. After the external is performed, the pictures are taken, then we proceed with the internal examination of both the, as I mentioned before, the torso, the body, as well as the head.
I'd like you to take us through the internal examination. Did you have a chance to look internally behind the laceration you saw on the back of Mr. O'Keefe's head?
Yes.
And when you did that, could you describe for us what you saw?
Yes. The way we examine the head is we make an incision with a scalpel behind the ear from one side to the other. That allows us to reflect or pull back the scalp, and that will expose the skull underneath. We do this carefully so that we don't disfigure clearly the face. And when we reflected, or when we pulled back the scalp, I noted that there was blood, what we call hemorrhage, under the laceration or associated with the laceration on the back of the right head. And then furthermore, there were skull fractures associated with that laceration abrasion on the right side of the head.
Were the skull fractures in the same or different area?
The skull fractures were in multiple areas of the skull, what we call the base of the skull. Imagine the base of the skull is sort of a bowl, and the brain sits on top or in the bowl. When the brain is removed, you can have a very good view of the base of the skull. So when the brain was removed and we were able to look at the base of the skull, I noted that there were multiple fractures that appeared to be originating from the area of the laceration, or what would correspond to the area of the laceration.
When you made your examination of the fractures in the skull, did that lead you to your opinion, or was there more you needed to look at before you came to an opinion about the cause of death?
Well, that was part of the findings that led to my opinion. But yes, I removed the brain, and as is our protocol, I saved the brain in a special solution called formalin that allows the brain to become a little harder, so that our neuropathologist in Boston could go ahead and examine it. Because when I did look at the brain, I noted that there were injuries. There was bleeding on top of the brain. And therefore, I saved it. The brain ultimately went to our Boston office, and our neuropathologist, Dr. Stonebridge, examined it and issued a report.
Did you engage in any type of analysis on your own about any injury to Mr. O'Keefe's brain?
I noted the kind of injuries I could see superficially on the brain, and I have looked at the brain after it was fixed and pictures of it, but I did not issue a report on it. The whole point was for our neuropathologist to examine it closely and issue a more detailed report.
I have a few more photos. Would now be appropriate time for a break, Your Honor?
Yes.
Sorry, Towel friends. All right, now we need to watch one more overview of the morning session. Then we're going to watch the Karen clips about the knee. Then we're going to hopefully be close to return to session. So let's watch.
In his skull, and also your observation of Mr. O'Keefe's brain. You mentioned earlier that you use other resources, other testing. Did you ask for any type of assistance on toxicology analysis for Mr. O'Keefe?
Yes, it is routine, and it is protocol to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
Thank you, Mr. President. Doctor, I'm handing you a document. Do you recognize that?
Yes, this is the report of toxicology from the State Police Crime Lab for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes.
Is that a fair and accurate depiction of the report we saw before?
Yes.
Do I introduce this as the next exhibit, please?
No objection, Your Honor.
Thank you.
Exhibit 161.
Thank you. I have that in front of me. Sure. Thank you very much.
Thank you.
In your experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
In the toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay. And was there any?
There were no prescription medications. There were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor?
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball. And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, doctor. After your autopsy and observations of Mr. O'Keefe's body, inevitably did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes. The cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit.
And what is a normal body temperature?
98.6.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes.
And what is that document?
It's the death certificate.
Did you do so in this case?
Yes.
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
Yes. There is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate in this case stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a document. Do you recognize that document?
Yes.
And what is it?
This is the final or amended death certificate for Mr. O'Keefe, stating that the cause of death is blunt impact injuries of head and hypothermia, and that the manner of death could not be determined.
Do you recognize that document as accurate?
Yes.
All right, move this into evidence, please.
No objection, Your Honor.
All right, thank you. Ticket 162.
After issuing the death certificate and after the 90 days passed, have you done any further study or investigation on this case, doctor?
No.
Thank you. I have no further questions.
Ladies and gentlemen, 2 pieces of good news. 1, I'm back. I'm a towel. 3, second piece of good news. We don't have to listen to Bob Alessi. Why? Because I'm a towel. You know why they call a towel, friends? Because it's a towel. God bless so many who've been hanging out. I've been enjoying chatting with you all. Eva mentioned that the Bohemian Grove came up during the Diddy trial. If Diddy was in Bohemian Grove, that wouldn't surprise me. We saw exclusive footage on Towel Channel, ladies and gentlemen, of inside the Bohemian Grove. It wasn't exclusive. I got it from somewhere, but it was hard to find. Now, ladies and gentlemen, I think we have the clips you've all been waiting for. We're going to take a look at the testimony about John's knee in just a second. But before we do that, let's watch this great compilation from Tony B on Twitter. And we're going to do some real-time video editing. Everyone loves real-time towel video editing. I know you all are excited. So look what we do with real-time towel video editing. Have you all been here for this before? Here we go. Real-time towel video editing. Everybody's excited. Oh, wait a minute. Before we do this, we had a request from Colleen Henry. I am not a man to deny a request from the wonderful the wonderful towel, Colleen Henry. I am going to scroll down on my Twitter feed, ladies and gentlemen, and we are going to watch the clip of Hank Brennan saying I could call him Hank. Apparently, people find this very endearing. I'm going to guess that Hank Brennan might read and or watch Towel's Twitter feed. Oh, yes, ladies and gentlemen, here we go. We're going to watch the moment that Hank Brennan said I could call him Hank. Hold on, let's watch it twice. You as well, Mr. Brennan. Okay, sir, I will, Hank. One more time in HD. You as well, Mr. Brennan. Okay, sir, I will, Hank. Who, as he walks out with like 7 state police officers. Oh, goodness. All the towel friends are swooning. Oh, ladies and gentlemen, the towel friends are swooning. Colleen Henry has lost it. Colleen Henry is aghast. Mouth agape. Oh, ladies and gentlemen, in HD. Now, let's do some towel editing. You all continue to talk about how much you enjoy Hank Brennan. Oh, thanks, Colleen Henry. I did my best to respond. I was like, oh, yes, sir, Hank. I did my best, Eva. Little towel. The force, the towel to be reckoned with. But yes, let's watch these clips about Karen's knee, okay? Let's watch these clips and then let's edit it in with the testimony about John's knee today and the injury to John's knee.
I saw John go in the house.
Can you describe him going into the house? Which door and how and when?
No, I have, though, and I'm sure the prosecution will play it.
I was looking to find him on the side of the road. I was expecting I'd find him. He's in the general vicinity of where I last saw him. He's roughly where I left him. So yeah, when I found him, I was thinking, did I like clip him somehow?
Did he come and hit the back of my car and I hit him in the knee and he's drunk and
there it is.
Passed out and asphyxiated or something?
There it is. There it is. So I need that specific clip from the documentary. So give me a second. I don't like that audio over the back of it. God bless you all. Yeah, I just don't like. If anyone has a Twitter link to this clip from the HBO Max documentary, could someone share it? I love that Tony B found this, but I don't know how he put the audio. Start this again. So this is what we want. Like Tony B, this is perfect, but it's not. It's not exactly what I want.
Did I like clip?
Hold on one second. Let me switch over to duration. It's going to be a second because it's uploading this clip. So does anyone have this exact clip from the HBO Max ID Discovery documentary? Let's get the exact quote.
Hit the back of my car and I hit him in the knee and he's drunk and passed out.
So let me see if I can find it. If one of you found it in the chat, let me know. But I'm going to look for it now. Hold on. Oh, thank you, Tom. I do my best to be respectful. So, hold on. Karen Reed, and I'm just looking. I'm looking for those specific. I know I saw this clip before. Hold on. It was from the Body in the Snow documentary, but we need the clip. Hold on. We're going to find it. I wish Murder by Maestro was here. We just found that clip, but I need this, but not this, because this is not what I want. This is what I want, but I don't. This audio is it's a source audio. Like, leave the source audio. I like this guy Tony B, but don't use like your logo like you did. Other people, I don't know if Tony B realizes this, but maybe this is actually helpful to them. Other people, we definitely all have this archive, but if like I find it from your compilation and I need it as source material to juxtapose with the knee testimony from today, it's useless to me if you put this audio over it. It's useless. And just think about anyone who's putting these together. If you want other people to benefit from it, leave a watermark, put a logo, but don't mess with the audio, please.
Hit the back of my car and I hit him in the knee and he's drunk and passed out.
Hit him in the knee, Karen Reed. So I think I can find this. I think I can do it. Come on now, come on. I know someone posted about it. It was a while ago. I would say it was within the past 3 months. I know someone's going to come through in the clutch. This is a crowdsourced operation. Come on, little towels. Who can find me a clean copy of this clip? Towel might be able to find it first, but let's do it. Let's show our collective towel skills. I know that I found it in one of these clips, but I need the actual HBO Max documentary clip without this, and I know we can do it. Come on, little towels. Come on, little towels. Come on, little towels. I'm not going to give up this easily. It aired in the past few months, so that somewhat limits it. Let's listen to the full quote again. That might help us find it, the exact words.
And hit the back of my car.
Okay, so we know, I mean, we found the clip. You know what? I guess we can just do it. It really frustrates me, but let's just do it. So here's what we do. We split this, okay? We split that, we get rid of that, all right? So then we get rid of that. Then we know that we only want this much, okay? Then we delete this. Let's split it. All right, what has he got afterwards, actually? Let's just listen. It's going to drive me insane with this audio.
I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. He didn't look war. I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's
Could I have run him over? I mean, that's a very specific phrase. Could I have run him over? I think someone might have clipped this. Hold on, maybe someone found it already. No. Yeah, but you can obviously see we found the moment that we want. It's just I just have to find this exact clip. Could I have run him over? And I do have access to the documentary, but I don't want to. No, I want it to be. Can't you use Boolean operators? Why is this so frustrating? This is why we need Murder by Maestro, because that man is so excellent at this kind of thing. Could I have run him over? No, we don't have it. We don't have it. Come on, man. All right, we're just going to use this clip then. All right, now watch this. Watch this. Now what we do is we take the towel feed, okay, and then we're going to replace. We're not going to replace this. We're going to put the fan back up. All right, now watch this. Now we take the fan feed, right, which isn't actually the fan because they're not even doing lunch coverage. You can tell this Karen Reed trial isn't getting all the attention. It's the Diddy trial that's getting the attention because no one's doing lunchtime briefs on the Reed trial. So look at this, folks. Oh my goodness, it's double towel. Oh my word, it's what you've always wanted. Double towel, ladies and gentlemen. It's metaphysical towel. We got to go back. When was the exact moment of the knee testimony? Let's look at that screenshot again, shall we, little towels? We are such efficient little towels. We have just everything at our fingertips. That is why people watch Towel Stream, for the erudite information about, and the fact that we're all towels. And the fact that you all have such loving compassion for each other. We need to go to exactly, I repeat, exactly 10:43 and 6 seconds. Also, did you all know that David Dinetti's actually a very sweet man? Like, I know we get very polemical sometimes when we don't know people, but I just want to let you know I got to read his vibe, and he is actually a very sweet man. He's working a job, like he's doing a job. But I think Alan Jackson, I don't know, I haven't been able to read his vibe like that. But David Dinetti, I am convinced we were all wrong about him, and he is actually a very sweet man. Not that, like, he didn't go a little overboard with the tactics in this trial, but I actually think he, like, at his core is a very decent man. Like, very compassionate man. Not fake either. Like, I think he actually cares. And I think he's like, you know, like, I got hired to win and I want to win. Like, it's my job. And I could see how he got a little carried away, you know what I'm saying? But I think he's actually a decent, sweet man. Like, outside of this case, if I had someone come to me who were like, oh, like, who should I have defend me? Like, I can afford it. I'd be like, oh, you should call David Dinetti. Like, outside of this case. Like, it was only this case I didn't like what he was doing. All right, we got to go to 10:43 a.m. exactly. We got to be good little towels. We got to make our little clip here. We got to make our clip. We got to be good little towels indeed, ladies and gentlemen. So it's about an hour before that. Oh, hold on. Does Karen talk about, someone found a link. Let me click the, oh, it's a YouTube link. Yeah, so we're looking for a very specific click. Paula, in the clip that you have, does it mention the knee? I mean, we can open it right now, actually. 1 second. Hold on, about 20 seconds in. Let's check this. Oh, actually, we can't really, because depending on what this is a clip of, I'm going to mute it. but it depends if this was from in court. Yeah, I don't think we've seen the one we're talking about. Yeah, no, agreed. I agree with you. This is definitely important, but Paul, this is definitely important, but there's a very specific one we're looking for. Let me give people the let me just play it for people one more time if you missed it. It's from yeah, no, it's the knee one, Paula. Let me show it to you actually right now. It's going to pop up on your screen. Let me just move the let me just move this feed down. 1 second. I'm managing a lot while we're waiting for court to come back into session. So take a look at this, Paula. We're looking for this specific clip. It looks like it's from In the Snow, the trial of Karen Reed.
Hit the back of my car, and I hit him in the knee, and he's drunk and passed out and asphyxiated or something. So I thought, could I have run him over? Did he try to get me as I was leaving? And
So anything that we can find related to that, absolutely. So yeah, no, we're looking for this one because what we're now going to do, and I'm going to bring it back up on your screen, we're going to watch the testimony from 10:43 a.m. about John's knee, which is or John's leg, which is very damaging. All right. Let me, it should be when the picture of the leg goes up, so stay with Little Towel. We're going to switch this, watch this, we're going to make this quality go up here. Yeah, I think we can do that. Give it a little second, Little Towels, okay. Now watch this, we're going to get rid of this off the screen, and then we're going to bring this back up on the screen. I'm a little towel. Oh my word, I am a towel. Now I want to get rid of my mouse cursor so you don't see that. There you go. Now watch this. Now what we are going to do is, we don't need the sound, but when we see the testimony about John's leg, we're going to make our recording. Is this it? Oh, see folks, unfortunately when you're that good, you know when it happened.
I'd like to show the jury 9467.
Yes. Okay, 1 second.
You used the abrasion or a scrape. Could you
hold on? Here's what we're going to do.
look at this?
So what we're going to do is we're going to start the recording and then pause it. All right. So give me a second. We got to find the exact moment about the testimony, when the testimony starts.
Yes.
Not just a picture.
This is a picture of Mr. O'Keefe's lower extremities, his legs.
Handing you a photograph.
Okay, let me start up. Hello, folks. My name is Grant Smith Ellis. If you missed it, there was a big moment during this morning's John O'Keefe and Karen Reed trial when state medical examiner Dr. Irene Scodorti-Bello confirmed that there were injuries to John O'Keefe's leg. And you might be wondering, right around his knee, why is that such a big deal? Well, let's listen to the testimony from Dr. Scodorti-Bello and then watch a clip of Karen Reed admitting she thought she might have hit John, clipped him with her car near his knee. Ladies and gentlemen, John O'Keefe injured at the leg area. Karen Reed making statements she thought John, when she last saw John around 12:32 a.m. when Karen allegedly drunkenly backed her car up into O'Keefe and then left John to die on the lawn in a blizzard from hypothermia and a traumatic brain injury, looked not mortally wounded. Ladies and gentlemen, did Karen hit John and cause him to fall to the ground, or did she strike him in some other way with her car, therein leading to John's death? Let's listen to the testimony and then watch the clip.
Doctor, I'm handing you a photograph. Do you recognize what's in that photograph?
Yes.
What is it?
This is a picture of Mr. O'Keefe's lower extremities, his legs.
Is it a fair, accurate depiction of how his knee appeared to the autopsy?
Yes.
All right, we'll go to the evidence, please.
No objection, Your Honor.
Okay.
159. Thank you.
With the court's permission, I'd like to show the jury 9467.
Yes.
You used the word lateral and you talked about abrasion or a scrape. Could you look at this photograph and could we enlarge it, Ms. Gilman, and could you point out to the jury and explain what it is that you saw?
Yes, you can see the abrasion here with a little bit of adjacent discoloration, but this is what I was describing.
Ladies and gentlemen, you saw it. You saw it right there in real time.
Abrasion or a scrape. Could you look at this photograph and could we enlarge it, Ms. Gilman, and could you point out to the jury and explain what it is that you saw?
Yes, you can see the abrasion here with a little bit of adjacent discoloration, but this is what I was describing.
So, folks, you even saw it there on the replay. Let me just show you next, folks. Let me show you what comes next. Listen to Karen Reed herself in her own words, ladies and gentlemen. Let Karen Reed's own words be her undoing in this sense. And we will listen to it now. What does Karen Reed say in a prior interview about John O'Keefe's knee and her the collision with her car? Let's listen.
Hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something. I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. He didn't look mortally wounded as far as, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah.
You heard it, folks. You heard Karen say it herself. Karen Reed thought she hit John O'Keefe in the knee. Ladies and gentlemen, you saw it. You heard it. It lines up with the injuries to John's leg. And now, ladies and gentlemen, I'm going to go back to the towel friend. Watch live when lunch comes back into session. More testimony, youtube.com/@GrantSmithEllis. I'm a towel. Hello, I'm back, towel friends. We did our clip. We did our wonderful towel clip. And so, thanks to Tony, we were able to get the Karen clip with a little bit of music. But alas, what are you going to do? All right, now stay with Little Towel, friends. We are about to come back into session. Yes, look at that, friends. It felt like 5 minutes. We were just hanging out. We were being little towels. We were reviewing the evidence. There's one more thing someone asked us to look at. Oh, the Pilgrim Shadow asked, it might be the next break. We'll look at the damage to her car from the jury view, especially around the upper part near where John's head might have been, and then the diagram of the injuries to John's head. Now, ladies and gentlemen, it's coming up on 1:35. We should be coming back up into session any minute here. I become auctioneering towel. Yes, ladies and gentlemen, if you've ever wondered what would it sound like if a man thought he was an anthropomorphic towel and also thought he was a horse racing announcer and then simultaneously thought he was an auctioneering announcer. Yes, ladies and gentlemen, my name is Grant Smith Ellis, and if you give me an energy drink that has 1,000 milligrams of carnitine, 2,000 milligrams of caffeine, 150 milligrams of alpha GPC, 58%, which doesn't sound like a healthy chemical, and 100 milligrams of neurofactor and 100 milligrams of 4 daily vitamins, while I will be an auctioneering announcer towel, and we will just prepare to peacefully invade Northern Europe in order to reclaim Northern France for the towel people. Oh, ladies and gentlemen, we are waiting for court to come back into session. My name is Grant Smith Ellis. Thank you very much for your patience and for staying with Little Towel as we continue to monitor developments and wait for the start of court. We don't have the Karen cam yet, so I can tell you with affirmation that we do not have the Karen cam, and if we don't even have the Karen cam preview, then we are probably not in session. However, because Judge Cannoni said that lunch was going to be about 45 minutes, and that normally is an hour, I expect us to at most be on break for another 5 to 13 minutes. If someone wants to make note of that prediction, were it to eventually come true, I would then say, I am a towel. And people would say, sir, you are not actually a towel. You are a man who thinks he's a towel. And I would say, yes, that is absolutely true. I am a man who thinks he's a towel, who also thinks he's a horse racing announcer. And then you might say, sir, horse racing announcer, how did that happen? And then I would say, don't blame me. Judge Cannoni is the horse racing official, and the lawyers line up like horses, and the little foals, the horse children, go down the path, and then everyone lines up, and then we begin our session. I don't really know exactly why. I can't really explain it. I am just a towel. And as much as you all may want to say, sir, we have talked about this multiple times. You are not actually a towel. I will continue to say over and over and over again, yes, I am a towel. Yes, I am a towel. Now, you might, and I know we've had a lot of protracted debates about this, and especially when it comes time for us to spend time thinking about what we should do and how we should wait for court to come back, I just start saying things like, listen, I am a towel. And then you all may start saying things like, well, Grant, that's not really analysis. But I already did analysis. And now I want to say things like, ladies and gentlemen, I, Grant Smith Ellis, am a towel. And now you all may then say, well, we know that, Grant. We love that you are a towel. We appreciate your towelness. You know what I would say? I would say that is what makes me very happy. I like being a towel. Oh, no, it's the fan. Ladies and gentlemen, you know what that means. We need to break out the David Yannetti spaghetti and the Chewbacca and the Stay Puft Marshmallow Man image. Yes, ladies and gentlemen, horse racing announcer towel is in the building. We are somewhat working to preserve her horse racing announcer towel's voice. But overall, horse racing announcer towel recovered after yesterday's very, very intense and stressful day. Towel was exhausted, but Towel puts it all on the line for you little towels. Let me just say that. And yesterday I really just felt honored to be able to be in the courtroom to report on KF's testimony. And in that regard, I felt called, ladies and gentlemen, called to serve. And it was my honor to do so. But yes, we are not done with lunch. It is a slow, meandering horse trot, ladies and gentlemen. Look at David Yannetti's spaghetti. Look at it. Love it. Come to appreciate the beauty that is David Yannetti's spaghetti. Now, if there's another update that we can watch, I guess I'll look for a clip for us to watch. But we have pretty much got completely caught up. The morning session was intense testimony. And now, ladies and gentlemen, I will see if I can find us something else to get caught up on as we wait for the return and more of Bob Alessi being a Bob Alessi. And you might say, what is a Bob Alessi? That sounds like an existential question, Grant. What is a Bob Alessi? I don't know, ladies and gentlemen. I don't know what a Bob Alessi is. I cannot define it for you, ladies and gentlemen. All I can let you know is that if I can find us something to watch, we will do so. We already watched the Hank Brennan clip. Let's watch Karen Reed leaving court yesterday like a Karen Reed. She's such a Karen Reed. I can't describe her as anything but a Karen Reed.
Karen John's niece was on the stand. Any reaction to her testimony?
No comment.
How about in terms like to see her?
No comment.
We've heard a lot of talk about
Slow, Brad. Slow. And the hearing is issues that came up prior, correct?
Are you feeling better, Karen? Hi, Esty. And then, folks, of course, there were two new clips played of Karen Reed in court yesterday before KF's testimony. We'll take a look at those a little bit later. But if you missed it, we'll do it again. This was the moment. That people really like talking about this moment. I don't understand, but here it is. You as well, Mr. Brennan. Okay, sir, I will, Hank. Artworks, too. It's so good to see you, dear friend. This is the moment the world's talking about. You as well, Mr. Brennan. Okay, sir, I will, Hank. I'm such a towel. And then this was Mr. Bill Reed, Mr. Reed, with his comments at caught. His daughter went down the park. She had to go down the park. His daughter.
She said, fire it up. needed more sleep than she got, I guess. And so she's doing fine.
It's not related to her long-term health issues.
Well, I mean, she does that ability to maintain your health and maintain your strength is indiscernible. It's something that is very strong. Her. So, no, it wasn't. It was just she was run down. Everything that they worked through the weekends. I mean, these are people that tremendous amount of hell of an effective job.
Bill, what do you make of the hair on the bumper that made it out to Dighton and back in a snowstorm?
Well, listen, I'm a reasonable man, and I drove the vehicle there, and I did, by the way, clean off that bumper with my hand. I didn't mean to bring that off from your hand, but so it's pretty remarkable, right? Glass traveling, as well as the hair.
All right, ladies and gentlemen, I hate to break in, but the Karen cam is up. I repeat, the Karen cam is up. Ladies and gentlemen, I am a towel. My name is Grant Smith Ellis. Get ready. We're switching screens. The Karen cam is up. David Yanetti's spaghetti is across the table. The Stay Puft Marshmallow Man is shocked. Ladies and gentlemen, look at what happened. Oh, my word. No, they did not win, Beach Nets. There was nothing to win. The buffer zone is still active. There's been no modifications. It just has a mens rea requirement. It's still intact, exactly the same as it was before. It just means that they will absolutely enforce it more strictly and just say you could tell you were violating the mens rea requirement. Oh, ladies and gentlemen, yeah, it's absolutely bad for them. But listen, folks, we got to go over to the screen. I'll see you after. No audio yet. No audio yet, but we see the lawyers beginning to walk in the court. It'll pop up on your screen any second now. I'm a towel. My name is Grant Smith Ellis. And yes, the Hinden Reed is collapsing. And we are here to watch it. The good ship Hinden Reed. Oh, the humanity. Oh, the humanity, ladies and gentlemen. Yeah, exactly. Mandy Strong is right. Turtle Boy did not understand what he was reading, and he probably was just saying things to try to encourage people to go into the buffer zone, in my opinion, which is only going to get them in trouble because Turtle Boy is not, in my opinion, very intelligent. All right, ladies and gentlemen, we're preparing the Karen Cam. I repeat, we are preparing the Karen Cam. We're being good little towels. We are being good little towels. My name is Grant Smith Ellis. Towel is exhausted from his trip to the courthouse yesterday. It was so tiring, but we did it. Towel did 8 hours, ladies and gentlemen. Now I'm back with you. I repeat, I am back with you, ladies and gentlemen. We sit, we monitor like good little towels, and we wait for the return of session. I repeat, oh, there's the Karen Cam. It's not up, but we have it ready. Oh, ladies and gentlemen. Oh, the humanity. Oh, the humanity. Right, Turtle Boy is just saying things. I don't understand why. I get that you have to debunk it, but when you why does anyone read it and say, oh, I should go talk about this? He must be right. He's just saying things, in my opinion. So when you repeat it, and we have to debunk it, it sets this tone as if anything he had to say was relevant. Now, listen, I'm not critiquing the person who brought it up now, but just, folks, generally understand, when people just say fake things, okay, they're doing it so that you will talk about it and believe it. So don't read that stuff. The one thing Turtle Boy doesn't want is for you all to just not read his stuff. So just don't read it. Literally, just don't read it. Every time you read it. They are weekly, Tom. I can go. I have a week. I was there this whole week. It is very hard for me to do that. Like, I mean, even right now, I barely made it through today. And yesterday, my body was not doing well, so I could have gone today, but I didn't. So you know. But anyway, there aren't even 10 people there. There's the media hasn't really been clamoring to like go cover it. There's other stuff going on. So, yeah, I just couldn't go. I was so exhausted. That's great, Jill D. From Profiling Evil. Thank you for sharing that link. Let me actually try to grab that link in the chat. I actually don't want to share their content unless I talk to them first. Like, I don't want to put it on the screen, but I'll save that link, Jill. Thank you so much. Yeah, exactly. But if you all, do you realize the what Turtle Boy's numbers? I was looking at some of the other Karen Reed streams. He's dropping below them. Folks, we're in session. I'm a towel.
You are unmuted.
Excuse me, please.
Please rise for the jury.
Oh, the water? I'm good. Thank you. I want to know about the bathroom break.
Court is in session. Please be seated.
All right, Mr. Lessie, whenever you're ready.
Thank you, Your Honor. Good afternoon, Dr. Scordi-Bello, and welcome back.
Thank you.
I want to move on to a slightly different aspect of the hypothermia discussion. So, you've acknowledged previously that hypothermia is a very difficult diagnosis to make, correct?
Correct.
And you acknowledge that in your grand jury testimony in this proceeding, correct? Do you recall that?
I do.
And you indicated in that grand jury proceeding generally that diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right, and the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
you diagnosed Mr. O'Keefe with hypothermia based upon certain medical data that you believe you observed in the gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, to just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ. And in your autopsy, the lining of both the stomach and the pancreas, is that correct?
I'm sorry, what was the word you used?
Let's start with the stomach. Did you observe the lining of the stomach as part of Mr. O'Keefe as part of the autopsy?
Yes, I observed some hemorrhages in the lining of the stomach.
We'll get to that, right? But I just want to talk about the organs and what aspects of the organs first, and then we'll get to that. And with regard to the pancreas, what aspect of the...
As well as the pancreas itself by making several cuts.
And there was also a histopathology report that was relevant to both the pancreas. T-O-P-A-T-H-O-L-O-G-Y. So that histopath information informed your hypothermia analysis, is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So, do I have it correct, and let's start with the pancreas, that you noted the pancreas was congested and diffusely hemorrhagic? Do I have that correct? And you feel free to look at your report, please.
I will.
And I specifically, if it helps, I'm looking at the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1, and then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And then, and the next page is the histopathology.
Yes.
All right. Are we sort of oriented in the same location?
Yes.
All right. So let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion and patchy parenchymal, that's P-A-R-E-N-C-H-Y-M-A-L, hemorrhage, autolytic changes. Did I read that correctly?
Yes.
And I want to go at these one at a time, so now I'm going to jump back to the previous page where you discussed the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you see the last sentence says the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of hypothermia?
The determination of hypothermia was made, yes, based on these findings and the circumstances I was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but it's sort of the medical legal construct that we were talking about. I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back, as we did with the pancreas, for the stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And one aspect of that information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were, I'm sorry, I will. Thank you, Your Honor. Do you recall the death notification report in this matter?
I do recall, the very initial first information that comes in. That's the death notification given to our intake staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me, but I can tell you what the gist of it was.
Would it be helpful to you if I showed you a document that might refresh your recollection on what that, a document that may refresh your recollection?
She said sure. I don't think you heard her.
I did. Thank you, Your Honor. May I prove? May I approach, Your Honor?
Yep.
Thank
Just
you.
show Mr. Brennan.
Yes. May I approach, Your Honor?
Yes.
Dr. Scordi-Bello, what I'd like to do, you can read anything you want, but I'm just going to reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you just that section up to here. And once you're done, if you could kindly look up and let me know.
Okay.
Dr. Scordi-Bello, did that refresh your recollection with regard to the circumstances of death section of the death notification report?
Yes.
And you could please state now what your refreshed recollection is on that topic.
Yes. The initial intake death notification was made by a physician at the hospital, and it stated that we were dealing with a adult male that was found in a snowbank. There was note of having been at a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
sustain.
Strike.
Jurors, disregard that. Move on with this, Mr. Leslie. With this, but just move on.
Yeah, yes. In terms of the differential diagnosis concept that we were talking about before, based upon your refreshed recollection of circumstances of death as discussed in the death notification report. Based upon that, did you consider whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
Objection. I'm going to allow that.
Initially, no.
Let's go to significance, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in the autopsy, correct?
Correct.
And is it correct before the grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment? Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments? Do you recall any testimony?
I'll see you at 10.
We have a sidebar. My name is Grant Smith Ellis. Sidebar. I'm with you for the rest of the afternoon, which means you get to hear me say things like, we have a sidebar. Ladies and gentlemen, we have a sidebar. Sound the sidebar alert. Ladies and gentlemen, we have a sidebar. Will Bob Alessi end his cross before 4 p.m.? The world says no. The world says no. Who called the sidebar? It was Judge Canoni calling the sidebar. Ladies and gentlemen, you know that what this means. We have a sidebar alert. Oh no, ladies and gentlemen, a sidebar alert. Bob Alessi is just trying the confusion tactic. Bob Alessi has deployed the infamous Chewbacca strategy. Confuse the hell out of the jury. Oh, ladies and gentlemen, it is agonizing, and the world thinks we're going to be at the sidebar and in court until after 4 on this long, tormented cross so that Bob Alessi and the other horses can't go down the park. They got to spend their time running around in circles, going nowhere. Hank Brennan's the only person who seems to understand the point, which is to get to the finish line, not run around in circles talking to people about Chewbacca and the Stay Puft Marshmallow Man. Oh, yes, ladies and gentlemen, the humanity of the good ship Hinden Reed going down. Oh, the humanity. I don't even know how to analyze what Bob Alessi's doing. He is not making a lot of progress, and he's boring everyone. He's lost the room again. He is a Bob Alessi, and we are at sidebar, ladies and gentlemen. Yes, we stare at Bill Reed as horse racing announcer towel gets us ready for the sidebar to end. Hopefully the horses are getting some carrots at the sidebar. You can't just bring a horse to a sidebar and then not give it any carrots. It'll be like, what are you doing? Except horses don't speak English that we know of. But it would speak in horse language, and probably in a very perplexed tone, and tilt its head and be like, I'm at the sidebar and you didn't give me any carrots. Now you might be like, Sir, I am watching coverage of a criminal trial. What the hell are you talking about? Well, listen to me. You try, Liz. I am making more sense than Bob Alessi, okay? I swear I am more coherent right now than Bob Alessi. Yes, ladies and gentlemen, the horses eating carrots at the sidebar is somehow more coherent and more relevant than Bob Alessi's cross. I don't know how this has happened. Ladies and gentlemen, here comes Little Towel down the stretch. Oh, Modelo Macy is trying out to be horse racing announcer Towel. Ladies and gentlemen, ladies and gentlemen, the humanity of the good ship Hinden Reed. I thought, it's almost over. The sidebar is almost over. Save us from this cross. We're almost back in session. My name's Grant Smith Ellis, and I'm a towel.
May I, Your Honor?
Yes.
Thank you. At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. You recall that?
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct.
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation?
It's possible.
Do you know what a Lucas machine is?
Yes.
And a Lucas machine is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having to exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so, yeah.
So, when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging, wouldn't you?
Where?
In the stomach? In the pancreas? Would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine could cause hemorrhaging in the stomach?
Personally, I have not seen it in that context.
But do you rule that out?
I can't rule it out. I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset of the stomach, right? You're talking about the gastric rugae.
Talking about the inner lining of the
inner
stomach.
lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach, in the soft tissues of the torso.
Okay. So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine, and assume 100 compressions per minute. That would result in 3,700 compressions from a Lucas machine, correct?
Correct.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation could be why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you consider that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees, my opinion was that those hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
My question was, does your report state anywhere the words Lucas machine?
No.
And you agree that a Lucas machine can cause hemorrhaging to the pancreas?
It can cause hemorrhage in a lot of tissues.
But including the pancreas?
Including the pancreas.
If you see hemorrhaging of the pancreas and you believe that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to have a spelling of that. Doctor, can you give us the spelling of that?
Would you like to give it?
If you'd like me to, I'm prepared
Go
to
ahead.
give it. Thank you. Wishnewski. So, can you just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots are small hemorrhages, small areas of bleeding in the mucosa of the stomach that are thought to be associated with hypothermia, amongst other things. They're believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't.
Do you recall?
Hold on.
Okay.
Move on. The objection sustained. So
Okay.
you're asking it. Yes. Go
Okay.
ahead.
Thank you. There were no Wisniewski's ulcers present in Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
You mean the stomach?
I'm going to start with the pancreas.
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that. So now I want to move to the stomach.
Okay.
Do you believe all hemorrhages in the stomach are Wisniewski ulcers?
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer but not have hemorrhaging.
You could, but ulceration would manifest in what we call hemorrhage. The actual appearance of it.
What I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with Your Honor's permission, publish some depictions of first the gastric mucosa, and then start with that, Your Honor. Publish that.
All right. So this is the one that we have not introduced into evidence openly, but at sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
Start with that.
What number?
Your Honor, just to...
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
Yes.
It's Friday.
Pardon me?
It's N Friday.
And I'd like to move N into evidence at this time.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
It's 164.
May I, Your Honor?
Yes.
Dr. Scorbello, I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at on the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164. Dr. Scordi-Bello, do you recognize 164 as the, well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface is the mucosa. That's the lining of the stomach. And you had used the word rouge before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was, correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to them as hemorrhages.
Correct.
Okay. So what I'd like to do now is to, if I may approach, Your Honor,
yes,
for the chalk.
Exhibit MM.
With your Honor's permission, may I show Dr. Scordi-Bello the chalk that's marked for identification? Is that
Yes, and let's see what she answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Dr. Scordi-Bello, could you please take what's identified as Exhibit M and see if you can identify what that depicts?
Yes, this is a picture of a stomach. Again, the mucosa with hemorrhage.
Just hold for the, sorry, not your fault.
Your Honor, can we take a break?
Yes.
Jurors.
Yes.
Rise for jury.
Oh, this is bad. Oh, hello. We're going into recess.
I'll see counsel at sidebar, please.
Sidebar. Ladies and gentlemen, we have a sidebar. My name is Grant Smith Ellis. If you just missed it, the jurors had to actually stop. Bob Alessi caused the trial to come to a stop by showing the jurors. Oh, my dear God. Oh, my dear God. Oh, my dear God, Bob Alessi, what have you done? Oh, my God, Chewbacca and Marshmallow Man speak for us all. Holy shit, that was a moment. That was a moment. Oh, my dear goodness, ladies and gentlemen. Bob Alessi, you
hey
moron.
Hey there, Karen Reed trial watchers. So we know that
Sorry.
you're true crime fans, but are you also in a business?
Bob Alessi, you moron. You absolute moron. What are you doing, you crazy man? How could you have done that? Oh, my God. Bob Alessi caused the jurors to call a halt. Oh, my dear God, ladies and gentlemen. Oh, my dear God. Look at Chewbacca and the Stay Puft Marshmallow Man. Oh, my God. Look at those two. Look at those two. Bob Alessi showed the jurors pictures of John's stomach after it was excised from his body during an autopsy. And the jurors called a stop to the trial. Oh, dear God. Oh, dear God. Oh, my word. All right, we have to pull it back a few seconds. Hold on, little towels. Hold on, little towels. That was horrifying. Hold on, little towels. Bob Alessi, you moron. No. That was a court officer. That was a court officer. I know that voice. That was a court officer. Folks, that was disturbing. I don't know if you just missed it, folks, but we had to literally stop the middle. No, it wasn't. No, Beach Nance. I'll rewatch it, but why would Alessi have called? No, hold on. No, hold on. Stop. We're going to rewatch it. We're going to rewatch it live. We're not guessing. I know that voice, folks. We're going to rewatch it. It was right around 2:26, so hold on. It wasn't Yannetti. I'm telling you, it was a court officer. I know what I was listening to. Sorry, I'm not getting frustrated with you all. It's just I know what I was listening to.
And you had used the word hemorrhage.
Hold on.
And let's see what she answers.
It's identified as Exhibit M.
I'm replaying it now, folks.
You can identify what that.
No,
depicts.
Yannetti didn't call for
Yes,
it.
this is a picture of a stomach, again, the mucosa with hemorrhage.
Just hold for the sorry, not your fault.
Your Honor, can we take a break?
Yes.
No. That was a court officer.
Your Honor, can we take a break?
Yes.
Jurors.
Yes.
All right, pause.
Your Honor.
All right, hold on. We got to record this. Oh, my words, ladies and gentlemen. Grant Smith Ellis here. The Karen Reed defense via Bob Alessi has just made a major tactical error in the afternoon session of day 17 in the John O'Keefe and Karen Reed trial. Oh my word, Bob Alessi showed the jurors pictures of the insides of John O'Keefe's stomach, excised from his body after his autopsy. Immediately, within a minute, jurors asked their bailiffs for a break. Ladies and gentlemen, we're going to watch the moment. Thankfully, the stream didn't show the pictures. Ladies and gentlemen, the Bob Alessi, for no reason, this has to do with whether John O'Keefe had hypothermia as a result of Karen Reed leaving John O'Keefe on the lawn after allegedly striking John with her car, causing a traumatic brain injury. And then John's phone indicated he never left the spot on the lawn after 12:32 a.m. and 16 seconds on January 29, 2022, when Karen Reed, with a blood alcohol level of 0.14 to 0.28, which is 2 to 4 times the legal limit, backed her car up to 24.2 miles an hour, reducing to 23.7 miles an hour at the moment of impact with a 4.7 degree steering wheel correction to the right, and then left John to die on that lawn with his body temperature getting as low as 60 degrees or so the next morning. Ladies and gentlemen, Bob Alessi didn't have to do this. The jurors must have got sick. They asked their bailiffs for the first time in the trial to stop the trial. Let's watch the moment. I'm a little towel. Oh no, I clicked the record button again. But I guess, no, I'm not putting them together. Yeah, okay, I can. Hold on one second. I wish I had been able to make that as one clip, but I couldn't. All right, stay with me, little towels.
Your Honor, can we take a break?
Yes.
Jurors.
Yes.
Rise for jury.
That was the moment, ladies and gentlemen. Bob Alessi should not have done that. That's the worst possible thing that could have happened. Oh, ladies and gentlemen, very bad day for the Karen Reed defense. Tune in live, youtube.com/@GrantSmithEllis. Watch how this all unfolds when we get back from break. Oh, that was bad. That was so bad. I can't believe Bob Alessi made that kind of unforced error, and we saw it in real time. Little towels, my name is Grant Smith Ellis. That was absolutely wild. Now we are monitoring. We have a live look into the courtroom cam. It is live. The fan is spinning. It is still spinning, ladies and gentlemen, but we don't have to watch it. Why? Because we have a view of something else. But ladies and gentlemen, my word, moments, scenes, friends, scenes, absolute scenes. The Karen Reed defense just in shambles. In shambles, ladies and gentlemen. The worst possible outcome is a juror having to request that, yes, that's what I'm saying. It's at the request of a juror, ladies and gentlemen. We just heard it. Worst possible thing to happen to Karen Reed. Oh, my word, ladies and gentlemen, my name is Grant Smith Ellis. How can this keep happening every day? There's something just absolutely ridiculous that happens, ladies and gentlemen. Absolutely absurd moments here in the John O'Keefe and Karen Reed trial, as now the defense has shown pictures of John's excised stomach to the jury, causing them to literally have to stop the trial. Oh, my word, ladies and gentlemen. Oh, my word. Oh, it was the worst of all worlds. It was the worst possible outcome for the Karen Reed defense. And now, as little towels, we have to render this. Oh, God, ladies and gentlemen, it was a horrible moment. Oh, the Karen Reed defense just in absolute shambles. Oh, how could this have happened? Oh, the humanity. We were just talking about the good Chip Hinton Reed. The good Chip Hinton Reed has gone down. It has gone down, ladies and gentlemen. Just in truly shocking moments. Karen Reed's lawyer, Bob Alessi, brought proceedings in the John O'Keefe and Karen Reed retrial to a halt at the request of a juror. For the first time, Alessi showed jurors pictures of the inside of John's stomach after John's autopsy for no good reason. Within seconds, a juror asked their bailiff for a break. The jury is going to be furious with Reed's defense for showing them the inside of John's stomach for no reason, gratuitously, and only for shock value. Alessi was literally only showing this to get confirmation that John died from partially from hypothermia after Karen allegedly struck John while drunk driving and then left John alone in a blizzard on a lawn with a head injury. Oh dear God. Oh dear, it is all crashing down for the Reed defense in real time. No, we do not know how long this recess will go on, but there is confirmation it was requested by a juror. Oh, Bob Alessi literally stopped proceedings. Oh, dear God, ladies and gentlemen. Oh, dear God. Oh, the humanity. Oh, the humanity, ladies and gentlemen. I am a towel, and even I cannot appreciate how stupid Bob Alessi is. Oh, you a moron. Why would you do that? You have no idea how upset the jury is going to be. Oh, my God, you made one of the jurors ask us. They're probably puking. Oh, dear God, you moron, Bob Alessi. And I'm not saying this to be mean, you can't do that to your client. They're going to hate, all the jury's now going to be like, look what you did to our buddy. How could you do that, Bob Alessi? Oh, dear God. Yeah, I don't know if we can continue. Throw in the towel, Bob Alessi. Stop this. Oh, my God. That's what it took for Bob Alessi to get the message. A juror almost fainting or having to vomit. Oh, dear God, the humanity. It's actually appropriate for me to say, oh, my dear God, the humanity. The humanity of it all. Dear Jesus, somebody save us from this. What has this become? Oh, my God. Dear Lord. Oh, please, this is the worst. I can't. It has no tactical value, and it is the most horrifying thing to happen if you're the defense. Holy wow. What do I say? I don't know what to say anymore. Oh, my God. Ladies and gentlemen, there was no point unless he pushed it way too far. Oh, some kind of divine retribution in the form of the jurors literally getting sick. Oh, dear Lord. Just scenes, ladies and gentlemen, scenes. Unheard of scenes. Bob Alessi, what are you doing? What are you doing? You literally, Bob Alessi, you injured the jury. How do you do so badly on cross that you hurt the jurors? Oh, God. Oh, ladies and gentlemen. Oh, the humanity of it all. Oh, the Reed defense. Oh, literally the humanity. I don't know what to do anymore with myself. What do you want from me? Oh my God, this is ridiculous. It's absolutely absurd. Oh, Christ. I don't know what to do anymore. I don't know what to say. How does this happen? Oh, why? Somebody tell me why. Why do I have to write these words on the paper? Why is this happening? Oh my God. Oh. It makes no sense. It was for no reason. There was no tactical value to it. I am not yelling gratuitously either. I'm not reading your comments. Not that anyone's saying I'm yelling gratuitously. It was so pointless. Oh my God. Oh my dear God. Ladies and gentlemen. Ladies and gentlemen. Oh my dear Lord. Bob Alessi, this is beyond madman territory. This is, you screwed your client. You screwed her. Why? Why would you do this? Why? Why would you do this to the jury? Like you're losing them? My God, so you friggin' show the inside of John's stomach? That's not gonna shock them back into attention. You made them collapse. You made the jury leave the room. They literally probably had to go vomit. Bob Alessi, how is it? How am I saying these words? Bob Alessi, what is wrong with you? Oh my God. I'm not blaming the judge. No, hold on. Beach Dance, I think what Beach Dance is saying is there was a juxtaposition between how the jury got their instruction about John's autopsy photos and then that. Judge only told him it was graphic. She didn't, are you kidding me? She didn't tell them there was going to be that. Oh, yes, it's allowed. You can, listen, we talked about it earlier. You have to allow medical evidence. You have to. It's very important, crucial components of the case. But not like that. You didn't have to do it that way. Like, no, I'm not talking about Judge Cannoni, but like the defense has a right to introduce it. But the way that went down was abhorrent. Oh, my dear Lord. That cannot happen. It cannot happen. Oh, dear Lord. I don't even know what's going to happen from here on out. We're going to stay with this. We're going to monitor it, Little Towels. Court is still on a break. Who knows if we're going to come back into session at this point. Oh, my word. What is, literally, you heard me yelling. I was not yelling there in sardonic mockery. I was yelling there because I'm furious. Well, I'm furious as to Bob Alessi doing that. I'm also incredulous because you don't know how much this will hurt the defense. Every single juror knows that what Bob Alessi just did, he literally hurt the jury. How do you hurt a juror? In a trial, you have to be so bad at life as a lawyer to literally physically hurt the jury. Oh, God. No, yes, so it's allowed. You can present this evidence, but you got to do it. You have to say, okay, you can close, like Bob Alessi, it's his job, it's his evidence. He has to say something like, okay, you're going to want to close your eyes, but you'll be able to review this. He just showed it to him. That's what I'm saying, and the jurors are going to be like, no, it's his stomach. Like, it's just about the hypothermia. Why do we have to see this? At least tell us we don't have to look at it. We'll look at it in the jury room. He didn't do that. It's his evidence. The jury is going to, listen, this is not like the prosecution brought it up so the defense had to rebut. The jury is going to hate Bob Alessi over this. He did it. This is not an unforced error. He hurt a juror. He caused a juror to have a breakdown or vomit or collapse, whatever. It doesn't matter. Bob Alessi induced it, and he'll pay for it. The juror is never going to forget their whole life. Forget about during deliberations. They are just always going to be thinking of, oh, my God, Bob Alessi made me collapse. Oh, dear God, help us. I don't know what we're going to do here. Okay, we're coming back into session. Hold on, little towels. Hold on. Hold on. It seems like the juror has composed themselves.
Please be seated. Court is in session.
All right, Mr. Alessi, you can continue where you left off.
Thank you, Your Honor. May I reapproach the witness?
Yes.
Does that exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence.
I object to anybody as a chalk.
I'll, you know what, if I can use it as a chalk
Yes, you
publication.
can.
Yeah, that's what I'll do, Your Honor. Thank you, Mr. President.
So you can have it displayed.
Thank you. And again, I'll leave this hard copy with the court reporter, and we'll use the screen.
Oh, so it's not in evidence?
It is not.
It's marked for identification?
Yes, marked for identification, and we are with it. Mr. Wolf? Dr. Scorti-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
All right. The objection sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's gastric mucosa?
Yes.
Isn't it correct, Dr. Scorti-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So, you can take that down, Mr. Wolf. Isn't it correct that for hypothermia and the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage of the, and I'm trying to avoid putting it up again, so what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10 and 15%.
Just 10 and 15%. Thank you. Now, if we could look to the issue of continuing with hypothermia. Let's go to frostbite. Do you note any evidence of frostbite on the deceased, Mr. O'Keefe?
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early mornings? I'm sorry, I keep saying Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29, 2022, going through 6 a.m. on January 29, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusting winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusting winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature in a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
Dr. Scordi-Bello, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, There were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Objection.
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident?
Objection.
I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
And can you elaborate to the jury what you mean by no evidence of an impact site?
Objection.
I'm going to sustain that objection.
What do you mean in your answer, no evidence of impact injuries?
Objection.
I'll allow that.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct? Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So, you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain, from that impacted back of the head, a laceration to the nose, correct?
Correct.
So if we could, Mr. Wolk, and with Your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scortibello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Oh, let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could.
Okay.
Dr. Scortibello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
Exhibit 165.
Thank you.
Yeah, Your Honor.
Yes.
Thank you. Dr. Scortibello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolf publish 165? Thank you, Mr. Wolf. So, Dr. Scortibello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury, you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt impact.
Blunt impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch? Yes.
I'll allow it.
Could be consistent.
If we could, Mr. Woke, have the laceration to the nose. I'm sorry, hold off on a moment. Your Honor, Mr. Brennan has agreed to stipulate that this going.
Okay, so like we can mark it.
Exhibit 166.
Oh, thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scortibello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolf, publish.
Yes.
Thank you. Dr. Scortibello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that down, Mr. Wolf. On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With Your Honor's permission, I would like to
Mr. Brennan.
Your Honor, Mr. Brennan has agreed to stipulate into evidence these two photographs. May I please have them marked as next evidence?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Scordi-Bello. I'm going to leave these with you, but I'm also going to leave the court's permission to have them published.
Okay.
Use whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries to these wounds to Mr. O'Keefe in your autopsy report?
Yes.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those patterned wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, couldn't hear you.
Ask another question. Sustained.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So, can you answer that, Doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So, were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No.
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you had doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
Thank you for answering my questions, Dr. Scordi-Bello.
You're welcome.
All right, thank you, Mr. Leslie, Mr. Brennan.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained is to the point.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe, and you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes.
Is it important to have a complete statement rather than just part of a statement?
Yes.
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago.
Okay.
But I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question?
Yes.
And he read part to you, right? I understand your question, and my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that question.
Do you remember Attorney Alisi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this thing.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show her the statement.
Okay. I can approach. I'm going to ask you to take a look at part of your grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
Were you asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Did you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes.
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it. Turn it over. Turn the paper over, please.
I can take it, Your Honor.
Ask the appropriate questions to Gordon.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names?
Correct.
You said that there would be a log identifying names?
It would be a log, yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Lesson.
It's part of the end report. Take a look at your report. You have it.
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brennan.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature?
Yes.
Objection, Your Honor. Scope.
No, it's within the scope. Let's see if she's got the basis for it.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there was any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Objection, Your Honor.
Sustained. Sustained. Move on, Mr. Brennan.
You were shown a photograph, a chalk, that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was A preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay.
May I hand the witness another document?
Let us mark it.
Oh, sorry. I may have that back.
Yeah.
2Q for identification.
Thank you. May I approach, Your Honor?
Yes.
Second document, was that another document in your file?
Yes.
And is that another report to be considered?
Yes.
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification.
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory. I'm going to hand you a document. I'm not going to ask you to read it aloud. I'm just going to ask you to look at it. Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You would never, well, let me ask you. You submitted the death certificate on April 14th?
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant...
I'm going to allow it.
That the defendant said, I hit him, I hit him, I hit him. Were you aware of that?
I became aware of it at some point.
During your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I hit him?
Objection, may we approach, please? Briefly.
Okay.
Cyber. Ladies and gentlemen, we have a sidebar. Hank Brennan is on his redirect of the medical examiner, Dr. Irene Scudordi-Bello, and Bob Alessi tried to take things out of context based on what the medical examiner knew during the autopsy, and now Hank Brennan's going into what the medical examiner learned over time because she is not a police investigator, and Bob Alessi freaked out 3 questions in. Oh, folks were wondering, how is Hank Brennan going to turn around Bob Alessi sabotaged himself on cross by causing the jurors to ask for a recess because Bob Alessi showed pictures of the inside of John's stomach, stupidly, and now the jurors are going to be furious. We're about to be done with sidebar, but now the Hank Brennan is correcting all the out of context information that Bob Alessi tried to present to jurors during cross, and now Hank Brennan's showing that Dr. Scudordi-Bello learned even more after her autopsy findings about Karen Reed's confessions to hitting John O'Keefe. Here we go. We're coming back into from sidebar. I'm a towel. Name Grant Smith Ellis. YouTube.com/@ Grant Smith Ellis. Tune in, watch, join the chat.
So, jurors, I want to let you know that, like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scudordi-Bello's knowledge and state of mind at the time of her report.
Thank you. At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Miss McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes.
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
About their
observations?
Yes.
Okay. Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead?
Yeah, I was given that information.
And the questions of did I hit him, were you aware of that?
Yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes.
Were you aware of the statements that she made to the troopers?
Not in detail.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll allow that.
Yes, I was provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
Okay. How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that form.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes.
And you offered that was not consistent with falling backwards on the head alone.
Correct.
You were asked if that was consistent with a punch.
Correct.
Objection, Your Honor.
That's not the testimony. That's your objection.
That is, Your Honor. There's not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could it be consistent with first aid treatment?
Anything is possible.
Do you have any first-hand knowledge of how the laceration on the nose happened?
I do not have first-hand knowledge.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Lessie.
Thank you, Your Honor. Dr. Scorti-Bello, Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol, too, you said, right?
Correct, Your
Go right
Honor.
ahead.
Yeah, Coach, Your Honor.
Yes.
Dr. May I, Your Honor?
Yes.
Dr. Scorti-Bello, may I stand by the witness there?
Yes.
Thank you. Dr. Scorti-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Right. Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes.
And that medication is?
It's an antacid.
Right. And so omeprazole is the trade name of omeprazole Pepcid?
I believe so.
And Pepcid is a proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scordi-Bello.
All right, doctor, you are all set.
Thank you, Your Honor.
I'm going to see counsel at the sidebar.
Sidebar, ladies and gentlemen, you heard it. John O'Keefe's injury could well have been caused by a side swipe. Ladies and gentlemen, oh my word, ladies and gentlemen, we are at sidebar. We are at sidebar. My name is Grant Smith Ellis, and I am a towel. There was the moment John O'Keefe's injuries, especially to his leg, could have been caused by a side swipe. Oh, ladies and gentlemen, 1 second.
Okay. How about a side swipe?
Ladies and gentlemen, that was the moment. You heard it, little towels. My name is Grant Smith Ellis. We're at sidebar. We are at sidebar. What will happen next? Oh, the day is just full of surprises. Oh, ladies and gentlemen, the honorary towel spouse, Mandy, her faith in Hank Brennan came through in the end, ladies and gentlemen. Never lose faith in Hank Brennan. It was a tough witness. This witness is just a pathologist who had no idea what was going on at the time because the case developed so rapidly over a period of days and weeks. And so when the initial report was written, there was so little context. Over time, more context was provided. And importantly, sideswipe impacts from the back of vehicles are not what medical examiners see very often. Oh, ladies and gentlemen, very bad day for Karen Reed. Very, very, very bad day. An interesting day for towels. There were some moments there where I was as infuriated as Hank Brennan, I think, at what Bob Alessi was trying to do. But my word, never doubt the Hank. We're allowed to call him Hank because he said, call me Hank. Ladies and gentlemen, never doubt the Hank. You can't do it. You can't doubt the Hank. Ladies and gentlemen, you must have faith in the Hank. We don't know what's going on in terms of what's going next. Hold on.
So, jurors, that is it for today. I'm told that we are on schedule. So with that, I'm going to let you go a few minutes early. So please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media. So we'll see you tomorrow morning.
The rest of the jury.
Stay, ladies and gentlemen, stay tuned. We'll see what's going on next. My name is Grant Smith Ellis. Will we be here for a motion hearing? Will that be the end of the day? Ladies and gentlemen, the medical examiner's done testifying. We'll do our recap shortly. For now, we watch the courtroom, we monitor, we see what's going on. My name is Grant Smith Ellis, and I am a little towel. We have a recap to do. Oh my word, that was a bombshell moment. The medical examiner doesn't normally see front impacts, but when she was to learn more information and the possibility of a side swipe was presented, that could have caused John O'Keefe's injuries. Oh, here we go. Wait, hold on, stay here.
You may be seated.
All right, so Mr. Alessi, I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. first is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. Now, I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA. It's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture, and we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that?
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARCA at all.
So tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffin. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffin based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
All right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the ways, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. On my case in chief, because we now have this available data. As I said, this wasn't ambushed. It isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DiSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
trial. All right, I thought Burgess was, no?
No, neither. Okay. No one from Aperture was.
I knew Aperture was, and I thought he may have been something. The name just sounded.
Neither Burgess nor Welcher were part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding, fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it's going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, and to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. You've heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon, because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We will go to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No. No, because Dr. Welcher relies on Shannon Burgess's information and material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
All right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double re-rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
All right, we're done for the day. Folks, my name is Grant Smith Ellis. That was, oh my goodness, Hank Brennan, folks. Hank Brennan has information from Karen Reed's Lexus infotainment system that there was a collision event exactly around the time, exactly the moment John's phone stopped moving. My name is Grant Smith Ellis. YouTube.com/Grant Smith Ellis. We will do a recap in just a few minutes from the Towel Friend. Oh my word, that was that was stunning. That was incredible moments to watch, folks. And then at the end there, what you were listening to was Reed's experts from ARCA turned over. There was a bunch of Rule 14 violations because Reed hid payments and contacts with ARCA from the court and from Hank Brennan for a while. Eventually, they were disclosed. Reed's experts then got a deadline by the court to finish their testing. They finished their testing for this retrial, turned in documents, and now Hank Brennan's expert has found serious flaws that led Brennan's expert to now have to do his own testing. And so Brennan was saying, okay, I need to call my expert in my case in chief. Then Aperture's going to testify about their report. Then I need to call my expert in rebuttal. And then Alessi's argument was, well, that creates a right of sur rebuttal for us. But really, it was the defense who caused this. Oh, ladies and gentlemen, that was not even the least of the moments. Bob Alessi today, we'll talk about it during recap, caused the jury to ask the trial to stop for a little bit because he showed pictures of the inside of John's stomach. Oh, it was horrifying, ladies and gentlemen. And earlier, in one of the biggest moments of the day, the medical examiner confirmed that John's injuries on his leg or otherwise could have been caused by a side swipe with a vehicle. Oh, from a vehicle. Oh, ladies and gentlemen. Oh, ladies and gentlemen, my name is Grant Smith Ellis. What a day. What a day. I think Hank Brennan is very upset at Karen Reed's lawyers for the ARCA situation because Reed's lawyers may have done some serious misconduct and Hank Brennan's expert might be onto it. And the Lexus infotainment system data. Oh, ladies and gentlemen, it was a day. All right, folks, I finished the clip. You and I got to talk. We have to talk, Towel Friends. Oh, my word. Oh, my word. I've never seen something like it in my entire life, ladies and gentlemen. Ladies and gentlemen, we are Towels. We are here. We are doing what we need to do. We have a few things we need to do. Number one, we need to upload that motion hearing. That came out of nowhere. It was absolutely explosive. I cannot believe we just learned in a matter of seconds, folks, that Hank Brennan has information from Karen Reed's Lexus GPS infotainment system of a collision event at the moment of impact when John O'Keefe's phone never moved again. Oh my word, ladies and gentlemen, we are Towels. We saw that unfold live. I can't believe that we stuck around. We knew not to move. We knew to watch. We are Towels. We are now going to do our recap. We have to do a few things, folks. We have to do a few things as we prepare to do our recap. Number one, we need to get ready with our first clip. I uploaded that entire motion hearing, and now what I'm doing is I'm preparing the second component of that motion hearing because it actually went on for at least, that was a long motion hearing, huh? Went on for 30 or so minutes, folks. That was quite a motion hearing. Yeah, it went on for 32 minutes and 30 seconds. So now, folks, we got that going on, and then we're also going to do our recap. Now, the thing is, we need to wait a little bit of time because in order to be able to effectively do our recap, we need to wait. I guess we don't have to wait for this upload to take place per se, but my word, Towel Friends, you all saw it. That yes, Alessi, Boss Texas Chick, it was great to see you. Yes, Alessi kind of went off the rails there, even though we knew it was over. But we are going to do our recap because I will tell you, folks, that was something. That you see things from time to time, and you very rarely get a tip off in open court about a piece of evidence that explosive. But you heard it there, ladies and gentlemen. You heard it in real time from Hank Brennan, the man himself. We are allowed to call him Hank. Dropped it out of nowhere, folks. That's Hank Brennan for you. Classic Hank Brennan move. And we are going to do our recap here, but I do want to get this post up because that was incredible scenes, and I wrote up the whole motion hearing. And then, of course, I had already got the clip earlier the medical examiner confirming a sideswipe could have been the cause of John's injury. But my word, ladies and gentlemen, Murder by Maestro. No, you have to go back and watch Murder by Maestro. It's not a hint. Hank Brennan said there's a collision impact event at exactly the moment John O'Keefe's phone stopped working. Oh, my word, we tried to summon you, my dear friends. My dear friend, I was having a conniption. I was running around like a towel with his head cut off. I was being a towel. We knew it was coming, Murder by Maestro. He said it. The Lexus infotainment system captured an impact event. That is the headline. Oh, my word, ladies and gentlemen. And again, we knew that this was coming, but how it got confirmed was Alessi brought up how in a report, Hank Brennan has confirmed that the John O'Keefe's phone data wasn't exactly synced to the clock in the same way that Karen Reed's Lexus was. And when you adjust the dates and times, they're exactly the same. Oh, Murder by Maestro. We're going to rewatch it right now, folks. We are going to rewatch it. In fact, what we'll do is I will clip out that specific part. I'll make that into a clip, and then I'll put the full motion hearing up. So let's start with that initial part. We're going to listen to it right now. We'll do our real-time towel video editing. We all love these moments when towel is breathless, and I'm running around like a towel with my head cut off, and we have to do real-time video editing. Here we go. Ladies and gentlemen, let us be little towels. So we start there. Okay, we bring that up. Okay, then we grab this over here. Now we grab this. Are you all watching what's happening? Murder by Maestro, you're going to get a chance to rewatch it right now, because what we do is we go into this clip. Actually, let's do it by duration. All right, so what we're going to do is let's go forward in this clip until we hear Hank Brennan talking. Is this Hank Brennan? No, that was Bob Alessi. That's still Bob Alessi. Bob Alessi, I appreciate you opening the door to this to give us this wonderful information, but we don't need your information. We need Hank Brennan. There's Hank Brennan. There's the man, Hank Brennan, right here. Let's go back and let's zoom it backwards right to the moment Hank Brennan starts talking. Yes, I am a horse racing announcer towel and also an auctioneering towel. I am a towel. Ladies and gentlemen, here's the moment. Bob Alessi finally stopped talking during the motion hearing. Just finish up now, please, Mr. Alessi. Thank you. We appreciate everything you had to say. Move along.
Mr. Brennan.
Okay, here we go. Okay, let me start with where it says Mr. Brennan.
Thank you.
All right, here we go. Split it. All right, Murder by Maestro, you're going to get a chance to listen to it now because we're going to clip the relevant parts. Actually, hold on one second. Let me jump forward because, well, all right, let's just listen to it.
Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it's clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. On my case in chief, because we now have this available data. As I said, this wasn't ambush, it isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay.
Oh my word, ladies and gentlemen. Oh my word. We got it. We got it. We got it. Now watch what I do. I wait for that to do its thing. I grab that. I make sure we're on the right page. Let me just make sure. How long is this clip? It's 4 minutes and 22 seconds. We render it down. We want to make sure that it's the current page. It's in MP4 format. Done. Done, ladies and gentlemen. Oh my word. Oh my word. What a moment. Oh, wow. Oh, wow. Wow, wow, wow. That was it. Well, you saw it. It's coming in. It's coming in. It's not even about extent. So I'm going to try to explain. This is a very big deal. Hank Brennan, I don't know if he necessarily wanted to. We knew this was coming. Hank Brennan has a collision impact event. Ladies and gentlemen, a collision impact event from Karen Reed's Lexus infotainment system data. Oh my word. And when you actually sync the times of John's phone, which was a little bit ahead just because it ran ahead or something, when you sync that with the Lexus infotainment system data in the black box, oh, ladies and gentlemen, it shows the collision at the moment John's phone basically stopped moving. And it seems like, yeah, this is a collision impact event from the infotainment system. It's a collision impact event from the infotainment system. Now, we'll listen a little bit more, but I'm pretty sure that was everything we needed, because Alessi then talks, and I don't think Brennan talks anymore about this issue during this, but let's listen, because it is a collision impact event from the infotainment system. I was listening very closely. I know what I got. Yeah, they got her. Murder by Maestro, and I know this. We've been studying this for a very long time, this very specific issue about whether the Lexus infotainment system data is going to have GPS, time, and place. But really, what none of us saw coming was it has a collision impact event. Oh my word, it was hiding under the surface the whole time. It's game over. I'm telling you, it's game over. It could be even more, but I'm telling you, Murder by Maestro, this specific thing was about a dispute about the collision impact event and its specific timing. But there could be even more. I'm telling you, they got her. They got her. She's cooked. They have a collision impact event. This is what was hidden during the first trial when 2.4 gigs of 8 gigs was collected from the 3 chips by Karen Reed's expert instead of the full 8 gigs. For some reason, Karen Reed's expert used the wrong chip reader. and only got 2.4 gigs of 8 gigs. You only read 1 chip instead of 3. Ladies and gentlemen, there was a collision impact event on that chip. Oh, Hank was pissed because ARCA apparently did something really shady with their new reports, and Hank's expert found it. And so Hank's expert now has to go through and do his own testing to figure out exactly what ARCA was up to nefariously. And Hank's expert can't present that in the case in chief. He has to wait now because the new testing can't get done quick enough. So Hank was furious because now you got a situation where Hank has to call the expert, and then Reed's experts from ARCA will get up and testify. Then Hank's expert's got to come back and be like, okay, I did my own testing on the ARCA testing. Whereas normally Hank in his case in chief should be able to have the ARCA testing so his expert in the case in chief can testify about the ARCA reports. Oh my God, Reed's experts tried to sandbag Hank Brennan, but Hank Brennan caught on to it, but didn't have enough time to have his expert do more testing before the expert was going to take the stand. Oh, ladies and gentlemen, and that was the second half of the hearing. We didn't even watch that. Listen, I got to get this clip up, okay? That is one of the most important things to get up right now. They're like, I have to get up that summary. I have to get up that clip. It's incredibly important because a lot of people aren't going to understand. You have to really follow the nuances of this to get it. I know Murder by Maestro and I do, and some others on this stream do, but it is huge. It has monumental impact. Not in the way that, like, even I don't know if the mainstream press is going to exactly get it, but trust me, it's huge. It's bombshell. And that's why Reed's lawyers literally had a meltdown. They were losing their minds. Oh my God, they were literally losing their minds. They were freaking out. I mean, I've seen some stuff, folks, but they were running around like chickens with their heads cut off. They absolutely lost their minds. And it's not just, they got this a week ago. That's why they're all freaking out. Karen, her lawyers, everybody's freaking out because they've known about this for a week. Oh, dear goodness, it's as bad as it can possibly be for the Reed defense. I'm telling you, I know this stuff. I know it well. I'm a little towel, and as a little towel, having studied this stuff extensively, I'm telling you it's really bad. We haven't even got to our summary yet because I can't make. Why is my video not formatted the way that I want it to be? Is it just my display being a little weird? Hold on, I want my video formatted correctly. How can these two videos be not the same exact format? It is literally the same exact format. All right, so we can compromise a little bit. Yeah, we'll compromise a little bit. All right, there we go. So I got that. I got those two. All right, now I got to generate this full thing. We don't need this in 1080p. We're going to download all 4 of them. Got it. All right, I got the full hearing. Oh, my word, ladies and gentlemen. Hank that was huge. That was just so huge. Brennan literally caused them to... there are just huge implications of this. I know I've been explaining. I'm sure Murder by Maestro is explaining it as well. But a collision detection event. Oh, my goodness. Of a collision detection event. It's huge. It's huge. That's it. That's it. That's it. You can't argue against that. That's it. Collision detection event. Oh, goodness. Oh, my word. Oh, my dear. I can't believe a lot of folks aren't actually going to follow that, but we all followed it, and we're going to do our recap in a second. I just have to actually post that, because to do the recap, I have to reference it, and I want to show the clip. Like, it's so recursive what we have to do. But it's just past 4:30. My name's Grant Smith Ellis. I work hard for you, little towels. I care. It's not the timing is why the Reed's lawyers brought it up today, because they're saying like this new information about how Brennan figured out the sync of the timing is, new to them. They got it last week. But the big thing is we now got the disclosure. There was a collision detection event. I'm trying to put it into words in a certain sense, but a collision detection event, that's like, oh my goodness. I mean, that's everything that Aaron was trying to hide during the first trial. It was a collision detection event. Do you see what we're saying here? A collision detection event. Exactly. Like, that's why the motion hearing happened. That's like this the out of sync timing. But the what was revealed, and what again prosecutors don't talk except during their opening and during motion hearings. What was revealed was that there was a collision detection event. It's coming. Oh, goodness. It was, yeah, no, she had collision detection. That's what I think we're getting at there. And it's not just she had collision detection system. The infotainment system registered the event. It's a big, big deal. It is a big, big deal. And we're Little Towels. We're going to cover it. I'm here. My name's Grant Smith Ellis. You all believe in Little Towel, and I believe in you. Yep. Yeah, exactly. It's the reason why they're syncing it, though, obviously, is that the timeline is so damning. But the most important thing is the event. Like, you all have to understand, and I'm sure some of you do, that the database that holds this information registers events. When you have a collision detection event, oh my goodness, he's calling it a collision because he's going to be able to deliver. Hank Brennan's calling it a collision detection event because he's going to be able to deliver on it. No, the motion was prevent a part of the Aperture report that corrects the time sync to show John's phone was a little bit out of, like its clock was out of sync. So when you sync John's phone on its actual time based on the Waze data and timestamps with the actual time on John's phone, that lines up exactly with this impact event. But again, that's how court motions work. It may ostensibly be on the surface about like a thing about a time differential. That's not why Bob Alessi was having a literal existential crisis in the middle of a courthouse. He was having an existential crisis because the actual thing hiding underneath was that the event time that they're talking about, the event in question, an event is a specific thing in a database. It is a registered event. And Brennan then used the term collision impact event. And then it got reinforced by Alessi during argument. I'm telling you, this is it. This is the whole case. That is the case. That is the entire case. That's the whole kit and caboodle. That's everything in one package. If you have a collision detection event, and then obviously you have to explain the synced phone data because people's phones run out of sync all the time. That's not that hard to understand. But you have a collision detection event right as John's phone stops moving. That's what was missing from the first trial. That puts it all together. Couple it with the testimony we got earlier about how a sideswipe could have caused John's injury. Ladies and gentlemen, neat little bow delivered. And what Hank Brennan was upset about was something different. He was upset about the Aperture witnesses trying to surprise the prosecution with this flawed report, apparently. But it's completely unrelated to the issue that we were just talking about. There were the motion hearing was bifurcated, okay? Well, why? It was 30 minutes. I don't want to watch it again now. But the first part of the motion hearing was about this collision detection event and the part of the Aperture report of syncing the timelines, but the underlying bombshell was about confirming the collision detection event right as John's phone stopped moving. Then the second part of the hearing was about whether Hank Brennan's expert should now has to do new testing because ARCA turned over discovery very, very late, obviously, although in compliance with the court order, and what Brennan got and showed to his expert indicates that ARCA's testing was very flawed. So Brennan's expert has to do his own testing now, and Brennan can't do that before the expert has to testify in the case in chief. So you got the situation where Brennan's expert's going to have to testify, Reed's experts will then testify, then Brennan's expert's going to have to come back and testify again because he can't do his testing because Reed's defense tried to spring this new report, the ARCA experts, at the last minute on Brennan. Two different issues. They're bifurcated. Well, that's what I'm saying. Yeah, but that's what I'm saying. Murder by Maestro. Brennan called it new. Brennan called it new. And then they both, and I think Brennan, I think both of them may have said infotainment. I'm telling you, Murder by Maestro, I don't know exactly where this is going, but I'm telling you that collision detection event was not a part of the first trial. The collision detection event, collision event, those two words were not said together at all. And then Brennan used the word new. We need to tease this out. The point is, none of us have seen this. It's not been presented. It got hinted at, but this was the first time we got anything about this. I know what's Murder by Maestro, my friend. I know what we're looking at here. I'm reading all your comments, by the way, because what I'm doing right now is uploading. I just uploaded the video of Brennan, just Brennan's part of the argument. And now what I'm going to do is I have the full motion hearing as well. And then that full motion hearing, I think, will also help people, obviously, because what I try to do is when we're going to do these recaps, I'd like to already have a lot of the stuff out because it helps me to just go through my Twitter timeline. And we have the stuff from Brennan now, which is great. We have the knee injury. We have the statement from the medical examiner. I got all that stuff up. So this is the very last thing I want to do. It's going to take a little longer than the last video. And then we are ready to go into our towel mode. All right, so I got that. I'm going to grab it. We are going to be good, effective little towels, and we're going to actually do our recap. Thank you for being patient with me. I know a lot of you appreciate staying for the recap. Ring, we haven't even heard the ring experts yet. We don't know when they're being called. The keeper of records is on the way, and remember, if we're on schedule, that means ring could be tomorrow, ladies and gentlemen. Oh, ladies and gentlemen, there's a lot going on. My name's Grant Smith Ellis. It's just after 4:30 p.m. on, what is it, Thursday, May 15, 2025. And if you're just tuning in, we're about to start our recap of day 17. I'm calling it day 17 of the John O'Keefe and Karen Reed trial. It was bad for the defense. Bad news. It was bad news all around, and we're going to go through it moment by moment. We're going to give you the recap. Then I'm going to upload the recap. Then I'm going to make tomorrow's stream. Then I'm going to try to go to bed. There is no rest for the towel. Towel just dedicates himself to you all. Towel refuses to give up. I am a towel. I appreciate you all, though, so much. It wasn't overlooked, Tiger Lily Girl. That's why I'm saying Murder by Maestro, saying it has to be from the EDR, but I'm saying they had it in the first trial. This has got to be a collision detection event from something that wasn't available during the first trial. It is new. It's black box, as Hank said, and she is screwed. Okay, so I'm going to call it black box. So, all right, let's say, so I guess Alessi was the one who misspoke. So let's call it the black box system. Because the key point here, whether it's the black box or the infotainment system, the key point here is that it's new. It's new data. And that new data was not available during the first trial. And that new data is absolutely devastating to Karen Reed. That's what we have concluded. Oh, the car has multiple black boxes. Oh, and is one of the black boxes in the infotainment system, Murder by Maestro? Hold on, I can't publish the piece. I can't publish. We got to figure out, is it a black box Murder by Maestro? This could be it. Is there a black box? Oh, okay. Okay, got it. Has new evidence. There we go. That was huge. I got it. So Murder by Maestro, this is big. This is big. Big. Here we go. New testing. I think we've put it together. It's the black box EDR data, which is the important part. But there was new testing done on the infotainment system as well. But my word, ladies and gentlemen, my word. And I got the full motion hearing uploaded. It's 32 minutes and 30 seconds. I need to take some time to process all of this. Right, it was multiple chips, and they got far new data, but the big takeaway here, folks, collision detection event, not part of the first trial. That's what I'm saying. It was a new Lexus. It's a new model. It has a lot of data. I'm telling you, the Reed defense went into catastrophic meltdown when they got this. This explains why they've been freaking out the past week. That puts it all together. Oh, my word. Oh my word. And now I have to add the part at the bottom of this post about how earlier the medical examiner confirmed John's injuries could have been the result of a sideswipe impact. Oh, ladies and gentlemen, my brain went into towel overload. I actually use capital letters. I never use capital letters. Earlier on Thursday, the medical examiner, see that footage here. My word. Good thing I mean, in some sense, I'm kind of glad. I was exhausted today. I don't think I would have been able to do that in court. That would have been a lot. That would have been a lot, folks, to take in court and to be doing the live stream and to, it's just a lot. Little Towel wouldn't have been able to do it. I don't have the physical strength right now. All right, the post is up. The full motion hearing is up. It's time for the recap. Who's ready for the recap? Here we go. This is one, we do it live. We one take it. We're Little Towels. Everybody loves a little towel. All right, so how are we going to start? How do we even start? Oh, my dear goodness. Let me process this all in Little Towel's brain and then decide how we're going to start this. So it started with the medical examiner. So I guess we're going to start with the, I'll review it first because I have a lot on my brain right now. And that collision testimony was absolutely devastating. Wow, almost 8,000 viewers on the Twitter over today. Wow, on the X over today. Wow, that's wonderful. And then there was, we are just a towel universe is strong, ladies and gentlemen. And it's going to be our recap. And before we get into the recap, remember, this is a public information service. This is a service that's literally powered by you all. We now have, at least YouTube is running ads on this thing, but there's no sponsors. There's no one except for the Towel supporters. And you all, whether you're liking or subscribing to the channel, you all are the reason why this channel is continuing to thrive and flourish. And we even have new links if you want to send support or you want to get memberships or whatever. There's lots of benefits you can get by supporting this channel. You can get emojis and things like that. It's all in fun, but it helps this public information service, which is rooted in Lord Reith's commitment to educating, informing, and entertaining the wider public at large. And by goodness, ladies and gentlemen, is there anything more noble than helping other people become informed, cogent participants in our wider public sphere, such as to ward off usurpation of our representative forms of government? I swear, ladies and gentlemen, you Little Towels have built a wonderful community among yourselves. And don't forget, Towel is doing his very best. I think we're going to make it till tomorrow. But at any time, if you want to support this stream, you can help your fellow Towels. You can also click on the links below, which our wonderful Murder by Maestro helped put together. And this is going to be my way to lead into our wonderful Towel discussion about the recap. All right, let's begin. All right, let me take my breath. Let me get myself centered. We got to go back a little bit, move forward. Oh, right, Alessi at the moment where he was an idiot and caused the jury to have to literally leave the room. And then the buffer zone ruling started the day. And okay, all right, let's do it. Oh, goodness. So what was the moment of the day? What was the moment of the day? What was the moment of the day? Was it the collision detection event or was it I think I'm going to link the collision detection event to the leg and then I'm going to go back to the start of the day and then go through the day. All right, I'm ready. I have a schema. All right, Towel friends, you all, this is a collaborative effort. We do things in real time. Ladies and gentlemen, God bless you all, by the way. I did look down at my phone. We're almost 9 hours and 30 minutes in, and I'm still going strong like a little towel because I'm devoted, you're devoted, Sole Nina. So many of you in the Towel stream keep me going. It's your positive energy that makes this all possible. Don't you all ever forget it, Little Towels. The strength of the Towel universe is strong. All right, so if we're going to lead with that, then we got to actually lead with it. We got to lead with it, then we got to go into the side swipe, then we got to go into, yeah, there we go. All right, that's what we're going to do. That's what we're going to do. That's what we're going to do indeed. All right, here we go. Hello, ladies and gentlemen. My name is Grant Smith Ellis, and what is officially day 17 in the John O'Keefe and Karen Reed trial has concluded. It was a whirlwind series of events, ladies and gentlemen, but it concluded with a bombshell that no one saw coming in a motion hearing called by a frantic Reed defense who seems like they've been devastated and on the ropes for over a week now. Bob Alessi, while arguing a minor point about a time sync correction between John O'Keefe's phone and Karen Reed's Lexus data, opened the door for Hank Brennan to confirm the state has data, new data from Karen's black box EDR data that was not available in the first trial, showing a collision detection event at the very moment, ladies and gentlemen, when John O'Keefe's phone never moved again after 12:32 a.m. roughly on January 29, 2022. Ladies and gentlemen, it came out of nowhere. It was explosive, and it happened just minutes after the medical examiner in the John O'Keefe and Karen Reed retrial let the world know that John's injuries, while unlikely caused by a frontal impact from a car, the front of a car, which we know didn't happen because Karen's back right tail light was broken, could have been caused by a side swipe impact, ladies and gentlemen. Oh my word, jurors haven't seen this new Lexus black box data, neither has the world, but we got our first hint today. Jurors, however, for their part, absolutely did see the testimony about John O'Keefe's injuries potentially being the result of a side swipe impact. So let us start, ladies and gentlemen. My name is Grant Smith Ellis, as I mentioned. Let us start our Day 17 recap with the moment that literally blew half of the Karen Reed and John O'Keefe trial world off their feet. The medical examiner announcing that John O'Keefe's injuries could have been caused by a side swipe impact. Let's listen in.
Okay. How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that point.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes.
And you offered that was not consistent with falling backwards on the head alone.
Correct.
You were asked if that was consistent with a punch.
Correct.
Objection, Your Honor.
That's not the testimony. That's your objection, Mr.
That is, Your Honor. That is not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was it?
Could it be consistent with first aid treatment?
Anything is possible.
That's the answer Brennan wanted, folks. He got the double whammy. And by the way, folks, you just heard the testimony there from the medical examiner. A side swipe impact could have caused John O'Keefe's injuries to his legs, ladies and gentlemen. And if you missed those injuries, they were revealed for the first time today as well. And folks, we are also going to talk about, in what was a horrifying moment, Bob Alessi showed a picture of John O'Keefe's, the inside of his stomach after John's autopsy, and it caused jurors to ask for the trial to be, at least one juror to ask for the trial to be suspended for a little bit, and they needed to take a break. Oh, ladies and gentlemen, there is the photos of John O'Keefe's leg confirmed. The injuries that the medical examiner herself said could have been caused by a side swipe from a car, ladies and gentlemen. You heard it. And then, folks, it got even worse for Karen Reed's defense, because this was the culmination of the end of the day of the Karen Reed and John O'Keefe trial. We are actually going to watch the motion hearing. It came out of nowhere. Bob Alessi nearly had a nuclear meltdown about the collision impact event data that is going to be coming into evidence in the Karen Reed and John O'Keefe trial. And as a little bit of preface, Alessi is literally only arguing about how within the last week the defense was informed that the prosecution's expert was able to sync John O'Keefe's phone, which the clock on John's phone wasn't synced up with the regular time, which happens sometimes with phones. But Karen's Lexus was on the right time. And so after syncing the time of the phone events to the car, the collision impact event was right as John O'Keefe's phone stopped moving and was found to have never left the lawn where John was struck allegedly around 12:32 a.m. and not found until after 6 a.m. on that blizzard on January 29, 2022, where John succumbed, according to testimony from the medical examiner, from hypothermia and a traumatic brain injury alone on that lawn. Ladies and gentlemen, we heard the motion hearing, and the reason why the collision impact event is such big data is it wasn't available in the first trial. And you are going to hear, ladies and gentlemen, we are going to listen to the motion hearing. This was the culmination of the day. Jurors didn't hear it, but the public did. You're going to hear Bob Alessi start talking about this dispute over the timeline, but then you're going to hear Hank Brennan, ladies and gentlemen, come in and confirm what the world has been waiting to hear, that there's new data from Karen Reed's Lexus that wasn't available in the first trial that shows a collision impact event. Those words, big words, ladies and gentlemen, said by Hank Brennan himself, and you're here for the recap with your friend. My name is Grant, Howard Cosell, David Attenborough, Towell Smith Ellis, and I'm thrilled to be with you all as we watch what was the culmination, the shock culmination of day 17 of testimony in the John O'Keefe and Karen Reed retrial.
I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. Now, I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that?
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARCA at all.
All right, so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense, in theory, is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
All right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. On my case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong in the significance.
Bob Alessi gets this completely wrong. Hank Brennan knows it better than him. But folks, there's a point here. This was huge. Did you just hear this? The segue is Hank Brennan knows when Karen Reed's car even started at the waterfall. Time and place location. And you might say, Grant, did we get a preview of this? Did you and Murder by Maestro literally, were you all yelling about this to like an audience, a very small group of towel friends for months? Were you and Murder by Maestro just yelling from the rooftops because were you listening to court hearings during the pretrial process and you know something like this was going to come before they even did the chip off of the data in December of 2024? Yes, because we are compulsive and Murder by Maestro speaks hexadecimal and I'm a towel. Now let's listen to this, folks. If you didn't get the implications of that right there, collision impact event right before John's phone last moved. And ladies and gentlemen, they got time and place GPS data for Karen's car. It's all coming in. Bob Alessi literally was begging for a continuance of the trial. The defense, he said the exact quote, ladies and gentlemen, let me read it for you from the towel notes. We are in an almost impossibly challenging situation, said Bob Alessi. Oh my dear goodness, what a moment. Let's watch why. Let's watch this Murder by Maestro. You know it's a victory lap for you and Little Towel, even though we don't really take victory laps in criminal trials. On this one, we worked hard, my friend. We were right, and the world shall soon knoweth that Murder by Maestro and Little Towel proclaimed it to be so. The omniscient, prescient forces that is the Little Towel and Murder by Maestro. God bless us all. I didn't even catch it the first time. Did you all hear what he just said? The best laid plans of mice and men, folks. The best laid plans of mice and men.
What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. Navigation information, phones that were plugged into the radio, travel logs, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips.
Wait a minute, I didn't even catch that the first time. Did you all hear what he just said? Hank Brennan said that it wasn't just that only 1 of the 3 chips was read. The reads expert used the wrong software or the wrong chip reader, which is hardware. Oh my God. Oh my God. Oh my God. Murder by Maestro. You were right to be yelling from the rooftops about this, my friend. I will tell you right now, you nailed it right on the money. Could not be any more prescient. Nailed it. Nailed it. Nailed it. Absolutely 100% nailed it. There is a lot there, folks, and we haven't even heard the disclosures about what this detail is going to contain. I have my prescient forecast based on my extrapolation of all of the evidence in this case, being one of the few people who has read every single thing on this godforsaken 700-item docket at this point. But I'm telling you, folks, I'm telling you this is huge. I'm telling you now that it's huge because it wasn't just the chip off was incomplete and only 1 of 3 chips was extracted and read. It was that the wrong software was used initially too. Oh my God. Oh my God. It was definitely, I have a strong feeling Karen Reed's expert was like, oh my God, I can't believe Lally's letting me do this. Let me give myself some plausible deniability. Well, Brendan's got all 3 chips now, and the data went from 2.4 gigs to 8 gigs. Oh my word. I'm so glad we watched this. Folks, Murder by Maestro just put it together. Brendan's got 2 new chips. One of the chips is the infotainment system. One of them's the EDR. He's got collision detection event right as John's phone never moved again. Brendan's got Karen's time and place. The trip back to Fairview around 5:23 right as Karen left a voicemail. Oh my dear God. The collision detection event. Oh, it's all coming in. They got her. They got her. It's over. That's why Karen definitely had a mental breakdown on Monday. She wasn't tired. She got this information last week. She knows it's over. They got her. Folks, they got her. I'm telling you right now. You watch that last clip. You watch me beaming with that smile. It's not just me. Murder by Maestro and I were both on to this. We're right. We were the ones who heard these motion hearings before the chips even got extracted. We both knew what was coming. We could sense it. We were able to put it together. And that's why a lot of folks would be like, and I'd be like, why aren't you all seeing this? I would implore the media, like, listen to me. I know that I am right. And they would be like, I know, Grant, I know. And I'd be like, listen to me. My God. Oh, my word. We were right all along. Yeah, exactly. That can't hit a trigger event. So, but that, Murder by Maestro, we could see how he could get confused because he's dealing with this new report, which has probably new data from the infotainment system and the chip off from the EDR. Oh, my word. Ladies and gentlemen, we all see. Our eyes are open to the light. Oh, praise be, ladies and gentlemen. You were here during the recap. You saw it all put together. I figured it out live with Murder by Maestro. I had to come in to help. It was a towel assist. Oh, my word. Oh, my word. Ladies and gentlemen, that was not even the full summary of the day. Day 17, our summary continues. Now, let's look at this, ladies and gentlemen. Let's look at this. I will say it, ladies and gentlemen. I will say it. There was way more as well. We also got an expanded buffer zone from Judge Cannoni. I will give you a very quick summary of that. You can find it on my Twitter as well. That really was what started the day. Apparently, I'm not only a horse racing announcer towel, I'm also a auctioneering towel, and that I can say things very quickly and do a recap really quickly. Ladies and gentlemen, let me show you it right now. Let me show you it. I will show it to you, ladies and gentlemen. This is the buffer zone order from this morning in the John O'Keefe and Karen Read trial. The procedural history is thus. A buffer zone order entered that is larger than the first trial's buffer zone. It was appealed to the Federal District Court in Boston by way of something called a request for a temporary injunction. That was denied. The request for the temporary injunction was procedurally appealed to the Federal First Circuit Court of Appeals in Boston. The Federal First Circuit Court of Appeals, in a ruling earlier this week, said that the motion to enjoin, the denial would not be reversed, but would be vacated and remanded for further consideration by the lower federal district court. That means the status quo prevailed, and over the past few days, the buffer zone has been in effect. But then the counsel for the parties appealing the buffer zone to the First Circuit Court of Appeals filed an emergency motion for clarification and reconsideration of the court's Monday order for the remand, not the reversal of the buffer zone, denial of the injunction for the buffer zone, but the remand, the vacate and remand. The clarification said that there needed to be more of a, from the First Circuit Court of Appeals, said that there needed to be more of a robust factual record with regards to the mens rea component of the buffer zone. This means that under Cox v. Louisiana from 1962 or 1963, when you have a statute related to picketing or anything around a courthouse and it affects more than court property, you can have that statute, but you have to tailor it, narrowly tailor it to an intent requirement related to impacting the judicial system. So now there's a new buffer zone order. It does not actually change the buffer zone. Everything about the buffer zone is exactly the same. All it does is add a mens rea requirement for enforcement, and it provides an opportunity to appeal any enforcement actions to a justice of the Norfolk Superior Court. Okay, that's it. Now what will happen from here is this is now a more robust appellate record. The Federal First Circuit Court of Appeals will send it back down to the Federal District Court, which will weigh the issue again for the request for a temporary injunction. I think the Federal District Court will deny it again. Randazzo will appeal it up to the Federal First Circuit again. Then they will deny it under Cox v. Louisiana because of the mens rea component added to Judge Cannoni's order. That's why she wrote it that way. It's all designed that way on purpose. Now, we have a little bit more testimony to listen to because we're doing day 17 recap. And by the way, Tao really likes to do his recaps clearly. So we already talked about how Dr. Scudorti Bello testified, but now we need to listen to Hank Brennan's redirect of Dr. Scudorti Bello. I think we actually already heard that component. So we'll hear the very, very end then of Dr. Scudorti Bello's testimony before the lunch recess about John O'Keefe's injuries. But also, folks, before we do that, let's look at the moment that Bob Alessi literally caused the trial to come to a screeching halt because he started showing pictures of the inside of John O'Keefe's stomach on screens in the courthouse and definitely upset like half the jury. So let's find that exact moment. I know I have it here. I got it right here, folks. Let's watch it. You can even watch Little Tal's commentary. That's how intense it was. Oh, my words, ladies and gentlemen. Grant Smith Ellis here. The Karen Reed defense via Bob Alessi has just made a major tactical error in the afternoon session of day 17 in the John O'Keefe and Karen Reed trial. Oh, my word. Bob Alessi showed the jurors pictures of the insides of John O'Keefe's stomach, excised from his body after his autopsy. Immediately, within a minute, jurors asked their bailiffs for a break. Ladies and gentlemen, we're going to watch the moment. Thankfully, the stream didn't show the pictures. Ladies and gentlemen, the Bob Alessi, for no reason, this has to do with whether John O'Keefe had hypothermia as a result of Karen Reed leaving John O'Keefe on the lawn after allegedly striking John with her car, causing a traumatic brain injury. And then John's phone indicated he never left the spot on the lawn after 12:32 a.m. and 16 seconds on January 29, 2022, when Karen Reed, with a blood alcohol level of 0.14 to 0.28, which is 2 to 4 times the legal limit, backed her car up to 24.2 miles an hour, reducing to 23.7 miles an hour at the moment of impact with a 4.7 degree steering wheel correction to the right. And then left John to die on that lawn with his body temperature getting as low as 60 degrees or so the next morning. Ladies and gentlemen, Bob Alessi didn't have to do this. The jurors must have got sick. They asked their bailiffs for the first time in the trial to stop the trial. Let's watch the moment.
Your Honor, can we take a break?
Yes.
Jurors.
Yes.
That was the jurors asking for a break. It was devastating. And now we will close with the most apropos moment, the moment that folks need to keep in mind, which is the injuries that John O'Keefe suffered in the moments after he allegedly was struck by Karen Reed's car. The room went silent. Ladies and gentlemen, let us listen.
In his skull, and also your observation of Mr. O'Keefe's brain. You mentioned earlier that you use other resources, other testing. Did you ask for any type of assistance on toxicology analysis for Mr. O'Keefe?
Yes, it is routine and it is protocol to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
Thank you, Mr. Brandon. Doctor, I'm handing you a document. Do you recognize that?
Yes, this is the report of toxicology from the State Police Crime Lab for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes.
Is that a fair and accurate depiction of the report you saw before?
Yes.
All right, introduce this as the next exhibit, please.
No objection, Your Honor.
Thank you.
Exhibit 161.
Thank you. I have that in front of me. Sure. Thank you very much.
Thank you.
In your experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
In the toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay, and was there any?
There were no prescription medications, there were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor?
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball. And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, doctor. After your autopsy and observations of Mr. O'Keefe's body, inevitably did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes. The cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit.
And what is a normal body temperature?
98.6.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes.
And what is that document?
It's the death certificate.
Did you do so in this case?
Yes.
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
Yes. There is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate, in this case, stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
So you understand that, folks? That was the big moment of the testimony.
May I approach, Your Honor?
Yes.
This is the distinction between cause and manner of death. There was a cause of death. Ladies and gentlemen, you heard it there. Blunt impact injury and hypothermia for John O'Keefe. It was devastating. As we approach 10,000 people on the X feed, ladies and gentlemen, my name is Grant Smith Ellis. You saw it, folks. You saw it. There's only one more thing we have to watch. I'm sorry to have to do it to you, but there was a second section of the end of the day motion hearing. And yes, for the purposes of completeness, as if we were functioning under MRE or FRE 106, the rule of completeness, we must watch the second half of the motion hearing. You're going to have to get tormented. I'm so sorry.
A more layperson's term is a variance of time.
Hold on, I'm going
Your
to jump
Honor.
forward.
Has overruled government's objection and has
Actually say this, Your Honor, there's nobody that's more surprised to getting this than the
deadlines without any excuse.
What's your argument?
when we got it on May 11th.
Okay.
So this is the second part of the motion hearing. This was how the day ended. We have to watch it, folks. Here we go.
Thank you. The other issue about calling your...
Oh, so let me explain what's going to happen here. This is the part where ARCA turned in their discovery just a few days ago for Reed's experts, and Hank Brennan found out that ARCA's reports indicate serious flaws, and Hank Brennan's expert, who was supposed to testify soon, now has to do more testing. Let's listen.
Expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it is going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, and to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims
made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. You've heard from the ARPA witnesses themselves that the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No. No, because Dr. Welcher relies on Shannon Burgess' information and material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
All right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. we proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
All right, we're done for the day. Folks, we really were done for the day. It was wild, folks. If you missed it, here's the quick recap. Oh, my word. Oh, we have one more thing to watch. Hold on. Stay with me, little towels. We have one more thing to watch. If you missed it, Hank Brennan's got Karen's number on the vehicle data. Hank Brennan's got a collision impact event. I got it for Murder by Maestro. We got one more thing on Karen's vehicle data. Let me know, folks, whether you think, based on the medical examiner's massive testimony, that John O'Keefe's injuries could have been caused by a sideswipe impact by the car, and whether you think Hank Brennan's new data, new EDR data about a vehicle collision event lines up with Murder by Maestro's stunning reconstruction, which, I mean, remember, it's modeled, but it's a stunningly well-done reconstruction. Is this what happened to John O'Keefe, ladies and gentlemen? Is this what all the testimony on day 17 is leading up to? Let's watch the reconstruction. Ladies and gentlemen, what do you think? In some sense, it all lines up. This is Murder by Maestro on Twitter. Definitely check Murder by Maestro out. He has been on top of this vehicle data, and now we know there's a collision detection event. Murder by Maestro may have been the first person in the entire world, the first towel, the first super towel, member of Ordo Noble Linto, the Order of the Noble Towel. God bless you, Murder by Maestro. This is tough footage to watch, but I think you got it. I think you put it together. I think it's going to be very similar to what Hank Brennan's experts are going to show, and they have the vehicle data showing the collision impact detection event. Oh, ladies and gentlemen, it all lines up. The damage to John's arm, the damage to John's leg, the side swipe conclusion possibility from the ME, from the medical examiner. Oh, my word, ladies and gentlemen. Murder by Maestro is the GOAT, says Def Otter, the greatest of all towels. Oh, the towels are flooding the chat. They are all saying that Murder by Maestro's prescient prediction has nailed it. You know what we have to do, towel friends? We have to put up a towel poll. We have to put up a towel poll. Do you feel Murder by Maestro's amazing reconstruction video is accurate as to Karen hitting John? Oh, ladies and gentlemen, only Murder by Maestro could put something together like this. I put up the poll. Look at, folks, what are we going to see? We're running the poll in real time to end the recap. Will this be another prescient prediction? The poll is now running. I know some votes are going to come in nearly right away. Oh, it's yes, folks. It is yes by an overwhelming majority. Folks, the towel fandom has spoken. Oh, it's playing, folks. Don't worry. It plays over and over because I put the poll up. The towel universe has spoken. This is game over. Murder by Maestro didn't even know about the knee injury, but it all lined up because Murder by Maestro is a prescient towel. The vehicle data, the GPS location, the collision impact event from the EDR black box, the chip-offs. We know that 2 new chips were recovered from Karen Reed's Lexus. The infotainment chip, the EDR chip, both not initially extracted by Karen Reed's expert during the first trial. The bombshells keep coming. Karen Reed's defense got this information a week ago. That's when they started melting down. Bob Alessi literally freaked out in the courtroom today to the point where he had to ask for a continuation of the trial. Ladies and gentlemen, he's going to ask again tomorrow morning. Murder by Maestro is a wonderful little towel. My name is Grant Smith Ellis. These moments are hard to watch. Join us again tomorrow, youtube.com/@Grant Smith Ellis. But Murder by Maestro has put it together, ladies and gentlemen. Murder by Maestro, you saw him popping up in the chat, combined with Little Towel months ago, November, December 2024. We were calling it. We knew this was coming. The collision impact event, the time and place location of Karen's car. We knew it, ladies and gentlemen. Watch tomorrow. Where will this all go next? Friday's testimony. Be with me, 7:30 a.m. Eastern. Join the Towel Friends. It's a wonderfully loving community. It's very peaceful. It's very compassionate. It is a place unlike any other. We even have people on different sides of the case who disagree with each other but are respectful. Ladies and gentlemen, and that matters. My name's Grant Smith Ellis. I'm a Little Towel. We will talk tomorrow. I'm ending this recap, and I'm going back to talk to the Towel Friends as always. Oh my goodness. Murder by Maestro, you proved it. You proved it. You are a genius, Little Towel. Oh my God, we need to make Murder by Maestro. Okay, who wants to get Murder by Maestro a plaque? We need to make a towel plaque. We need to send it to Murder by Maestro. It shall say, you are the greatest of all towels. You were the prescient, erudite, 24-year-old hexadecimal speaking, wonderful towel who put it all together. Murder by Maestro, yes, Little Towel helped you as he could, but it was you, my dear friend. And I'm not blowing steam up Murder by Maestro's towel exhaust. It is real, ladies and gentlemen. Murder by Maestro is the real deal. It is heartbreaking to watch, but listen, folks, the implications of what Murder by Maestro put together, the numbers, the throw distance, the data. He didn't even know there was a leg injury at the time, and all the simulations and the data all led to the same conclusion. And then the new pictures proved it. Murder by Maestro is the super towel. You cannot say enough about Murder by Maestro. Somebody put this man on a statute. We'll make a statute. We'll make a plaque. We'll give Murder by Maestro a plaque, and it will say you interpolated the data. You knew what was coming. You knew the defense couldn't stop it from coming, and then when the defense experienced it and the world was wondering why Karen had a breakdown, we knew. We put it together, folks. Oh, my goodness. Yes, Murder by Maestro speaks hexadecimal. We just are seeing it in English, ladies and gentlemen. He is a 24-year-old hexadecimal speaking towel, the rarest of all towels, I say, ladies and gentlemen. Take your applause. Take your bow and accept the applause, Murder by Maestro. You have been crowned the super towel of all super towels. Oh, goodness. I agree, folks. And it's about time, Murder by Maestro, get all of the praise and wonderful recognition that he deserves, because Murder by Maestro is not just a hidden gem. He is a gem shining so brightly that the light of his insights brings forth peace in the world and the conviction of Karen Read. Can you be anything more? Could you ask for anything more in life than to be the light of the world and to bring justice for John O'Keefe in the form of a hexadecimal speaking towel? No, Murder by Maestro has truly ascended to their pure form. As the Greeks would say, Murder by Maestro found their eudaimonia, their summum bonum in the Latin, their greatest good. It is to hold people accountable by interpolating complex data and translating it for the public. Oh, ladies and gentlemen, Murder by Maestro has just become the subject of towel praise, and I'm going to keep going with it. There's nothing you can do about it. Oh, goodness. Murder by Maestro says that they love us all. We have been crowned with Murder by Maestro's love. It was wonderful. All right, so there's two things we got to do. One, I'm exhausted, and I still have to do the recap, and I have to prepare tomorrow's stream, and I have to I have to get that link up, and I have to do an image for it. So, someone said we have to get a DeLorean. Who are we bringing where? Who are we getting in a DeLorean? I'm so good. I think Murder by Maestro is already here. You want to go and get him and bring him here? He's already in this time period. If we have a DeLorean, are you saying you want to bring him to a different time period? I think Judge is going to deny Alessi's motion, allow in the full aperture report, and then allow Brennan's proposal to do expert in his case in chief, ARCA testimony, expert in rebuttal from Brennan. I do need food and rest. Little Towel is exhausted. So that leads us into the final part of the stream. So if you know how the stream ends, it has a very rhythmic flow to it, okay? Like a Joycean Vico-inspired recursive historical circle. We on this stream like to do something important, and that is I like to bring up all your comments, and I like to say thank you to every one of you, whether I have a headache or not. You all stuck around. You have been watching. You earned this, in my opinion. Every single one of you who stuck out for the recap, who were chatting with each other, who were being amazing little towels to each other. You are the very best of the towel universe, and I would be remiss if I did not begin with the wonderful towelette Dewdrops, who has literally been here for 10 hours, and Dewdrops probably needs to get some sleep now. Literally 10 hours, ladies and gentlemen. Dewdrops is still here, and we are saying thank you after our wonderful praise session for Murder by Maestro. We are saying God bless you and thank you to Dewdrops. Why? Because there is no towelette like Dewdrops. There will never be a towelette like Dewdrops, and people deserve to get their flowers while they can still smell them. And my name is Towel, and I like to do things like that for people, especially when there's a lot of people watching. So, but there's other things we have to do as well. Okay. Now, the very first thing we have to do is Christina Towel has sent an update. And as I go through my thank yous and I get to talk to each of you individually by saying your name as I look in the comments, we have to look at the update from Christina Towel. What if it is about Chewbacca and the Stay Puft Marshmallow Man? We cannot just end the day without an update from on-the-ground reporter Towel Christina, who is not actually Christina Rex, but still gives us wonderful updates. And we do have an update. Oh, no. What is that? What is this? Oh, no. What have you done? How did you get this picture? Where did you find this monstrosity? Oh no! I have very bad news about Chewbacca and the Stay Puft Marshmallow Man. Mandy Strong, I think judge is going to allow Brennan's expert's full report in and then allow Brennan to call his expert in rebuttal, as I said earlier. Mark it in stone. Towel has thus said it. Ladies and gentlemen, I have to show you something. I just cannot get over this. I cannot believe this has happened. I have bad news about Chewbacca and the Stay Puft Marshmallow Man. Our reporter, Towel Christina, has provided this update from the ground, folks. I don't know how to tell you this, but reporter Towel Christina is saying that the Stay Puft Marshmallow Man and Chewbacca are surrounded by an army of green trolls. This is worse than the Wiccans. Oh God, what are they gonna do? What are you? No, I'm not worried about the judge's ruling at all, by the way. Not one bit. She's going to rule that the full report comes in, and then she's going to rule Brennan gets his expert to respond as well as testify in the case in chief. Ladies and gentlemen, reporter Towel Christina has just indicated that Chewbacca, who is actually a dog named Chloe in a wig, and the Stay Puft Marshmallow Man are being chased by giant green trolls in FKR shirts. Listen, this saga has involved paper airplanes, a dinghy across the Pacific Ocean, an F-16 that Alan Jackson stole from some kind of Air Force base. Oh my goodness, David Yanetti's spaghetti. It involved that the Stay Puft Marshmallow Man passed a bar at one point. Oh dear God, ladies and gentlemen, this saga. They're gonna catch Chloe. What are we gonna do? No, a sir rebuttal isn't really a thing, Eva, but technically in this case the defense could argue for it by right. So that's kind of what's going on here. The defense is making a very unique argument, and then Brennan's making a unique argument in response because it's a unique situation. Yes, folks, we are in a lot of trouble. Chewbacca and the Stay Puft Marshmallow Man. Well, Chewbacca's a dog named Chloe in a wig in a Chewbacca costume. And the Stay Puft Marshmallow Man, first of all, they escaped Christina's basement to start all this. Then Alan Jackson wanted to call the Stay Puft Marshmallow Man as a witness in the trial. Then all of a sudden it became about calling Chewbacca when Alan Jackson figured out that was Chloe in a wig. And then the Stay Puft Marshmallow Man became a lawyer. And then David Yannetti used spaghetti to distract Chewbacca while the Stay Puft Marshmallow Man was like, oh dear God, don't do this with my client. Ladies and gentlemen, and I just want to be clear, I'm not making this up. I swear, look at the reaction when this all played out. And look at how, I'm not even kidding, somehow David Yannetti Spaghetti got involved in all of this as well. And I must say, there it is. There it is. It was the distraction no one saw coming. Oh, Pat Brooks, welcome to the Towel Friends. You now have access to towel emojis. And, you know, I'm going to leave the spaghetti up on the screen, and then I'm going to do this. Jew Drops, God bless you, my dear friend. Get some rest. Mandy Strong, you are a wonderful honorary towel spouse, even though I'm afraid of commitment. None your business. You are actually very respectful. I'm so glad we have you on this channel. I'm actually pleased that you came across us, and you're pretty funny. And you're respectful. DJ, God bless you. Good night, dear friend. You deserve a rest. Jew Drops, get some rest. As I said, friend, you deserve it. We'll see you bright and early. Pat Brooks, God bless you for joining the towel fandom. As I mentioned, and feel free to use your new wonderful towel emojis. Tay Marie asked Murder by Maestro to look for the statement about the two troopers, so let's follow up with that tomorrow, MBM. Eva, God bless you, dear friend. You're such a wonderful towel supporter. Susan Spatafor, God bless you as well, dear friend. I always love seeing your name pop up. Murder by Maestro, you got your celebration. It was an epic celebration for you, dear friend. I saw Ange Wittick in there. God bless you, friend. I've had you in mind all week, and your family and your dear brother. God bless you. Second Beach Gal, you had some great comments today. Always insightful. Always with a great vibe. Thanks for being with us. Modelo Macy, dear friend. I always love seeing your name pop up, and I love the way that you engage with your fellow towel friends. And your questions are on point. Your comments are on point. Always a pleasure. DJ, I mentioned you. Christina, reporter towel. Christina, where would we be without you, dear friend? You are wonderful. Paula, Towel appreciates all of your contributions and support. It does not go unnoticed. Oh, look at you all. Luisa Ramirez, you were here from the beginning, dear friend. God bless you. I appreciate you sticking around. Colleen Henry, you asked some great questions. We got to see the Call Me Hank clip. You know what? Let's do it. What better way? We don't have a clip of Hank Brennan leaving court today, but because Colleen Henry asked for it earlier, how many views do we hit on the over on the X? We're almost at 10,000, so we may as well stick around for a few more minutes. You know we'll hit that 10,000 mark. It'll be another towel celebration. You know I have to show you the clip of Hank Brennan. If you're wondering, Towel, did Hank Brennan say you could call him Hank? And then did you run around and go tell Abby Paquin, the reporter from Boston.com, that you're going to wear that like a medal? And then did you go walking merrily down the street like a little towel? Yes, all of those things happen, and I am hilarious. Let's watch the moment. Apparently, a lot of people found this interesting. They said it was very cute. I'm just a towel.
You as well, Mr. Brennan. Okay, sir, I will, Hank. You as well, Mr. Brennan. Okay, sir, I will, Hank.
Kelly Patton, I saw you pop up in there. I hope you enjoyed that wonderful You Could Call Me Hank video. I got to keep going back through the list, though. This is it. There were a lot of you chatting, and I make sure. Robert P., I got to add you to the honorary towel fold, because anyone who loves Murder by Maestro is an honorary towel. None of your business. I already said hello to you, dear friend. Kitties 1993, I always love seeing you pop up. It's so great to see you, dear friend. Colleen Henry, I saw. Oh my goodness, you all were chatting ferociously. I normally can scroll back quite far in the chat. We're actually going. Oh, Deaf Otter, dear friend, you were even gifting memberships. We are going to use the actual scroll. I don't even do this very often. We're going to use the actual towel scroll to see who else we can see here. Oh my goodness, you all chat so fast. It can the systems on the back end that control the chat and try to keep track of it all literally scroll to the point where I can't. It just scrolls off. Susan Spatafora, Tom Grist, both of you, I saw you pop up. I knew scrolling up would be worth it, even if I can't see your comments in real time. And also, folks, let's give a special towel thank you to dear Deaf Otter, who not only, along with MBM, keeps an eye on this channel and is such a wonderful honorary towel, but Deaf Otter bought 5 memberships. It was a membership parade earlier. We had a wall of towel emojis, friends. It was raining towel emojis in the chat as celebration. Oh, goodness, ladies and gentlemen. It was Maui Swift was in there as well. I saw you. Tenacious P, God bless you for taking care of your granddaughter or grandchild tomorrow. That's so kind of you. I hope you enjoy the day, and I hope you and your grandchild have some great moments. God bless you, friend. Paul Doherty, I hope you keep watching, friend. Keep learning about the court process. It'll all become easier in time. Ian Twittick, oh, God bless you. Tiger Lily Girl, it was great to see you. I do think they are going to be let in. Oh, Maui Swift just sent another membership parade. Susan Spatafora, G.A. Mom, Reticent Robin, Claire, and Artworks too. Congratulations. You all have just been gifted memberships. Let's give a special thank you first to Deaf Otter for his membership parade earlier, and then now to Maui Swift who came through. Ladies and gentlemen, enjoy your new towel emojis. God bless you, Maui Swift. That's so kind of you. That's what you get when you stay around till the end of stream, folks. It becomes a membership parade. The towel emojis just start flying in the chat. Oh, it becomes a wall of towels and Chewbacca's. Who else do we have here in the comments as I keep scrolling? Paula, I saw you earlier, of course, Murder by Maestro, and I mentioned Paul Doherty. Deb H., I'm so glad I got to see you, dear friend. Oh, Tay Marie, God bless you, I just saw you in there. And Pat Brooks, oh, God bless you, Pat Brooks. Hold on, I got to scroll up. I got to keep folks' chat on the screen. I got to give you a super heart for that, Pat Brooks. Hold on, and then I also have to do a reply, as is tradition. God bless you, Pat Brooks, and it's wonderful to have you among the towel fold. You are a true super towel. Oh, ladies and gentlemen, I'm so glad I was scrolled back to the bottom of the comments in order to be able to see that. And I also saw Lisa pop up in there. God bless you, Lisa. It was so great to see you in chat. Sorry about that issue earlier. I think you handled it beautifully and with decorum, and Towel respects you. Also, I want to send a special, even though Sema was trolling us a little bit, I like Sema as a person. I think she's got a good soul. I'll send her a message later and be like, listen, it's perfectly okay if you want to support, if you want to, you've been very nice to Towel, but like, if that's not just Towel space over there, that is all the Towel friends, and you don't need to bother them. Just they were willing to welcome you, Sema, so just be nice, and everyone can be nice. And if you want to debate a point that's being discussed in the testimony with a contrarian view, that's fine, but don't take us down rabbit holes. Don't be hostile, and if there's someone in chat that you don't want to deal with, this is me saying this to Sema, just block them rather than engage. That's the message I'm going to deliver. God bless you, though, Pat Brooks. And Chris, I saw you pop up in there. It's great to see you, dear friend. Umpire's Bad Call. Every time you and Chris pop up, I notice both of your names. I love Umpire's Bad Call as a username. And Chris, I love the way that your username is spelled. Both of you ask wonderful questions. Claudia Franco, all the way, I think you're from Portugal, dear friend. I am so glad that you're still with us. Thank you. I remember when you were here earlier in the day. Kelly Patton, of course, have to say hello to Kelly. God bless you, friend. Oh, ladies and gentlemen, Truth and Justice. I have to add you to the honorary telefold. I just want you to know, though, like, David Yannetti, I think this was an intense case. I think Alan Jackson may have been, like, really responsible for getting out of hand. And I think David, in his soul, is actually a decent man. He's, like, a kind human being. I think this kind of got out of hand. I don't think he was really, really malicious. I think he was like, I want to win. So just keep that in mind. And he just know that he didn't have to, but when my father passed earlier this week, he was the one on social media that just reached out and left condolences. He was the one that he personally extended his condolences. He is a very decent man. I know it's hard to separate it out from his actions in this case, but just he's a decent. I read auras pretty well, and Little Towel was in Mr. Unetti's presence. Like, not just that, but like if you actually come over and talk to me, like once you enter that bubble, like you are giving up the read of your soul. Like, I promise you. Like, you can keep it guarded if we're just walking and I'm asking you questions. But if you approach me and you actually talk to me, like, especially, like, very close, it was a very authentic moment from David. But, like, you're opening your soul to me. I'm going to be able to read it. I could tell. And he's fine. He's fine. Same with that guy Dylan from the UK. I met him in person the other day. I shook his hand. I didn't need more than 5 seconds. I was like, yeah, he's fine. And then we had a very pleasant exchange. So, like, you know what I mean? And I'm telling you, David Unetti's all right. So just try to separate the man from his work on this case. So, okay. Who do we see pop up? Anybody? Rachel McIntyre, I'm so glad you popped up at the end there so I could say, Crime Cricket, hello. Well, first of all, Rachel McIntyre, I'm so glad you popped up. Crime Cricket, my friend, when I see your name pop up, not just Rachel McIntyre's name, that makes my eyes light up, but Crime Cricket, when your name pops up after we didn't get to see you throughout the day, because I had actually saw Rachel's comment earlier, so I already got my, it's great to see you moment. Crime Cricket, I saw your name for the first time right there. My friend, you bring a smile to my face every single time your name pops up in the comments. Every contribution, every comment, every question you ask, every discourse with your fellow Towel friends, you bring a smile to Little Towel's face. Keep being you. Keep being a wonderful person. If you all may remember Crime Cricket, last weekend we were honoring on the stream Crime Cricket's mother who passed away last weekend. So please say a kind word to Crime Cricket. Keep them in your prayers and thoughts. Towel has been doing so all week. I appreciate the bonds that are forming here, the tight-knit interwoven fabric of the Towel universe. It means so much to me. The washcloths, the paper towels, the hemp towels, the flannels, the soap dispensers, the beach towels, the microfiber towels, the towelettes. There are so many wonderful towels, and all of you reflect the very best, in my opinion, of the Towel universe. Oh, God bless you. Oh, I really appreciate it. I really appreciate you, Mandy Strong, and all of your comments, folks. Thank you, Lisa. I appreciate you as well. Okay, folks, be nice and people are nice back, says Nunya Business. There you go. Look at it. What a wonderful message to send there at the end. All right, so now you know there's 3 more things we have to do. We did our one thing on our checklist. We have 3 things to go. Number 1, if you like this feed, if you learn something, you know exactly what you can do to help. You can click the like button. You can click the, Tropic Thunder Towel. I love it. Last of the Talikans. I love it. You're creative. You can subscribe. You can like the channel. You can like this video while the video is still live. You can subscribe to Towel Stream. You can turn your ad blocker off now. There are ways you can help this channel that don't really require you doing much. If you like the content, though, if you learned something today, if you want to help Little Towel, although I think I'm going to be okay tomorrow, but let's just hedge a little bit. If you want to help Little Towel, the super chats, all of your contributions have not gone unnoticed. There are other ways you can help donate to Towel, medical expenses, other things like keeping me alive, making sure in the morning I'm not nervous about getting my Dunkin' Donuts for breakfast. There are ways to donate directly. Just know this is a public information service, okay? Yes, there are ads running, but that's more of YouTube's thing. Like, I don't have any sponsorships, but I will accept a sponsorship from 7-Eleven because I like their pizza. You can also get pizza from D&E in Canton. They didn't pay me to say that. I just think they have good pizza, especially slices. They're amazing. Ladies and gentlemen, this is a public information service in the style of Lord Reith from the British Broadcasting Corporation. That means that it is user supported. All you wonderful Towel friends know that I go through my phone. I look at all of the contributions. If you don't get a heart or a reply from me right away, it's because I didn't see it right away, but I go through it meticulously. All of the donations, I see them. They mean a lot to me. If we're going to educate, inform, and entertain the public, if this is going to be a public information service, then we have to figure out ways for it to be sustained, and you all are helping me do that. It means the world to me. I'm happy to do this at a loss, but I do think I would wander around in the countryside in a robe and until I starved if it were up to me preaching about morality. So let's, with Murder by Maestro's help and all these other wonderful Towel friends, let's set up an administrative structure so Towel doesn't starve and he can just do his thing and channel this energy in a positive way to engender cogent public discourse and ward off the usurpation of our representative forms of government, in particular the judicial system. And let's do so authentically in line with our principles. And whether you do that by liking the stream, subscribing, donating, super chats, anything, I notice it. It means a lot to me. God bless you. Pilgrim Shadow, dear friend, I noticed you pop up earlier. I am so... Pilgrim Shadow, I saw that pop up earlier. Listen, the actual read of the ruling, is that there's just a mens rea requirement, and the order remains the same. Whether that means that they're going to be allowed to come up a little further without doing certain things, that is an interpretation of the order, and you have to look to the officials for that. So keep an eye on that. My interpretation of the order as written is that it's exactly the same. That doesn't mean that its enforcement will be exactly the same. We'll have to watch tomorrow, ladies and gentlemen. Yeah, no, I did. So Pilgrim Shadow, but hold on. Mandy Strong, to give Pilgrim Shadow some credit before we do our final outro here. What this could mean is that the authorities enforcing the order might be enforcing it differently. That doesn't mean that the parameters of the order have changed, so we're going to keep a very close eye on it. Yeah, don't worry. Pilgrim Shadow is on the ball. If Pilgrim Shadow seeing this reported, what it likely is, and we'll see confirmation is, it might be the state police saying that they've interpreted how they're going to enforce the order differently. So this is, if anything, this is very helpful information from Pilgrim Shadow. I will try to get you updates, folks, first thing in the morning. The buffer zone start kicks in at 8 a.m. tomorrow, so that's when we're going to find out. But see, the thing is, I wouldn't call it a win, because what it is that there's a mens rea requirement that that now applies. It doesn't really change the scope. Now I have to look at it, right? Because I read the order. I have to look at how the enforcement is going to happen. But really, what it does is just opens more leeway for enforcement actions based on a mens rea requirement. So, but yeah, we got to read it closely. We got to follow up closely. Yeah, Karen Reed, though, in terms of the actual evidence being presented, she's in trouble. But folks, you know I got to wrap this up because I'm getting tired and I have to do my recap and prepare things for tomorrow. So, final note. Here's how you can really pay this forward if you like Towel Stream, if you benefited from this information. Go out there, look for a reason to do small acts of kindness for other people around you. It can be donating to homeless veterans, smiling at a neighbor, shaking someone's hand, going to see a family member, talking to someone you haven't talked to in a while. Look for reasons to be a helper and to do good in the world. And through 6 degrees of authentic non-Chewbacca-based separation, maybe we can bring about a digital epoch and a new era as defined by Aquarius the water bearer walking with a towel that is rooted not in preserving, demonstrating, and expanding our power, but in preserving, demonstrating, and expanding our capacity for universal love as demonstrated through small acts of service to others. Look for a reason to be a good person, ladies and gentlemen. And WBZ is a TV station. Let's follow up closely. Let's see how the buffer. Remember, the buffer zone enforcement is different than how it's written. Let's see how this all plays out, ladies and gentlemen. God bless all of you. Pilgrim Shadow, thank you so much for that update, dear friend. I'm so glad that I saw your name pop up there in the end and I got to say hello. And truly, ladies and gentlemen, enjoy the rest of your Thursday. Thanks for being with me. Almost 10 hours now. Oh my God, we almost did an 11-hour stream. It has been 10 hours and 43 minutes. We broke the all-time towel stream record. Are you kidding me? 10 hours and 43 minutes. Oh my goodness. We have to leave room, folks. You can only do 12-hour streams. We're going to break more records. We're not going for 11 hours. I'm too tired. But yes, Pilgrim Shadow, I will look more into it, ladies and gentlemen. Good night. Thank you for staying here to the end. And you know how this goes. We end the Twitter stream first. Why? Well, Twitter friends, it was great to see you. I'll talk to you tomorrow. But on the YouTube, you get a few extra minutes because the Twitter friends get 5 minutes on the front end where you don't. What a day, ladies and gentlemen. What a day. What a day. No, yeah, Mandy, Pilgrim Shadow is they're a very helpful towel friend. They're just telling me they want me to know because WBZ has reporters on the ground, so it's possible the way the buffer zone is going to be enforced is different than how the order reads. But that's why we got to keep up to date. But yeah, absolutely. The buffer zone was it's big news today, folks, depending on how it changes. But the biggest news of the day was the autopsy testimony, the cause of death, the side swipe, the collision impact detection. It was bad, bad, bad for Karen. All right. Oh, Mandy Strong. I was like, what? I thought you were asking Pilgrim Shadow, and I was like, no. Pilgrim Shadow is the most helpful little towel. Mandy Strong, mens rea. Okay, we'll do this quickly because Mandy Strong has a question. The honorary towel spell, she gets an answer. Anyone asks a question like that, they would get an answer. But you're funny, Mandy Strong. There's 2 components of a criminal charge: the actus reus, the act requirement, and the mens rea. The mens rea is the mental requirement. And then you also have a proximate cause requirement, and it really depends on if it's an intent or a results crime. So, like, first you look as, like, is it a crime where you intended to do something or you actually did something? Then you have to look at, like, what's the proximate cause between your actions and the actual crime? And then you have to look at what is the mental state requirement? Like, do you have to be thinking a certain thing when you're doing the act? And then what's the act requirement? But okay, friends, let me end this YouTube stream. I got to take this, and we will talk very soon. God bless you, friends. Until tomorrow, be